And we are live. Hello everyone, welcome to the Alien Spaceship stream. You can be watching from anywhere around the country or the world. I really appreciate every single one of you. Coming to you from the Spaceship Studios from a galaxy far, far away. And we are... Hello Abs, welcome to the stream. It's been a while since we've seen you. Welcome. Alright, going over here. Alright, so basically what we're going to be doing is we're watching the O.J. Simpson trial, and we'll be reacting to it. That's what we'll be doing today. We discussed it yesterday, so now we got this done, and I hope that you're doing alright, Abs, and it's nice to have you here. Alright, so now we'll be proceeding with the O.J. Simpson trial. Alright.
All right, good morning, Council. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Ullman, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. All right, Council, we have just a few matters to dispose of before we reach our opening statement stage. Council, yesterday, the jurors, when they retired, one of the jurors handed the bailiffs a note for the court, and they were just curious as to whether or not the court was going to allow them to watch the Super Bowl this weekend, and I've indicated to them that yes, they can, and that we would arrange their visitation schedule accordingly. So I take it there's no comment on that. All right, Mrs. Robertson, would you create a file for juror notes, please? All right, first issue to be resolved is the defense motion to allow Mr. Simpson to briefly address the jury during the course of defense counsel's opening statements. All right. Certainly.
Your Honor, the first objection interposed by the people is that this has never been done before. And we have located at least two California precedents where it has been done before. The first came in probably the first case of the century, which was the trial of Clarence Darrow here in Los Angeles for jury bribery. Even though Mr. Darrow was represented by eminent counsel,
either at the margins or in the tissue spaces along the wound path.
Doctor,
I might say, incidentally, when I describe wounds or forensic pathologists describe wounds, we may say that we may describe injuries and specify where injuries appear to be post-mortem. I mean, that's characteristic. If we find a wound that appears to be inflicted post-mortem, we would specifically state that. And contrary to that, when we see vital activity, we generally describe bleeding in the wound or in the wound path or in the tissue spaces along the wound to substantiate that they occurred during life.
Dr. Golden, with regard to the figure in the lower left-hand portion of the diagram marked as Peoples 25 for identification, does that figure indicate some sort of wound or trauma to the right side of Nicole Brown Simpson's head?
If we're referring to the red marking here, yes.
And what did you find during the course of your autopsy that indicated such a wound or trauma?
Well, I'm referring to my report to refresh memory, but there was a bruise on the right side of the scalp 4 inches directly above the ear canal. And after a shaving of the scalp, it was 1 by 1 inch. It was a fresh bruise. It was red-violet in color. No other injury was apparent, meaning no abrasion or laceration. And this bruise, on subsequent examination, disclosed bruising beneath the scalp. Correction on that, fresh bruising beneath the scalp.
Would that indicate to you, sir, that this was an antemortem wound?
Yes, this was an antemortem wound. It was associated with a deep scalp bruise.
Inflicted, consequently, while Nicole Brown Simpson was still alive, is that correct?
Yes,
And inferentially, before she received the gaping incised wound across the neck, is that correct?
yes.
Your Honor, I have another diagram that I would like to have marked. It pertains to the autopsy of Nicole Brown Simpson. It reflects 3 wounds to the scalp. May this be People's 26 for identification?
Yes.
Dr. Golden, during the course of your autopsy upon the body of Nicole Brown Simpson, did you observe wounds or trauma to the scalp of Nicole?
Yes.
Okay. Tell us what you observed, sir.
There was a cutting wound on the back of the scalp, left side. Which, and I'm referring to my report, particularly the addendum report on Nicole Brown Simpson. It's a 1 1/4 inch length, diagonally oriented cutting wound, tapered above, and this doesn't reflect it as well. The diagram doesn't reflect the actual appearance as the photograph would, but it's a 1 1/4 inch long cutting wound. It was longer than deep. It went into the scalp for approximately 3/8 to 1/2 inch and did no further damage to the skull.
This was not a fatal wound, I take it?
No.
Was it an antemortem wound, that is, one that was inflicted before Nicole Brown Simpson died?
Yes, it was. This wound was associated with fresh scalp hemorrhage. In other words, bleeding in the deep scalp tissues.
Now, Dr. Golden, there were 2 other wounds that you observed with regard to Nicole Brown Simpson's scalp, is that correct?
Yes.
Okay. Would you
There was a cutting wound or stab wound superficially right in the posterior parietal occipital, in other words, lower down here on the right side of the lower scalp. This was a 1/2 inch in length superficial wound, only going in, again, 3/8 to 1/2 inch, a non-fatal wound.
Was it also...
There was a small amount of hemorrhage associated. Again, that occurred before death. It was an antemortem injury.
Okay, thank you, doctor. And just for purposes of the record, you were indicating a wound roughly in the center of the head, midway between the ears on People's 26 for identification.
Yes.
Doctor, there was a 3rd wound. Would you briefly describe that wound for us and indicate whether or not it was antemortem, perimortem, or postmortem?
That was an antemortem cutting wound, 3/16 of an inch in length, involving the skin only, with a small amount of deep scalp hemorrhage. Again, it's antemortem. It was a superficial cutting wound of the scalp.
And you're indicating on the diagram, People's 26 for identification, a wound closest to the left ear as depicted on the diagram. Is that correct?
Yes.
Now, doctor, during the course of your autopsy as performed upon Nicole Brown Simpson's body, did you notice any injuries to her hands?
Yes?
Tell us about that, sir.
Well, okay, referring to my notes, my autopsy notes and protocol to refresh my memory, on the index finger on the right index finger, there was a 5/8 inch long cut of the skin adjacent to the distal knuckle. Involved the skin only, and it had was a tangential cut, which would indicate that it was shelved. In other words, it didn't go in straight. It was an oblique cut, which would indicate a shelving or a tangential cut.
And so what is the distal knuckle?
The one closest to the fingertip. Proximal, distal. Proximal is closer to the. Proximal would be closer to the hand, and distal would be closer to the fingertip.
I see. Would you briefly describe the other wounds to Nicole Brown Simpson's hands that you observed?
Few minor injuries. Punctate abrasion on the ring finger of the right hand. On the left hand, there was a punctate abrasion, base of the right ring finger. And finally, there was a 1/2 inch superficial skin cut on the top of the left hand.
Dr. Golden, are you familiar with the term defense wounds?
Yes?
What are defense wounds, sir?
Defense wounds are injuries on the upper extremities, either the arms or the hands, which would occur when the victim raises the extremities to protect the body or to ward off or grab the instrument, or to ward off or fend off the blow by an assailant.
Sir, in your opinion, were any of the wounds to Nicole Brown Simpson's hands compatible with defense wounds?
Yes.
And why is that, sir?
The cut on the right index finger is in a characteristic location for a defense wound on the palmar or volar surface of the finger, which could indicate an attempt to fend off the weapon or to grab the weapon, and the superficial cutting wound on the top of the hand that I described could also be construed as a defense wound. It's a superficial cut, but could also indicate a defensive motion to attempt to ward off I don't want to say blow, to ward off the weapon that was inflicting the injuries.
Dr. Golden, at the conclusion of the autopsy that you performed upon Nicole Brown Simpson's body, did you form an opinion as to the cause of her death?
Yes.
What was your opinion, sir?
She died as a result of the sharp force injuries, which includes the cutting wound and the stab wound. So they're grouped as sharp force injuries.
And that would include the wounds most specifically depicted and is characterized by your testimony in People's 25 for identification. Is that correct?
Yes.
Now, Dr. Golden, later in the morning, on June 14th, 1994, you performed an autopsy upon the body of an individual identified to you as Ronald Goldman. Is that correct?
Yes,
And prior to performing the autopsy procedures, did you examine the body and determine that it was clothed?
yes.
And would you describe how Mr. Goldman's body was clothed when you first observed it?
Okay, I'll also refer to my autopsy protocol, but he was wearing a long sleeve type of shirt or sweater that was extensively bloodstained and moist at the time that I examined it. And he was also wearing a pair of bloodstained Levi jeans and 2 canvas type boots and 2 sweat socks.
Sir, with regard to the shirt, did you examine it for any evidence of cuts or slits or tears?
Yes, I did.
What did you find?
On the front or lower right side, there was a 1.5 inch long slit-like tear. Lower right sleeve, a 1 inch slit-like tear. On the back, lower side of the back, there is a 1/2 inch slit-like tear.
And sir, with regard to Mr. Goldman's jeans, did you find any evidence of a slit, tear, or cut in that item of clothes?
Yes, on the jeans, on the outside of the left hip region, there was a 1.5 inch long slit.
And Dr. Goldman, as part of your autopsy procedure, was the clothing removed from Mr. Goldman's body and preserved?
Yes,
After the clothing was removed, Dr. Goldman, did you determine the length of Mr. Goldman's body?
yes.
And what was that, sir?
69 inches or 5 feet 9 inches.
And Dr. Goldman, did you also determine the weight of Mr. Goldman's body?
Yes, 171 pounds.
Doctor, did you observe injury to the neck area of Ronald Goldman?
Yes,
And starting with the front of the neck, did you observe any evidence of injury to the front of the neck?
yes,
Your Honor, I have here a diagram pertaining to Ronald Goldman's autopsy. It reflects wounds to the front of the neck as well as to the right side of the face and as to the left side of the neck. May that be Peoples 27 for identification?
Yes.
Thank you. Dr. Goldman, Peoples 27 for identification is a diagram that you prepared in the course of the autopsy you performed upon Ronald Goldman's body. Is that correct?
yes it is.
And during the course of that autopsy, did you observe what appeared to be 2 parallel incised wounds on the front of Mr. Goldman's neck?
Yes, I did.
Would you describe those in more detail for us, sir, and make reference to the diagram Peoples 27 for identification as you do so?
Okay, I'll also use the autopsy report and the addendum report. Basically, at the there was a transverse superficial cutting wound at the level of the superior border of the larynx, or voice box, 3 inches in length, and it on the left side it went within 1/2 inch of the of another injury of the left side of the neck to be described later, and it went transversely across the front of the neck to the right side to the right anterior side of the neck.
How deep was that particular wound, Dr. Goldman?
It was deeper on the left, where it went down through the skin and dermis to the fascia, the connective tissue beneath the dermis and overlying the muscle. It became more superficial on the right.
Was that a deep wound?
I've already described it, Steph. It went down to the fascia on the left and tapered to the skin on the right. It was not a fatal wound.
And what are the fascia?
Fascia is the connective tissue, the flat sheets of connective tissue beneath, in the tissue planes. Here would be the covering, the superficial fascia overlying the muscles of the neck.
And doctor, this particular incised wound was not fatal in and of itself. Is that correct?
No, it was not.
Was it inflicted ante-mortem, that is, before fatal wounds were inflicted upon Mr. Goldman?
Yeah.
Again, just for the sake of the record, and I hate to bring this up, from where I'm sitting, it appears that the doctor from time to time at least refreshes his memory.
I think many times he has told us. It looks like you are looking at your report again to answer the question.
Yes.
Okay.
There was a small amount of tissue hemorrhage associated with that wound.
And with regard to your indications to the diagram here, you were referring to the upper leftmost figure on People's 27 for identification. Is that correct?
Yes.
Now, doctor, during the course of your autopsy, did you also observe a second incised wound below the larynx and parallel to the one you've just described?
Yes.
Describe that for us, please.
That was below the first wound, referring to my notes. It was horizontally oriented. It was parallel to the first wound, 6 inches in length. Starting on the left side of the neck, it was superficial, excuse me, involving the skin only. And it went around to the right side of the neck.
Did it angulate upwards?
It went to the right side of the neck, and although it's not shown here, it then angulated upward towards another wound on the right side of the neck to be described below.
Was this wound fatal in and of
So
itself?
this wound was superficial, and I've indicated it involves it involved the skin. It involves the skin only. It was a superficial cutting wound.
And how would you characterize this wound in terms of being antemortem, perimortem, or postmortem?
I believed it to be antemortem, inasmuch as there was a small amount of visible dermal, meaning skin hemorrhage, when I first saw it.
Now, doctor, referring to the lower right-hand figure on People's 27 for identification, does that particular figure depict some evidence of injury to the left side of Mr. Goldman's neck and head that you observed during the course of your autopsy?
Yes, it does.
Now, using your pointer, sir, and taking the lowermost wound, would you describe what you found with regard to that wound when you conducted your autopsy upon Mr. Goldman's body?
Well, there was a large gaping sharp force injury on the left side of the neck, 3 inches in length, which I'm pointing to right here.
Indicating the lowermost apparent sharp force wound in red on the diagram. Is that correct?
Yes.
Now, would you tell us something about the wound path of that particular wound?
Okay. And of course, I'm refreshing my memory. It was on the left side of the neck, began at the level of the mid-larynx, cut through the sternocleidomastoid muscle, and it went through the skin and the muscle with bleeding along the path, and basically it severed the left internal jugular vein. There was extensive bleeding in the adjacent tissue, and I determined that to be the pathway of that wound.
Did that wound transect or sever any major blood vessel?
Yes, as I stated, it transected the left internal jugular vein.
Now, there was a second wound to the left side of Mr. Goldman's head, is that correct?
Yes.
Describe that for us, please, in brief.
The second wound was above it, behind the left ear. It was a gaping wound, 2 inches in length. The lower borders were irregular or ragged, and as I mentioned, it was 2 inches in length. Along the tissue planes, it appeared to be separated from the lower one by approximate distance of 4 inches. So those two wounds shared common areas of injury.
Are you saying that the two wound paths intersected with regard to those two wounds?
Yes, they met, they met deep along the tissue planes. So basically, you say they communicated or they shared common areas of injury.
Taking those two wounds together, doctor, are they fatal wounds? Either one or both or together? Also taking into consideration that the jugular vein on that side was severed?
Well, either or together, it's a fatal injury because of the severing of the left internal jugular vein.
And doctor, with regard to those two wounds, were they antemortem, perimortem, or postmortem?
No, as I've described, there was extensive hemorrhage along the wound path and in the tissue spaces.
Now, doctor, I realize that there are more lesser wounds that were not indicated on your diagram, but I would like to move ahead now to the lower left-hand figure on People's 27 for identification. And, sir, you observed during the course of your autopsy 5 wounds to the right side of Mr. Goldman's face. Is that correct?
Yes.
And it appears that we have 4 of those 5 wounds marked in red on that lower left-hand figure on People's 27 for identification. Is that correct?
Yes.
Now, would you, in brief, describe those wounds for us, sir?
Okay, and referring to my notes, these were superficial cuts, varying in orientation, involving the skin of the right cheek, and they varied from approximately 1/2 to 1 inch in maximal length.
And these 5 wounds, sir, were non-fatal. Is that correct? In and of themselves?
No, correction, actually, yes. I said 1/2 to 1. It's referring to my protocol. They were small cuts. They varied from 1/4 inch in length to 5/8 of an inch in length. These superficial cuts on the right side of the cheek.
All to the right side of the cheek, is that correct?
Yes.
And were all of those antemortem wounds, as far as you can determine?
Yes, they were.
Now, doctor, during the course of your autopsy, you observed injury to the right side of Mr. Goldman's neck, did you not?
Yes.
Your Honor, I have another diagram pertaining to Mr. Goldman's autopsy. It depicts wounds to the right side of the neck. May that be People's next in order 28.
Yes.
Now, Dr. Golden, with regard to the lower left-hand figure depicted on People's 28 for identification,
Yes.
you observed some wounds in that area of Mr. Goldman's body, is that correct?
Yes, I did.
Would you describe those wounds for us, please?
Right, and referring to the report in the addendum, on the right side of the neck, 3 inches below the external auditory canal, there was a stab wound, 5/8 of an inch in length, and one end was pointed, the other end was Y-shaped or forked. And basically, the wound path was through the skin, subcutaneous tissue, did not strike a major artery or vein. And this wound connected or shared common area of injury with another wound on the right side of the neck above it, which was below and behind the right ear, behind the sternocleidomastoid muscle, and that was a 2-inch long wound with a 1-inch long superficial cut of the skin above it. And as you indicate here, the wound that I've just described, the deeper wound, intersected the superficial cut of the front of the neck, which we described earlier, which went around to the right side and then angled upward, and intersected that wound. So that's why it has that peculiar configuration there.
And sir, when you're referring to that superficial incised wound, that was on a previous diagram what appeared to be a superficial incised cut which moved across above the larynx and then intersected with this wound as depicted on People's 28. Is that correct?
That's correct.
Now, Dr. Golden, with regard to these wounds that you just described in your testimony, were these wounds fatal in and of themselves?
All that I've described on the right side of the neck were not fatal, as I've described earlier. No major artery or vein was cut or incised, and that includes the jugular and the common carotid artery.
Dr. Golden, although not depicted on this particular diagram, did you observe abrasions to the right side of Mr. Goldman's face?
Yes?
And in brief, describe what you observed with regard to the pattern of abrasions that you observed.
Well, these are not depicted, so I'll have to refer to my notes, particularly on the addendum. There are multiple abrasions or scrapes on the right side of the face, extending from the basically extending from the temporal region down to the right cheek, and from the going as far forward as the lower eyelid and back to the front of the ear. Basically, the area covered was 4.5 by 2.5 inches, and they were linear, some diagonally oriented, some vertically. The area that they covered, namely the abrasions, also circumscribed the area of the superficial cutting wounds of the right cheek that I described earlier.
Those are the 5 cutting wounds you testified to?
Yes. So I had 2 things visible there: the multiple abrasions on the cheek, and then the circumscribed area which contained the cutting wounds, the superficial cutting wounds.
And sir, with reference to the diagram People's 28 for identification, you're indicating an area on the figure in the lower left-hand side, is that correct?
Yes.
Now, with regard to those abrasions, would you characterize those abrasions as antemortem, perimortem, or postmortem?
I would not characterize them as post-mortem. They appear to be peri-mortem based on their color.
And again,
coloration.
perimortem meeting?
At about the time of death, which could be shortly before, at the time of, or shortly thereafter.
Now, doctor, during the course of your autopsy, you observed a number of various small incised wounds to the right and left ears of Mr. Goldman, is that correct?
Yes.
And did you also observe injuries to the scalp of Ronald Goldman?
Yes.
Your Honor, I have another diagram pertaining to Mr. Goldman's autopsy. May that be Peoples 29 for identification?
Yes.
Dr. Golden, with reference to Peoples 29 for identification, does that diagram, particularly the figure in the lower right-hand corner, depict the approximate locations of scalp wounds you observed on Mr. Goldman's head during the course of your autopsy?
Yes, it does.
Were each of those wounds non-fatal?
Yes, that's correct.
And did they all appear to be antemortem in nature?
Yes, they did.
And with regard to the dimensions of the wounds, no, I'll withdraw that. Now, Dr. Golden, during the course of your autopsy, you also observed what appeared to be stab wounds to the torso of Mr. Goldman's body. Is that correct?
Yes.
Your Honor, I have here another diagram depicting apparent stab wounds to the right side of the torso and the left thigh. May that be Peoples 30 for identification?
Yes.
Dr. Golden, with reference to Peoples 30 for identification and the figure which appears at the left-hand side of the diagram, are there depicted the approximate locations of 3 stab or cutting wounds that you observed on Mr. Goldman's body during the autopsy that you performed?
Yes.
And again, these wounds are numbered for reference purposes only and do not necessarily mean the order in which they were inflicted. Is that correct?
That's correct.
And Dr. Golden, starting with wound number 1, as indicated on Peoples 30 for identification, would you describe that wound for us, please?
That depicts a stab wound on the right side of the chest. Excuse me. Did you want a description of each wound, or just what they are?
I would like a description of each wound, starting with the wound that you have numbered as number 1.
All right. That was a stab wound on the right side of the chest, 5/8 of an inch in length, with a rounded or blunt end on the lower end, and this wound went into the chest through the right 7th rib into the chest cavity. There was approximately 100-200 ml of blood in the chest cavity, and further dissection disclosed that the wound perforated the right lung and continued forward and terminated, or the wound path terminated on the front of the rib cage, where I found a 3/4 inch cut on the posterior aspect or back of the right 4th rib. So after estimating the total length of the wound path was 4 inches.
Now, doctor, when you say ml, you're referring to milliliters, are you not?
Yes.
Was the length of this particular wound approximately 5/8 of an inch?
The measurement on the skin was 5/8 of an inch, yes.
And in your opinion, sir, was this wound consistent with having been inflicted by a single-edged knife?
Yes, this one had the configuration of a single-edged blade. It had the wound had a blunt or squared off end and a pointed or tapered end.
Was this a fatal wound, doctor?
This wound perforated the lung and caused hemorrhage into the right chest cavity, and is considered a fatal wound. It should also be noted there was another stab wound also into the right side of the chest, which also injured the lung.
We're going to talk about that second stab wound in just a second, doctor. It's just one more question with regard to stab wound number 1. Was that an antemortem wound, in your opinion?
Yes, it was.
Now, doctor, with reference to the stab wound that you have numbered as stab wound number 2 on the right side of Mr. Goldman's body, would you describe that wound for us, please?
That was on the right side of the chest. Actually close to stab wound number 1. And this wound measured 1.5 inches in length on the skin, diagonally oriented. This also had the characteristic of a dull or blunt end and a pointed or a tapered end, which again is consistent with a single-edged blade. And this wound also penetrated the chest through the rib cage, and this wound path was close to the wound path of stab wound number 1, with bleeding along the wound path, and it also went through the lower part of the right lung, creating a perforating injury. And again, there was hemorrhage along the wound path and the blood in the pleural cavity.
Indicating that this was a wound inflicted while Mr. Goldman was alive, isn't that right?
Yes.
Was this wound fatal?
Yes, because of the perforation of the lung and the associated hemothorax.
Doctor, there's a third wound that is depicted on the figure, the left-hand side of People's 30 for identification. That was a stab wound to the right flank, was it not?
Yes.
And that had a length of approximately 3/8 inches and a depth of penetration only into the skin and underlying tissue, is that correct?
Yes, that was a superficial wound. It did not penetrate the chest or abdomen.
Was it an antemortem wound, in your opinion?
Yes.
Doctor, with regard to the figure at the right side of the diagram marked People's 30 for identification, there appears to be a wound to the left thigh indicated on the diagram. Is that correct?
Yes.
And did you detect and observe such a wound upon the body of Ronald Goldman when you performed the autopsy?
Yes.
And would you describe that wound, please?
This was a stab wound of the lateral outside aspect of the left thigh, 2 1/8 inches in length, and there was a blunt or dull end seam, 1/32 of an inch, and the wound path was through the skin into the muscle of the thigh with bleeding along the wound path. The depth of penetration was approximately 3-3.5 inches.
Meaning 3 to 3.5 inches?
Yes.
And from your testimony, sir, I would infer that this was a wound that you would characterize as antemortem. Is that correct?
Yes, there was bleeding along the wound path and the tissue spaces, yes.
with regard to what you observed in connection with this particular wound, would you characterize this wound as one consistent with having been inflicted by a single-edged knife?
Now, this wound did have the characteristic rounded or dull end that would be characteristic of a single-edged blade. Yes, it would.
Doctor, during the course of the autopsy involving Mr. Goldman's body, you detected a wound to the left side abdomen of Mr. Goldman, did you not?
Yes?
And, Your Honor, I have here one last diagram depicting the described wound to the left side abdomen of Mr. Goldman. May this be 31 for identification?
Yes.
Doctor, with reference to the wound as depicted in the rightmost figure on this diagram of People's 31 for identification, would you describe that wound for us, please?
Okay, and I'm referring to my report to refresh my recollection. This is a stab wound of the left flank below the rib cage, and it was 3/4 of an inch in length. This wound did not have a blunt or squared off end. It was, one end was pointed or tapered, the opposite end was forked or split. And then going through this wound penetrated into the body wall and passed through the muscle, the iliopsoas muscle, with bleeding along the way, and then going from back to front, the wound path ended in the abdominal aorta, where two perforating stab wounds were evident. So the wound terminated in the abdominal aorta with two perforating wounds.
In other words, the abdominal aorta was perforated, is that correct?
Yes.
What was the apparent depth of the wound?
Measured from the outside of the body wall to the termination in the aorta was approximately 5.5 inches.
Was this wound fatal in and of itself?
Yes, this perforated the aorta. There was hemorrhage along the wound path, and there was bleeding inside the body cavity, the peritoneal cavity.
Doctor, not depicted on any diagram identified thus far, was there a stab wound to the upper right chest over the right clavicle? Do you recall that one?
Yes, yes, it's not on this diagram. It's in my report.
And that was a
This
superficial
is
wound?
a superficially oriented wound, 1/2 inch in length, involving the skin, the subcutaneous tissue. Again, it was split or forked on one end, pointed or tapered on the other end, with a small amount of hemorrhage. Again, cannot tell from this wound whether it was caused by a single or double-edged
You
blade.
were able to determine, were you not, that this was an antemortem wound?
Yes, there was a small amount of fresh bleeding associated, so it was an antemortem wound.
Dr. Golden, earlier in your testimony today, you have described for us what are known as defense wounds. Did you see any indicia of defense wounds on Mr. Goldman's body?
Yes.
In general, would you describe what you observed in that regard?
He had cutting wounds on the right hand, and on the left hand. And specifically, there were cutting wounds on the palm of the right hand, at the base of the index finger, palmar surface of the right hand, at the web of the thumb, palmar surface of the right hand, near the web of the thumb, palmar surface of the left hand, at the web of the thumb, and on the addendum report, specifically on the palmar surface of the left hand, there was a superficial cutting wound. So I believe that characterizes the main sharp force or cutting injuries
Your
on
Honor,
his hands.
I have here two photographs. People's 29 for identification, with the court's permission, depicts the...
I'm sorry,
palms-
People's 29?
I'm sorry,
We're up to
32.
31.
Yes. And that, the photograph bears a coroner's tag and appears to depict the right palm of the decedent. And then People's 33 for identification, Your Honor, similar photograph depicting what appears to be the left palm of the decedent, Ronald Goldman. It too also bears a coroner's evidence tag, which corresponds to the case number assigned to Mr. Goldman's autopsy. May these be so marked for
Yes.
identification? Dr. Goldman, I'm going to hand you first People's 32 for identification and ask that you observe that in discrete fashion. Sir, does that photograph depict the sharper incised wounds that you've described in your testimony as defense wounds to the right palm of Mr. Goldman's hand?
Yes?
Was that a photo taken during Mr. Goldman's autopsy?
Yes?
With regard to People's 33 for identification, would you tell us what that depicts, sir? That is the photograph that
That's
is
the
now
pop-
face down on the witness stand before you. What does that photograph depict, sir?
That is the left hand of the decedent, palmar surface.
Does that photograph truly and accurately depict the defense wounds to the left palm of Mr. Goldman's hands that you've described thus far in your testimony?
Yes?
Dr. Golden, in addition to the wounds depicted in People's 32 and 33 for identification, did you observe what might be characterized as other defense wounds to the back of Mr. Goldman's hands as well as to his forearms?
Yes.
And in general and in brief, how would you characterize those wounds?
Basically, there are multiple abrasions involving the forearm, including the outer or lateral aspect of the forearm where there are multiple abrasions. That means scratches. Some were not scratches. They were irregular in configuration. On the top of the hand, there were fresh bruises, abrasions on the knuckles, and I went into detail on which fingers and which knuckles there are abrasions, bruises on the various knuckles and fingers of the right hand. On the top or dorsal surface of the left hand, there were multiple red-brown abrasions involving the knuckles of the index finger, and then there were also multiple irregularly configured abrasions on the knuckle of the middle finger. There was also a fresh bruise, about 1 1/4 by 1 1/2 inches on the top of the left hand, adjacent to the wrist, and fresh bruises on the ulnar surface of the left wrist, which means on the, I guess you'd say, the inner surface of the left wrist. And on the addendum report, there were few additional abrasions on the fingers, the fingers of the left hand, middle finger, left hand, fifth finger, and on the distal portion of the left thumb. So basically, there are a number of abrasions and bruises, many on the top or knuckles of the fingers and on the top of the hand.
All compatible with defense wounds, in your opinion?
Well, yes, or arising during a struggle.
Dr. Golden, at the conclusion of your autopsy, did you form an opinion as to the cause of Ronald Goldman's death?
Yes.
And what was your opinion?
He died as a result of the multiple sharp injuries, which included the cutting wound of the left side of the neck, which severed or transected the left internal jugular vein, and the two stab wounds of the right side of the chest, which perforated the thorax and right lung, and the stab wound of the left side of the abdomen, which perforated the abdominal aorta.
A few more questions, sir, if I may.
Yes.
Dr. Golden, during each of these autopsies, were the investigating officers from the Los Angeles Police Department present?
Yes.
And by that I mean specifically, were Detectives Phil Van Adder and Tom Lang present during each of the autopsies?
Yes.
Sir, with regard to the autopsy performed on Nicole Brown Simpson's body, did you take a blood sample for purposes of serological study?
Yes.
And was that particular blood sample placed in a test tube bearing Nicole Brown Simpson's name and the applicable coroner's case number?
Yes.
Was the same procedure followed with regard to the taking of a blood sample from Ronald Goldman's body?
Yes.
And were those blood samples later delivered into the custody of Detective Van Adder?
Yes.
Dr. Golden, on June the 15th, 1994, were you visited at the Los Angeles County Coroner's Office by Detective Phil Van Adder?
Yes.
On that date, sir, did Detective Van Adder show you a knife?
Yes.
Describe what you recall about the knife that was shown to you by Detective Van Adder.
It was a folding knife with a blade approximately 6 inches long.
And describe what happened when Detective Van Adder showed you that knife.
Well, he wanted to know if that knife was consistent or compatible with the wounds that I saw inflicted on either individual, and whether it was compatible with some of the wounds inflicted on either individual.
And did you provide Detective Van Adder with an answer?
I said it could. Yes, I did.
And what was your answer?
I said it could have been the weapon. Yes, that inflicted some of the wounds.
Now, you examined the knife. Is that correct?
Cursorily, yes. I measured the length and the width of the blade.
Now, is your opinion that a knife such as that could have inflicted the wounds received by Nicole Brown Simpson and Ronald Goldman definitive, or would you have liked to have done something more with regard to examination of the knife to determine more precisely?
It was not definitive. I'd like to do a lot more.
Like what?
Well, make detailed measurements of the blade, correlating each wound that I described, specifically each stab wound that I described in my protocol, with measurements of the blade of the instrument.
To date, sir, have you had the opportunity to conduct such an examination?
No, I haven't.
So your opinion then is, with regard to the knife displayed to you by Detective Van Adder, that it could have inflicted the wounds upon Mr. Goldman's body and upon Nicole Brown Simpson's body, but not necessarily so. Is that correct?
Not necessarily so. To be scientific, I would have to get my little white ruler out that I use for measuring the wounds on the body and do the same thing on the knife.
Okay. May I have a moment, Your Honor?
Yes.
No further questions.
It's about 5 minutes to 12. Which,
All right, so now we're going to get into the opening statements. And hello, Frog. It's nice to have you with us. Howdy to you. Shout out to you and Frank. All right. Thank you all for being here and hanging out with me. Absolutely. We're doing that right now.
Precedents where it has been done before.
All right, good morning, counsel. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Ullman, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. All right, counsel, we have just a few matters to dispose of before we reach our opening statement.
Whoa. I just got to admire this for a second. Look at these computers in this courtroom. It's like I still have these type of computers, but they're in like I don't really use them that much. So it's like the classic computer screen, like those big clunky white boxes. I mean, for me, like to see this courtroom in this type of way is fascinating, truly, because now they have laptops, but look at this. They have these big computers. Wow. That's impressive. It was, absolutely. Definitely. I grew up with computers like that, and that was like the greatest technology at the time. And I wasn't, of course, in this time period. I came a few years later into this world, but yeah, I definitely I used a computer before, right from this year, like for that year from where this took place. So I'm very familiar with them. Yeah, so definitely to see time how it, and in 20 years, 30 years from now, I'm sure there's going to be like other technology, like why you'd say a floating computer with some floating screen one day. So, yeah, so this is very interesting. Heron said, we grew up with a computer in the kitchen if you were lucky to have one. Yeah, there's, especially, 30 years ago and beyond, people with these computers you would have, some people wouldn't even have them. Some people did have them, some people didn't. It was I would say the equivalent today is having a VR headset. And the AI stuff in our time is the modern version of like what these computers were for them at that time period. So, yeah, absolutely, indeed. And yet, remember the Apple Performa, that's one that I have, but, it's out of service. But still, it was one of those types of computers, and people would have it in their kitchen or somewhere in their house. And it would be a family computer everybody would use. Now you have a phone that could take a picture, that could go on the internet, a little phone. So the technology is quite incredible. But yeah, that's how it was in the beginning. It was those machines. And then before that, 50 plus years before that, it was a big room that had a computer in it. Kitchen, living room, where we could squeeze a desk. Yeah, a lot of people did that. And that's all the commercials from 90s, and they would have the family computer, and they would have, I remember like with Windows XP, which is much later, or in the 2000s, although of course I'm aware of the ones before that. see you would have a user accounts. That was something I liked about Windows XP. It was very cool with the user accounts. I would say the mod systems and we have on YouTube and the different accounts on YouTube is similar to like a computer user account. So yeah, and you would have a family, so you have multiple users using one computer. So that's where that came from. But now, like with an iPhone or an Android tablet, iPad, everyone just kind of has their own individual personal computer device. So it certainly has evolved over time, indeed.
Stage. Counsel, yesterday the jurors, when they retired, one of the jurors handed the bailiffs a note for the court, and they were just curious as to whether or not the court was going to allow them to watch the Super Bowl this weekend, and I've indicated to them that yes, they can, and that we would arrange their visitation schedule accordingly. So I take it there's no comment on that. All right, Mrs. Robertson, would you create a file for juror notes, please? All right, first issue to be resolved is the defense motion to allow Mr. Simpson to briefly address the jury during the course of defense counsel's opening statements. All right. Certainly.
Your Honor, the first objection interposed by the people is that this has never been done before. And we have located at least 2 California precedents where it has been done before. The first came in probably the first case of the century, which was the trial of Clarence Darrow here in Los Angeles.
And the only cases that I could find that were of interest were a case out of New York.
Yesterday evening, Your Honor, we were discussing the possibility of making alterations to the SOC timeline chart, of which there was an objection. As the court will see, we have altered the offending language to reflect the details and circumstances of a report that was part of an analyzed evidence report that I'd like to submit to the court and which I have already given to opposing counsel. What it says basically, Your Honor, is that there is a notation referring to different pieces of evidence. There is a notation for SOCs, navy blue / black. There is
the June 29th report.
This is a report, Your Honor, if I may approach.
No, just answer my question. Is it the June 29th report?
Yes, it is. And it talks about there being, quote, dress socks, semicolon, blood search, paren, none obvious, close paren. And we would submit, Your Honor, that this is in fact a fair reflection of what we think the evidence is going to show. We would submit that that chart is not unduly prejudicial, and we would submit that the court should overrule the objections and allow the admittance of that chart.
Who was the author of that report?
This refers, Your Honor, this document apparently was prepared for the split hearing. It's Peoples 2 at the split hearing. And Yamauchi, Kessler, and Matheson each testified about the process by which they took out different pieces of evidence and examined it. And this was a document that was prepared specifically for that hearing.
All right, that doesn't answer my question.
Who prepared the report?
Who prepared that report?
Michelle Kessler, Greg Matheson, and Colin Yamauchi.
Was that the index that was prepared, the evidence index?
It says summary of analyzed evidence by analysis performed. That's the title.
Okay.
It's Exhibit 2 at the split hearing. The remaining objection, Your Honor, would be in response to the concerns about the videotapes and the scenes that were reflected of different officers walking through the crime scene at various times. We have now obtained the remaining tape recordings, and Your Honor, there was a misstatement yesterday. The scenes that were shown in the tape that has been given over to the people are not scenes that were taken from CNN, but rather they are a collection of different tapes that were received from different local news media, so that for us to introduce these different snippets, if you will, at trial, we will simply be able to lay the foundation by subpoenaing and bringing in to testify those operators of, I think it's local channels 5, 7, 11, and 13, from whom these particular snippets were culled. That tape has now been provided to the court, and that tape has also been provided to the people. We now have the tape from San Francisco that had 2 other blips that were not shown on the first tape. I am told by Mr. Hodgman that the people would continue to maintain their objection. So what I propose, Your Honor, is that the court allow the showing of the scenes that were displayed yesterday. They are scenes, Your Honor, that are very capable of being authenticated. In many ways, it is self-authenticating. In many ways, they are authenticated because there will be an evidence or a police log where each individual who comes onto the scene first checks in with one of the police officers that are there. That log will be an item of evidence, and it is possible by showing the scenes and having those depicted there testify to establish clearly when the various pieces of scenes were taken and what sorts of things were occurring. It is true, Your Honor, that it is the people's crime scene. It is true, Your Honor, that they themselves do not have a videotape of the crime scene. There are certain discrete acts that are going on. For example, Detective Lang measuring a certain location. For example, you see criminalist Fung placing down particular evidence tags. You'll see detectives walking through, Detective Van Adder and Rogers walking through, and quite clearly the sheet is there because the body has been removed, but the sheet remains, and it shows, Your Honor, the sort of sense that we are going to depict in words. It helps to provide a visual context to the words that Mr. Cochran is going to speak. He is going to discuss how the evidence will show that there was contamination of the crime scene. We would then hope to show pictures that demonstrate, that reflect the contamination of the crime scene. They are going to offer evidence, I suppose, Your Honor, how the crime scene was not contaminated. Perhaps they'll show that when these scenes were shown, all of the items of evidence had been collected. Perhaps they'll show, or they'll offer evidence that when these scenes were shown, it was the next day or the third day after. That is the risk that we are going to take by the statements that we are going to make in our opening statement. But whether or not there are the visual reflections of certain words, Mr. Cochran, I think quite properly, will be able to discuss and to speak about how the crime scene was contaminated and how we contend these scenes are simply a small reflection from the only live record that is available showing the conduct of Detectives Van Adder and other detectives at both the Rockingham and Bundy crime scenes on June the 13th. Your Honor, that I think is the end of my objections to the charts that the people are going to offer and my explanation to the items that were remaining yesterday.
Thank you, Mr. Douglas. Ms. Clark? I'm sorry, excuse me, hold on a second. All right, Ms. Clark?
I thought that the court had concluded its ruling yesterday with respect to the tape. Mr. Cochran made a motion that when a ruling is issued, we not re-argue it, and we all agreed to that.
Well, what I said yesterday is that if the defense makes the videotape available to you, and after reviewing the tape, you still maintain, I mean, who knows, after looking at it, you might have changed your mind. Now that you've had the opportunity, it's been brought here, what's your position?
We haven't had a chance to see it. They just gave it to us this morning when we walked into court.
How long are these videotapes, Mr. Douglas?
Your Honor, the first tape was played, I think, in its entirety yesterday.
Correct.
The second tape, which is, we got this morning from San Francisco, is approximately 25 to 30 minutes long. However, a lot of that is a press conference by police officers. The first 5 or 10 minutes contains the 3 clips that we wish to use in opening today.
The
In
first
addition to
the first 5 or 10 minutes of
Yes.
this?
In addition to the ones that we showed yesterday.
The same problem exists now as it did before. We don't have a foundation as to time, and time is very important. The bloodstains were collected at a certain point, and that's not established with the tape. Secondly, there's a counter at the bottom of that tape that's very misleading, because it looks like all of these different, actually, pieces of tape were one continuous shoot, which is not the case, as counsel even concedes. There was considerable editing done to that tape, and the people maintain their objection.
All right, don't you think we ought to at least look at the first 5 or 10 minutes to see if you still do?
I will, certainly, Your Honor.
All right.
I'll be glad to. Let me go on to the other exhibit. With respect to the SOC timeline,
Yes.
what Mr. Douglas has represented to this court is very misleading. And I confronted him this morning, and I explained to him that on this is not a business record, I should indicate to the court, first of all. It was a chart prepared specifically for the Griffin hearing and the blood split hearing, actually, at my request, because I wanted to see exactly what they planned to do with all the items of evidence and what seemed to be sufficient for a split, what did not, what was capable of PCR, what seemed to be capable of RFLP. In the box-marked comments, it shows blood search, because that is what they planned to do. It had not yet been done. These are navy blue to black socks, which, if you look at it with the naked eye, you're not going to be able to see anything. It was scheduled for a blood search, and it was put down that none was obvious because on a black pair of socks, you're not going to see blood. It's going to be, at best, you might see something wet, but after a period of time and it dries, you won't even see that. So it was scheduled for a blood search, and what Mr. Douglas has on this chart is very misleading because it indicates that they have already looked for blood and that none is obvious. This is exactly the problem. Is that the jury is, and if Mr. Douglas had spoken to Mr. Matheson, he would tell him. We put it there, as many of the other items listed in this comments column, as a prospective plan. You can see on this list, it says, just above it, the item number 12, swatch, RFLP possible, and on previous items it shows RFLP would consume, PCR only. It's very obvious what this is. They're talking about what is capable of being done or what they plan to do. Not that it's been done, it hadn't been. So what counsel has put there is, again, completely misleading. It's the opposite of what occurred.
All right, let's take a look at the videotape and see what's there.
May I also request leave of the court? There was one chart we had not yet seen that we only saw a Xerox copy of. I wanted to address the court further on it, and I think I can do that better if I have the chart in front of the court. That was the chart entitled Deceptions, Distortions.
I thought you said you had no objection to that.
I had lost my copy of it at the time, Your Honor. There is language on it that I wanted to object to, not the entire chart, but certain language on it, and I need to confirm that that is on it. If it's not, there will be none. But that is the problem with not having everything in court on Friday as the court
counsel, is
requested.
there a reason you didn't tell me that you didn't have it in front of you when you asked me to rule on that?
I apologize to the court. I thought that...
I mean, I can't keep doing these things over.
All right, and now what we're going to do is going to get directly into the opening statement from the defense right now. Okay, so let's put this here. We'll make this a little bit bigger. All right, we're going to go back to this after the other clip is done. This wasn't quite the opening statements just yet. It's over here.
To my colleagues on the right here, the prosecutors, to my colleagues on the defense side, to the Brown family, to the Simpson family, to the Goldman families. Ladies and gentlemen, good morning to you. As the court indicated yesterday, I would have liked to have had this opportunity about 3:30 to address you. And it's my opportunity and it's my honor and privilege on behalf of the defense and our defense team, as it were, to stand before you now and address you what is called opening statement. Now, the opening statement is not opening argument, but it's just that, opening statement. If you've had occasion to go to a movie, you know that there's something called the previews of coming attractions. And that's what this is supposed to be. It's supposed to be a guide, or a roadmap, if you will, what we expect the...
Yeah, I'm going to say, like, these people talked much more sophisticated than people do now. Because I'm not, like, there's very good attorneys and stuff at trials and the DA, but these people seemed much more, in my opinion, more professional acting than the people nowadays. But, you know, I've only seen a few of these trials from this time period. In the early 2000s, we've seen a couple of times on this show, but yeah, I'm not too sure what it is exactly, but or if I'm just overthinking. But it seemed like they had. I like how they conducted themselves in this time period, from my observation of the trials that I've seen so far. From the different time periods they had trials, because most trials we see are from the modern age, but I've seen a few from back in the past. So, you know, that is my take on that. Okay, you could see my comments now. Okay. Oh, all right. Yeah, I don't know what it is. It's you know, YouTube glitches. But thank you for switching over so you could see what the comments I was saying to you. All right. Scared. All right. All right.
Evidence to show. As an officer of this court, and in the course of my remarks this morning, and maybe this afternoon, I would expect to tell you as honestly and as forthrightly as I can what I expect the evidence to be. As the court has so appropriately indicated, what I say is not evidence. It's just to aid you and guide you. I hope you remember something else the judge said to you last night. You heard the prosecutor's opening statement yesterday, that you were the same admonition applied to them. Those were not facts. But you kept an open mind, because you promised to do that throughout. We started this process of trial back on September 26th, 1994. That was the first day we all met, when you came down to that jury room up on the 11th floor. And here we are now, several months later, in this search for justice. You hear a lot about this talk about justice. I guess Dr. Martin Luther King said it best when he said that injustice anywhere is a threat to justice everywhere. And so we are now embarked upon this search for justice, this search for truth, this search for the facts. Each of you made a number of promises in the course of the voir dire examination, which is basically unprecedented and due mainly to the largesse of Judge Ito in understanding the possibility of media taint associated with this case. So we know a lot about you at this point. And we, of course, all sides are very, very pleased with the fact that you've agreed to serve as jurors, to give us your time, to leave your lives, to be sequestered, as it were. That's a remarkable sacrifice. Abraham Lincoln said it best when he said that the highest act of citizenship is jury service. And you're embarked upon that jury service. But it doesn't stop with just coming down and taking notes. It doesn't stop with the inconvenience of being away from your families. When it stops is when you, if you can, render a verdict in this case. And whether or not that verdict reflects the evidence in this case. A verdict rendered devoid of sympathy for or passion against Mr. Simpson or any side of this case. You made these promises, and both sides are mindful of those promises. And we know that you're going to keep those promises. Cicero said that he who violates his oath profanes the divinity of faith itself. And of course, we know that you will live up to your promises. And be fair, and keep an open mind, and decide this case not on speculation, not on conjecture, not on surmise, but based upon the facts. You then, as jurors, are the conscience of this community. Your verdicts set the standards of what we should have and what should happen in this community. You have this rare opportunity, it seems to me, to be participants in this search for justice and for truth. And in the final analysis, hopefully by April of this year, I'm optimistic still, you'll be able to render perhaps the most important decision of your lives. And so we want to keep your minds open and fresh so that you can render that decision impartially to both sides, so that people all across the world can say, this system works. This was a fair trial. These were fair people. So thank you in advance again for your service, for the verdict that you're likely to render, and for all the things that you're doing here for us.
Your Honor, the court knows me, and I know Mr. Cochran knows me. I have to interject at this point. This is argument.
Were introductory remarks that were similar in nature to prosecution's opening remarks. I think Mr. Cochran has just concluded his opening remarks.
And I trust.
Correct, Your Honor.
And again, I hesitate to interrupt another lawyer's opening statement, but I simply wanted to make sure that this type of.
These people got a projector. I actually don't have to, Xavier. I get notifications because of mental illness. Oh, okay. We love you, Frog. And they have a projector here, and in my library when I was back in school, they had a projector they would show us things on. So that's it, there it is right there, another one. That was before they had the computer stuff to like display on the screen. The computer projectors.
Statement was ceasing. Thank you, Mr. Cochran.
Thank you. Thank you, Mr. Eisman. I was just about to compliment the district attorney's office on their opening statement yesterday. Maybe I'll take that out now. I was about to say they did a thorough job as far as they went. But they're advocates. And all of us, as you will see today, have an obligation to tell you the whole truth of these facts. So in the course of my statement today, let me share with you some of the things they didn't tell you yesterday, and we'll have to wonder why they didn't do that. The evidence in this case, we believe, will show that O.J. Simpson is an innocent man wrongfully accused. Mr. Darden said yesterday that in Richmond, California, and someplace in Georgia, people were asking questions. Well, I'd like to think that in my hometown of Shreveport, Louisiana, my mother-in-law is in New Orleans, Louisiana, and other places throughout this country, today they're asking, why did Mr. Darden spend all that time on domestic violence? This is a murder case. Why did he do that? And then when he gave you this answer, he was going to answer the question for all of America. It's a little presumptuous, don't you think? Because the answer of O.J. Simpson's guilt or innocence would only be determined by you if you're able to do it. None of us were out there on June 12, 1994. We can only deal with the witnesses as they were. And it seems to me that this case, the prosecution's case, based on what we heard in the evidence, will show this case is about a rush to judgment, an obsession to win at any cost and by any means necessary. Let me just briefly talk about the witnesses that they didn't talk about yesterday and they didn't tell you about. There's a lady who lives next door and works next door to Mr. Simpson's home on Rockingham. This lady was interviewed as far back, I think, as July. She indicated, essentially, that on this night in question, she came out to walk her dog on several occasions. She knew Mr. Simpson. She knew his voice. She knew the Bronco. She'd seen it parked there many times. She will indicate that when she came out and walked her dog at about 8 o'clock, that Bronco was parked at the curb there, and it was parked at kind of a unique angle so that she noticed it. The rear wheels were a little bit further from the curb. And when you go out there, and I think the court will probably share with you that at some point you're going to get a chance to go out to each of these scenes to see for yourself these areas. When you come out of the Rockingham gate and you make your turn, the evidence will show it's a quick turn, and so you can't line the car up quite like you'd like to. But this lady will testify that she was out with her dog and saw that Bronco parked at that particular angle at about 8 o'clock, 8:30 on June 12, 1994, Sunday evening. She will indicate to you that she heard Mr. Simpson's voice at or about the time he and Mr. Cato Kalin went to McDonald's to get the hamburger. But she could hear, because her quarters are right across the fence there, that after he left, she heard something very strange. She heard a prowler that she described out there in the yard with like hard-soled shoes. And she was concerned about this prowler. That's what her statement was. She relaxed when she heard Mr. Simpson return back. You could hear his voice back over in the yard. But she was concerned because the people she works for were out of town at this time. She's concerned about this prowler, and we'll talk about that more later. She went about her business, and then she heard Mr. Simpson's voice again about 11 o'clock. She could hear his voice at that time as though he was leaving. We know that's correct because he was leaving to go on a trip to Chicago, a pre-planned trip. And then she didn't hear his voice anymore. But one of the important things that she tells us is that after Mr. Simpson had left, after 11 o'clock, she heard men's voices over on the Simpson property between 12 o'clock up till about 2:30 or 3 o'clock in the morning. Heard these men's voices over there talking, and she didn't know what was going on. I hope I told you that when she came out to walk her dog at 10:15, that same night, she looked at the Bronco, and the Bronco was parked exactly the same way, at that curb, same way. When she saw the Bronco the next morning, it was parked that same spot, the same place. And one of the most unique things about this lady is the fact that the morning of June 14th, that Monday morning, a police officer came over to her residence to ask her what she'd heard and to put her on alert that if she found any weapons or if the gardeners found any weapons, to let them know. And she can identify that officer as Detective Mark Furman. Detective Mark Furman will play an integral part in this case for a number of reasons. Now, it's very interesting that the prosecution never once mentioned his name yesterday. It's like they just want to hide him. But they can't hide him. He's very much a part of this case. We can only ask ourselves, why didn't they mention him? I think that answer will become very clear to you as the case progresses. But she will identify Detective Furman as the person who came over and spoke with her. And she told him at that time about her observations, about hearing this prowler, and about the fact that she heard these voices that went on until about 3 o'clock because she couldn't go to sleep until about 4. And when she woke up, it was like 7:30 or 8. And he was there showing his badge through the door. And she saw him on television at the preliminary hearing. So that's how she could identify him. He said that somebody from the LAPD will get back to you. But they never came back. They never came back at all. Because there's a rush to judgment here. There's another witness, Mary Ann Gerches, a very interesting lady, has her own business. And on this particular night, in June of 1994, June 12th again, she wanted to find a place in the West Los Angeles, Brentwood area. She drove her car after she closed up her business on Sunday evening and went to Catholic church, went to Mass, went and parked a car. And she came over there on Monday. Very interesting. Before I tell you what she has to say, let me tell you her contact with law enforcement. The evidence will show that Mary Ann Gerches, after she became aware that what she had seen had some great relevance to this case, started calling the police. She kept being transferred and transferred around. Couldn't get anybody really to talk to her. Finally, when she finally reached the police officer, they told her, we've got that case all wrapped up. They didn't want to hear from anybody else. And then, lo and behold, she called the district attorney's office. Spoke to a person whose name will be revealed during the testimony. And she didn't feel she's treated quite appropriately. In fact, she will say that the person put her on hold and said, excuse me, I'm talking to a psychic right now, and I'll get back to you. I guess it was part of that hotline they had. So it seems they're more interested in talking to a psychic than talking to her. So ultimately, she called the defense, and we talked to her. Walked with her out of the scene. Here's what she will testify about. That on June 12th, 1994, sometime after 10:30 in the evening, she's walking down Bundy. She's looking, it's a warm night, she says, and she's looking for places that have signs up to rent or to lease. That Miss Nicole Brown Simpson's condo, you recall, is on one side of the street, that's the west side, and she's on the east side of the street. And at about 10:45 p.m., she sees 4 men who come within 10 feet of her, 2 of which, gentlemen, appear to be Hispanic. I think the other are Caucasian. Several of which I believe have knit caps on their heads. The 2 who are behind apparently have something in their hands they're carrying. She thinks they may be undercover police. She doesn't know. They get into an unmarked car and they speed away, and she sees them. And that's what this lady was trying to tell the police, trying to tell the district attorney, trying to tell anybody who would listen. But they didn't want to listen because they made their decision in this rush to judgment. There are other witnesses that I won't bother you with right now because we'll talk about them later on in the course of the opening statement that bear upon that evening. But I will share just 2 of you because it sets the stage for many of the remarks that Ms. Clark made yesterday. You'll recall that in her opening statement, quite well done, Ms. Clark kept telling you that she had to fix the time of death in this case at about, what'd she say, about 10:15? She had to make it 10:15, and she made it based upon a dog's wail. Now, this is the first case you'll ever hear where the prosecution's theory is that you've got to determine the cause of the time of death by a dog's wail. And this is the most scientific of all cases. But there's a reason why she wants that, because she wants to give enough time for her theory about O.J. Simpson to work. But we will produce for you, and hopefully all these witnesses will be available. As you're well aware, these witnesses are afraid. This could be because of all the media attention, but we're going to try to get them. And what I say to you is what these witnesses have said to us at this point. There's 2 people who have been to Metzaluna restaurant, the same restaurant. Mr. Dan Mandel and Miss Ellen Aronson. They've been on a blind date. It's like their first date. And they're walking home. They walk home and they come right down Bundy also. It's very interesting. As they walk down Bundy, they walk on the west side of the street, right past 875, Miss Nicole Brown Simpson's residence. And they walk past there, and it's interesting because as you saw from those pictures, and we all apologize you have to look at those pictures, and certainly to the family, and we want to be as careful as we can with those pictures. But if you saw those pictures, you could see with the gate open, and you walk right past, the sidewalk comes right down, and the bodies were very visible with the gate open. They didn't see any gate open or any bodies or anything. And it was like 10:25 at that point. So what does that do to their theory about 10:15 and the dog's will? Now, who are we going to, well, I won't be argumentative. At any rate, there'll be evidence that at 10:25, that people who walk past, who have no axe to grind, have nothing to do with this case, who they know about and we know about, don't see any crime having been committed. There are other witnesses who are going to testify they don't hear any dog barking at 10:15 or no plaintiff wail, whatever that means. And so, in this initial phase of the opening statement, what I've tried to share with you is that all of us, it seems to me, have an obligation to share with you and be as honest and forthright as we can. In that connection, you'll recall that Ms. Clark yesterday talked on a number of occasions about the limousine driver and what he saw. You recall she said to you that the limousine driver, when he came and left to take Mr. Simpson to the airport, she told you that he did not see the Bronco parked there. That's not exactly what he said in his testimony at the preliminary hearing in the grand jury. And I'd like to read that to you, if I might. He says this question: did you make an effort to look and see if there were any cars there? Answer: I looked to the right to see if there were any cars coming down the street. Well, I'm asking you if you looked.
Objection, Your Honor. Objection, Your Honor. This is taken from a different portion of the preliminary hearing.
Overruled.
May I proceed, Your Honor? Thank you. Did you make an effort to look and see if there were any cars there? Answer: I looked to the right to see if there were any cars coming down the street. Well, I'm asking you if you looked, made an effort to see if there was a car parked. Answer: no. There might have been a car there and you didn't see it? Correct. Now that's under oath before the grand jury. Now let's look at the preliminary hearing. What he says there, at a second time this man testified. Then did you leave? Yes. What gate did you leave from? The Rockingham gate. And which way did you go on Rockingham as you exited the gate? I made a left. So you'll have to picture that as he's coming out of that gate. He's in the driver's compartment. He's going to make a left. The Bronco would be to the right. And which way did you go on the Rockingham as you exited the gate? I made a left. Question: did you look to see whether any cars were parked on the right side as you faced the driveway of Rockingham outside the residence? Answer: I didn't look to see. You weren't looking at the parked cars? Answer: yeah. You were looking to see if there was traffic. Answer: yes, of course. So I use those examples early on to talk about our contention that there is this rush to judgment in this case. That when Ms. Clark said yesterday that they did everything they could to exclude Mr. Simpson, we're going to talk to you about the trails that they didn't pursue and didn't go down today. We're going to also talk to you about this evidence, what we call the lack of integrity of much of the prosecution's evidence. You saw yesterday some pictures of this crime scene, and the crime scene was certainly bloody. We all acknowledge that. But I think you'll find the evidence will show that the LAPD, in its infinite wisdom in this case, assigned a trainee named Mazzola, who was the officer in charge of collecting this evidence. This was her third crime scene. And contrary to what you heard yesterday from Ms. Clark, our experts, and we have a number of experts that we call to testify. In fact, one of our experts is named Dr. Kerry Mullis. Let me tell you who Dr. Kerry Mullis is. Dr. Kerry Mullis is a DNA expert. He is the man who invented PCR, polymerase chain reaction. He is the man who received the Nobel Peace Prize for this invention. And he will come in here and tell you about this evidence, how sensitive it is, and how these police departments are not trained in the collection and use of it. That this is, by all accounts, 21st century cyberspace technology that is being used by these police departments with covered wagon technology. And so when Ms. Clark tells you yesterday that it's possible, just like cooking or doing something like that, She said she wasn't an expert, and I agree now on that, at least. She's an expert lawyer, but not in this area. The experts will say that's just not true. And so the collection of the evidence becomes very, very, very important in this case. And so, you know, when they were trying to hide Furman yesterday, there were a couple of pictures yesterday of an officer leaning down, pointing at the glove and the cap and everything. And you notice that as they talked about it, that was Officer Furman. Never bothered to mention his name, never bothered that. And so we have then this concept of the prosecution's theories. You heard Mr. Darden stand up and tell you his theory of how this happened. And a theory is only good until the facts come along and makes clear to you what actually took place. And so we think that if you keep an open mind, you'll be able to deal with these theories and then apply the facts, which is your job as the sole exclusive judges of the evidence in this case. Now, Mr. Darden, when he addressed you yesterday, spent a long period of time talking about Mr. O.J. Simpson's marriage to Miss Nicole Brown Simpson. And he spent a lot of time, and he told you a number of things. He told you how, for instance, that this was like a terrible marriage and that all kind of bad things happened, and these people were together 17 years and was just terrible all 17 years. I think you'll find that's not exactly true. He told you how Mr. Simpson was in, how did he describe it? An ugly mood on June 12th, 1994. He told you also that Mr. Simpson came there with some flowers. Well, we'll forgive him for that. Mr. Simpson didn't come with flowers. He was there. The testimony will be he was there, he left and went, got the flowers, and then came back. But let me try to show you graphically Mr. Simpson with his daughter. And Your Honor, I'm now referring to a photograph, and I need to check with my colleagues, and I believe this will be Defendants 1, if the court would allow, or A, whichever court would.
Defense 1.
Defense 1, thank you, Your Honor. This is a photograph of Mr. O.J. Simpson and his sweet little daughter, Sydney Brooke Simpson, shortly after this concert at Paul Revere High School. This picture was taken, and I think you'll even see the date. You see 6/12/94. This picture was taken by a Dr. Ron Fishman, who was at that particular recital. They were all friends. He will tell you that since Mr. Darden wasn't there, he's got his facts all wrong. O.J. Simpson, according to the testimony, was not in any ugly mood. He talked to Ron Fishman. He was there to see his child. And you'll hear that he came back to Southern California from New York City, where he was on business. He was out of town almost all that week, specifically to try and come to this recital. He had to leave right after this to go to Chicago. He was already back east in New York, and we will produce a friend who told him, why don't you just stay back here? And Mr. Simpson told him, I missed my daughter's first communion because I was out of town on business, so I want to go to this dance recital. And that's what he did. Does that look like he's in an ugly mood to you there? And you'll see the two of them there at that point. Wherever we can, we're going to bring to you the facts versus their speculations and theories about this man. They don't know this man. The evidence, you will know him by the conclusion of this case. And so, Mr. Darden kind of apologizes at the end and says, this isn't character assassination. You know, when somebody says that, who said it was character assassination? Because he knew that's exactly what it was. So at the very end, when he said it wasn't character assassination, that's exactly what he had done for an hour to O.J. Simpson. He's not charged with any domestic violence. This is a murder case. And in their pursuit to win, they're trying to dredge up some theory to give you a motive, because they don't have a motive for this and these particular crimes. And who's to say that those 4 men we saw running from the area of 875 hadn't followed Mr. Ron Goldman there, as opposed to looking for Mr. Cole Brown Simpson? Can they?
Your Honor, I interject once again on the grounds previously stated.
this is argumentative. This is not a recitation of evidence. We've gone beyond the normal scope of opening statement.
All right, the objection's overruled at this time. Thank you, Mr. Carpenter.
Thank you. Got a little sidetracked there. Let me see. I think I was indicating to you, who's to say, based upon the facts in this case and the evidence, that those 4 men that Marianne Gertjes will testify about hadn't followed Mr. Ron Goldman to that location. Another thing that happened yesterday that is not true that they told you. Ms. Clark told you that Mr. Ron Goldman checked out of work. He was going to come over and do a favor for Ms. Nicole Brown Simpson to bring the glasses, and she described for you how he was dressed. I think she said with some white shirt and black pants or whatever, that he then came over to the residence. You saw those pictures as terrible as they were. He was in some jeans and some kind of shoes that are far different. And the evidence will be he went home, dropped off a book, and changed clothes before he came to Nicole Brown Simpson. But the reason that you weren't told those facts is because it's important they keep this 10-15 time. They've got to keep everything squashed in there so they can tell you, oh, we had plenty of time to commit this crime. And when we conclude today, you're going to see there was no time to commit this crime. And so, to wrap up this part about the so-called character assassination or whatever, what I'd like you to do, as with all of the evidence in this case, is to keep an open mind till you've heard both sides. They may try to bring out incidents about this marriage, and these people did divorce in 1992. And unfortunately in our society, there are far too many divorces. People don't always get along. And we sometimes get divorced. Some of you probably got divorced. And it's unfortunate when that happens. But I'd like you to keep an open mind. But I think perhaps the most important thing about this whole area is this as a response to Mr. Darden. There is an expert in the United States whose name is Dr. Lenore Walker. She's, by all accounts, the #1 expert in America on the field of domestic violence. She's been called by some the mother of the battered woman syndrome. Now, they didn't talk about this yesterday, but Lenore Walker will be a witness for the defense. And I want to talk to you about her and her testimony because I think it'll be relevant as we talk about Mr. Darden and what he has to say on this area. We know that Mr. Darden is not an expert in this area, and he's a lawyer conveying the facts as he understood them. But he wasn't there. Dr. Lenore Walker, this #1 expert in America, perhaps in the world, in this concept, has seen and interviewed and tested Mr. Simpson. She hasn't concluded all the testing yet, but she will testify to you about the results of those tests when she's completed. But she has and does have some feelings about this case and about Mr. Darden's remarks. In fact, as an expert, she's permitted to watch Mr. Darden, and she watched him yesterday. And she was kind enough to share with me last night what her thoughts were about this theory.
Maybe approach.
I'm going to tell what the evidence is going to be.
All right, Mr.
He's going to offer to the jury Ms. Walker's feelings about my specific comments yesterday. My opening statement was not evidence, Your Honor. Ms. Walker ought to confine her opinions to the evidence in the case. And this is argumentative, and it's been argumentative.
Objections overruled.
Thank you. Dr. Walker, along with a number of us in the courtroom when Mr. Darden was speaking yesterday, felt that it's offensive to women to say that they never had a job.
This is argument.
All right, very well. You're right, Your Honor. And let me rephrase
She
that.
was going to testify as to her analysis of Mr. Simpson or what her testimony is going to be. That's one thing. Commentary upon Mr. Darden is something else.
You're right. You're absolutely right about that. Let me see if I can restate that in a positive way, Your Honor. With regard to Mr. Darden's statements yesterday. You recall when Mr. Darden said that Nicole Brown Simpson never held a job, and he wanted to paint this picture for her for being, totally under control and being controlled by O.J. Simpson and under his thumb and that sort of thing. Well, I think that some of us would feel that somebody who raises 2 children, who's an excellent mother, that's a pretty major job, being a homemaker. And we'll talk about whether or not Nicole Simpson was a Barbie doll that one could just make in their own mode. Because even in Darden's statement, he said this was a strong, tough lady. And I think you'll find that's what the evidence is going to be. But with regard to this whole aspect of battering, in this case, let me say up front that Mr. Simpson is not proud at all of the fact that he and his wife got into an altercation and she was struck on January 1st, 1989. He's not proud of that. In fact, in the course of this evidence, you're going to see perhaps 3 letters that he wrote apologizing to his wife. But what Mr. Darden and what the evidence hasn't shown you so far was that from 1989, January 1st, 1989, they made a big thing out of that. From that day forward to the present date, there's no evidence that O.J. Simpson ever struck his wife again. Now, you should never strike your wife. But even when he made a mistake on January 1st, 89, he paid his debt for that. He went to court and he pled nolo contendere. He pled no contest for that. He was sentenced to community service and he paid his debt. Now they want to retry that, I suppose. They don't tell you that. There was not any touching after that. In fact, O.J. Simpson did something else. After that incident, he was so contrite that he had a prenuptial agreement with Nicole Brown Simpson. So if they got a divorce, what her share would be. And he went and he had his lawyer put in writing, which was later signed by her, that if I ever strike you again, the prenuptial agreement is voidable. And until the date of her death, that agreement was never made void or voidable. Now, those are the facts. And so when Dr. Walker comes and testifies to you, she will talk about the fact that life-threatening violence usually precedes a homicide incident. And she does not find that in this case. She will, I believe, testify that according to the National Institute of Justice, approximately 2.5 million women are battered in this country every year. An intolerable situation. Statistics indicate, however, that between 1,200 and 4,000 of those women are killed. That's 1,200 to 4,000 of the 2.5 million battered. Dr. Walker will testify that it is impossible to use these statistics to prove that anybody who allegedly batters becomes a murderer. You might liken it to an example of smoking. Somebody may get lung cancer. The fact they get lung cancer may mean they smoke and may not. But if you smoke, I can't automatically predict you're going to get lung cancer. And so that this is not a predictable science, according to the lady who's the mother of this particular area. That although domestic violence is a very, very serious problem in this country, the level of violence in this case and the pattern is atypical. Atypical means untypical of those relationships where a lethal incident often occurs. For instance, stalkers don't go all across the United States working, doing commercials, shooting movies, having a new girlfriend, going out with their life, doing all the things you're going to find this evidence is about. They don't have a new girlfriend by the name of Paula Barberi, who you've been very serious about from April of 1992 till April of 1993 until Nicole Brown Simpson asked to reconcile and get back together. She did it in this way. She sent to Mr. Simpson, among other things, a video of their marriage a video of the birth of their children, accompanied by a long letter spelling out how much she wanted to get back with this family. Now, I think you'll find that's not stalking. And Mr. Simpson's response was, we've had problems in the past. I have a girlfriend now. I'm happy. Let's take our time about this. But she pursued. She followed up on that. She pursued. She wanted to move back to Rockingham. She didn't like the housekeeper there. She wanted him to fire her. Michelle's her name. And ultimately, she got into an altercation and struck Michelle. He didn't want to fire Michelle. Ultimately, Michelle did leave after being struck. It was her who pursued this in May of 1993 to May of 1994. And when Darden talked to you yesterday, he didn't mention that. And we will conclusively prove that to you so that when Dr. Walker talks to you about stalkers demonstrate obsessive behavior that concentrates on controlling the woman at all times and is inconsistent with making a new life, beginning a new relationship with a woman such as Paula Barberi, traveling away from home on business assignments. All of those things go against any idea of stalking that they would have you believe in this case. Dr. Walker will also tell you that there is a major difference between a wealthy person who gives gifts, someone who uses material possessions to gain power and control. And so the prosecution would have you believe that if Mr. Simpson gives Nicole Brown Simpson a gift, it's going to be bought and paid for. Nothing could be further from the truth. Let me give you an example of the testimony that will come out in this case. Before Mr. Simpson ever got married to his wife, he bought her a condominium in San Francisco and paid $500,000 for it and gave it to her free and clear in her name so she could have money up to $3,000 a month. He never, ever saw any of that money, wanted any of that money. There were no strings attached. This is before they got married. And later on in this discussion, I'm going to talk to you about what I call his circle of benevolence. Those who have come within the ambit and sphere of O.J. Simpson and his philanthropic largesse, what he's done for him. And there are many other things. This $500,000 condo free and clear, he then gave her some more money to buy the condo on Bundy. These are all her own separate things while they're still separated. He asked for no control. She had her own bank accounts. He gave her $4,000 a month for food at the house. And he paid all of the bills when they were together. Let me talk about this circle of benevolence while we're on it right now. It extended not just to Miss Nicole Brown Simpson, but to her family, to Mr. Lou Brown. He helped him become a Hertz licensee at the Ritz-Carlton in Laguna Beach for 7 years. The sisters, Dominique, he paid the tuition for Dominique for a couple of years at USC till she dropped out. Paid the tuition for Tanya, the other sister, I think, to San Diego State for a year or so till she dropped out. There's a cousin, Rolf Bauer, who worked for 7 years, Mr. O.J. Simpson's chicken franchise, Pioneer Chicken Franchises. The mother, Juditha, was a travel agent.
Yeah, I will say with DNA is that they have been able to prove different cases throughout time that were, they've caught serial killers years later, like they're senior citizens now because of DNA. So it can be used to solve cases that went cold. And that certainly is a factor taken into consideration in spite of other circumstances. And maybe two things to be true at once. Maybe both are true, or maybe, but certainly DNA would be a leaning factor in determining something like that. And sometimes the best people can snap or have a bad side to them, and sometimes it may not always be as it seems. So, very good discussion, chat, about this. Very good job. As I'm also just learning about this trial myself. you know, some of you have known about it longer than I've even been on this earth. So, yeah. And go to DNA. Okay, I'll go look for it, Anna. Thank you. And yeah, exactly. So yeah, DNA just certainly can be a telling factor in these things. Right, exactly. A very good point, Pussycat. Both of you, Anna and Pussycat. I like your take on this.
He gave her his business and encouraged his friends to do likewise. This man had a great relationship with his in-laws. He did wonderful things for them. Took them all on trips, paid their way, took them all out to dinner. They'd go to Hawaii and Cabo San Lucas. This is the same man that Mr. Darden was talking to you about. Mr. Darden says that she never worked. O.J. Simpson encouraged her to become a decorator. She became a decorator. He helped her get jobs from his friends. She redecorated the Rockingham house to the tune of $500,000. And he paid her. He paid his own wife a fee to decorate the house. This man that Darden was talking about, this man gives $5,000 every year to the Angel City Links, an inner city black organization. And the condition of his gift every year is it has to be anonymous, that he doesn't want to know he does that. The thing that he's perhaps proudest about are these next two things I'm going to tell you about. Number one is his mother, Eunice Simpson there. As soon as he was able, he bought her a house. She still lives in that house in San Francisco. This is a man, 47 years old, who grew up in the poor areas of San Francisco, in Potrero Hill, but he never forgot. Became rich and famous, but he didn't forget. So that to this day, he buys the uniforms for the kids at the Potrero Hill gymnasium where the kids go to work out. He still does that, even right now, even while in his jail cell. Bought his mother's house. You'll hear about those kinds of things. And the second thing he's most important, proud about, is that he had a child who drowned at a young age. That's always a tragedy, and you'll hear evidence about that. And the pronounced effect that it had upon him. And after that, he became involved in all of these kind of pediatric endeavors. And he has participated in raising hundreds of thousands of dollars for Camp Good Time, for kids who have cancer. He's very proud about that. There's testimony and evidence about that. People who know him, not people who speculate about him, will come in and testify about those things. And so, when Dr. Walker tells you that for a wealthy person to give gifts doesn't mean you're exercising any control. One of the sisters needed some money, up to $5,000, and he gave it to the sister and her boyfriend. And the condition was, don't tell Nicole. It's a lot of control, isn't it? So when you hear about theories, I'm going to tell you about the facts. So you'll hear from Dr. Walker, and you'll hear ultimately about the battery of tests. And I think you'll find that she will say that in looking at O.J. Simpson and interviewing him and looking at him at this point, she finds no evidence of antisocial personality disorder. I think you'll find that becomes very important in this case. And understand that this is no Janie come lately. This is the leading lady in America who testifies in these kind of cases where a battered woman shoots and kills her husband. So this is an area where, obviously, you get a chance to see her qualifications and her ability as she goes about this. Now, back to Mr. Darden's discussion. It tells you a number of things that I'd like to address, at least some of them, with you now. We've already covered the so-called ugly mood by showing you the photograph. We've covered the aspect of the flowers, because Mr. Simpson did get flowers, but he went out and got those flowers. We'll cover the aspect, let me talk to you about Mr. Simpson at that particular recital. I've told you how he came back to California specifically to go to that recital. That he'd come in to Paul Revere at about 5 o'clock and saw his ex-wife. He had to get his ticket and take his ticket back to the person at the door. That his daughter was 30-something on the program. You've been to those programs where your child is going to come up and she's like there's probably 100 people there, and your child is like 99th, and you have to be very interested until you get there. So this was like 30-something, and she was at the very end. But as all parents, you kind of sit there, and you're really proud of the youngsters, and you do that. As the program was going, he remembered that he didn't have any flowers. So when he first got there and he was sitting, he was 2 seats away from his ex-wife, Miss Nicole Brown Simpson. Wasn't staring at anybody. Wasn't glaring at anybody. Wasn't jealous about anything. In fact, you'll hear the conversation he had with Ron Goldman, who was still in the group. There was a group of them who ran around together in Brentwood. And O.J. Simpson was commiserating with Ron Goldman about his problems he was having. Please forgive me. Ron Fishman, excuse me. I heard those sounds. I'm sorry about that. Thank you. Ron Fishman. He's the man who took this picture here. He was talking about his problems with Cora Fishman and the group that ran around together. The testimony will be that he was saying, I'm glad to be out of it. I'm back with Paula. And was he back with Paula? Yes, he's back with Paula. The night before this trial is over, we'll have another picture, but this picture will do for now. By the way, this is Mr. Douglas is going to help us because there are some graphics and things. Hope you'll bear with us. Thank you, Mr. Douglas. Your Honor, can you just please see this picture? Would you like to see it? We'll call this, this is usually number 8. 1 and 2.
I thought we had agreed that it would be defense 1, 2, 3, 4.
I think the clerk has not changed it.
Right. But we're going to have so many, Mrs. Robertson. I thought we agreed on this. For now, we'll call it defense 2. And Mrs. Robertson will explain to me the error of my ways at lunchtime.
Okay, that's fine. You are in charge.
No, I'm not.
Oh, I see. This is in 201. And number 201 is another example of O.J. Simpson. This photograph, there'll be testimony, was taken on June 11th, on Saturday, June 11th. That is a charitable fundraiser. I think $25,000 a plate, by the way, to the benefit of Israel. And that's O.J. Simpson there. Now, that night, on Saturday, June 11th, he went with his girlfriend, Paula Barberi, who had picked him up at the airport on Friday evening, June 10th, when he came back from working in the East from New York. And they spent that time together, and they went out Saturday evening. And so this picture, again, is graphic evidence of O.J. Simpson and who he really is, it seems, to us. As I said, there is another picture of Paula Barberi with him there that we don't have yet, but that we will. Now, Mr. Darden talked a lot about Miss Simpson being weak and that he exercised all this control over her and picked her friends. The evidence will show that Miss Nicole Brown Simpson was a very strong, independent woman, very attractive, and an excellent and wonderful mother. But the one thing they never fought over or never had any arguments about were those children. That they both mutually loved those beautiful children, and that was very, very important, it seems, to both of them. That she picked and chose her own friends. That O.J. Simpson or no one else could tell her who her friends were to be. She had whatever friends she wanted. She did whatever she wanted. He tells you about 2 incidents where he alleges there's stalking. Let me tell you the facts and the true facts about those incidents, backed up with witnesses. There's a man in Los Angeles named Joe Stellini who owns a restaurant on the west side out on Pico. He's a good friend of O.J. Simpson's. They went out to dinner one night. And while out to dinner, they became aware of Miss Nicole Brown Simpson and their party. This is the time when they were separated. And they had an agreement, generally, that if one or the other came in while they were there, the person who was there first would leave or whatever. There wouldn't be any problems. The incident regarding Joe Stellini had nothing to do with Miss Nicole Brown Simpson or her party. He was out to dinner. They might frequent the same kinds of places. You'll hear from Joe Stellini, and you'll see there was not anything about any stalking. The other incident was about Mezzaluna, I believe. It was an incident where they both were at this restaurant. Mr. Simpson's party had already been seated when he came in. And again, you'll hear from these parties who would tell you that these were not any stalking incidents. That if you live in Brentwood and there are restaurants, hot restaurants in that area, and you go out to dinner a lot, you're going to run into each other. And there was no hostility, no stalking, no jealousy, no nothing. And so he tries to paint O.J. Simpson as a jealous man. Let me tell you what the evidence is going to be about that. You've heard about this incident of Keith Zlomowitz. I'm sure as a witness who's going to be called. Mr. Garden described it. Remember, he said yesterday, well, he didn't punch out Nicole and he didn't punch out Keith, or words to that effect. He certainly didn't. What happened was Mr. Simpson, in one of these incidents, had seen his ex-wife out. They went out dancing afterwards. And he stopped by our house afterwards to try to talk to her. He would go by and woo her on occasion. And the evidence will be that when they first broke up, he was advised in January of 1992 that she wanted a divorce. Between January and April of 1992, it was hard on him. Knowing somebody for 17 years, and he didn't want to lose her. He likes family. He learned that from his mother, and he's got this close-knit family. And he likes that. He loved his children. He didn't want to lose his wife. But something happened in April of 1992. As soon as he became aware that she had a boyfriend, from that point on, his interest changed, and he went on. And when he saw what he saw with Keith and Mrs. Simpson, he then went on with his life with Paula. That's when it started, in April of 1992. And so what happened was he wasn't peering in any windows. He came to the front door to try to see his wife. And he looked in, and he saw his wife making love to a gentleman on that couch. Now, according to Chris Darden, wouldn't you expect that he would just blow up, become ballistic? He went home, the evidence will be. He came back the next day to talk to Mrs. Simpson about the fact that the kids were upstairs, and what he saw them doing, he didn't think would be appropriate. One of the kids came downstairs. And so when he came back on the next day of this incident, he saw Keith, I think, sitting astride Miss Nicole Brown Simpson, giving her a massage or something in her shoulders. O.J. Simpson talked to both of them, shook Keith's hand, went on his way, and said essentially, look, I don't think you should be doing this in front of the kids or whatever. They didn't tell you that Keith Zlomowitz moved in with Nicole that summer. But O.J. Simpson was back with Paula. Didn't bother him. He knew she was there, that Keith was there. Was he stalking? Was he jealous? Was that a rage? I think not. So, again, I want you to take these facts and look at them. But there's an even more painful incident, probably, that tells you that he's not jealous. He has a very close friend, somebody who's very near and dear to him. The evidence will show who had a relationship with Nicole Brown Simpson, because she told him so when they got back together, and this gentleman told him so. And it was hurtful, but he never said a harsh word to her or this gentleman. He didn't go ballistic. He didn't do any of those things. In fact, you know what he did? He let this gentleman get married at his Rockingham house after learning this gentleman had been intimate with his wife. That's what O.J. Simpson did on that occasion. Your Honor, may I put your name?
Gentlemen, we're going to take a 10-minute recess. Love the tie. Love the suspenders. All right. Let's take a 10-minute recess, ladies and gentlemen, if you'll just step back into the jury room, and we'll resume in 10 minutes. All right, back on the record. In the Simpson matter, all parties and counsel are again present. The jury is not present. Counsel will take up at noon. Apparently, the Public Information Office has received several comments that apparently jurors are visible in the reflection off of the bailiff cubicle there. I have looked at the videotape. It does not appear apparent to me, but I only took about 30 seconds to look at it. We'll look into it at noon, but I just thought I'd let you, don't go away.
Well, I guess I could put a cloth there, but there's security concerns there, right?
No, what I'm going to do is I'm going to take hairspray so that it won't reflect, is what I'm going to do. But rather than have everybody move while I hairspray it, we'll... All right, Deputy McNair, let's have the jurors, please. And Mr. Cochran, I'll allow you to, if you want to slop over a couple of minutes there, but close to 12, you know, conclude your thought. And my guess is we're, if I had to guess, that was the introduction.
I'm sorry, it'll be this afternoon. You're worried about witnesses? We're leaving at 3:30 today, you Judge? Yeah. I'll make sure I finish before then. I will, if that's all right. I'll, you know.
All right, here are the jurors.
Thank you very much, Your Honor. Thank you very much. I wanted to try to pick up where we left off. To conclude those remarks about this friend, I think that speaks volumes about Mr. Simpson, his stability, his relationship with his ex-wife. I think the evidence will also show that in about May of 1992, Ms. Nicole Brown Simpson came over to the Rockingham house and said she'd found a boyfriend, somebody different than Keith, where the incident was April of 1992, and asked Mr. Simpson for some advice. He, of course, knew at that point that it was over and he was back with Paula and went on with his life, as I said, until such time as in 1993. She decided she wanted to get back together at that point. Now, to clear up, I want to always keep the faith with you about being as accurate as I can. The two incidents that they talked about, on the one incident involving the man Joe Stellini, that was at Mezzaluna. The other incident was a restaurant called Tryst. And in both incidents, there was no problem, no fight. In fact, in the Tryst incident, I believe it was, at the Mezzaluna incident, Mr. Simpson went home with his wife that night. So that there was not any incident where they were stalking or fighting, anything like that. There was no obsessive behavior. I hope that we put those in some kind of perspective. Mr. Darden talked in his opening statement about a 1985 incident in which some damage was done to a vehicle. And as I understand it, the testimony will be that was not any incident in 1985 because Miss Nicole Brown Simpson was pregnant, had a C-section later in that year, and they didn't have any situation like that. They did have some discussion apparently maybe in 86 or in 84. There was some damage done to her car and she was not in that car. She was not struck on that occasion. So I think you'll find an incident of not great consequence. And Mr. Darden talked about the 1993 911 tape that you've heard so much about. And I think even he conceded yesterday that in that situation, although you could hear Mr. Simpson's voice, and he was angry, Mr. Simpson never laid a hand on his wife, never called her a name. And I think the important thing about a trial is that finally you're going to get to hear all of this tape. And what you're going to hear, Mr. Darden didn't tell you this yesterday, is that there was a discussion on this 911 tape. And he alluded to the fact that Mr. Simpson couldn't get out of his mind what he'd seen back on April 1992. Well, now, first of all, most of us might have a problem getting that picture out of our mind of seeing your wife making love to someone else. But at any rate, this wasn't the reason for the argument. What had happened was, and the facts will be, that when they started trying to get back together again in '93, they had an agreement that they would take the pictures of their boyfriends and girlfriends out of the, you put them away, basically, which seemed to be a reasonable request. And there was a dispute because when Miss Brown Simpson would ever see Paula Barberi's picture, she was very upset about that. And Mr. Simpson, on this date, I believe, saw a picture of somebody that she had dated during the time they'd been separated. And he said, gee, what's fair for me would be fair for you. And they got into this conversation that went over a period of time. At some point, there was just a verbal conversation. It escalated, and tempers flared. It sometimes happens with married couples. Doesn't make it right, but sometimes it happens. He came over to her house, and he did, in fact, kick a French door. The evidence will be the door was already broken. He fixed it, but he never at any time struck his wife during this period of time. And what he was saying, at some point, she says, OJ, be quiet. What about the kids? And he says, essentially, you weren't thinking about the kids and being quiet when you were on the couch with Keith. And I think you'll hear that on the tape. So you put it in perspective, and the important point to make is that nobody was ever injured during this period of time. In fact, there is a tape recording and a transcript from some police officers who came out and talked with these parties. And in that tape, you'll get a chance to hear what Ms. Brown Simpson thought about that incident. And they also talked to OJ, who waited there for him. He agreed to fix that door. And they went on with their lives. They went on and continued during that period of time to get along. This was the time they were back together. You should note that Mr. Simpson, because of how he's conducted his life and the things he's done in his life, has been able to amass some assets. Not bad for a young man, a spindly leg youth from San Francisco, who suffered with rickets, who had trouble walking, was cared for by his mother, who grew up to become the greatest running back in the history of the National Football League. And so, because of that and his commercial endorsements and things, he's able to have several homes. He has a home in New York. And the evidence will be that in August of each year, because of his commitments with NBC, he would go and live in New York. And so he wouldn't try to control Miss Nicole Brown Simpson. I mean, she would do what she wanted to while he was here. Even during '93, he was living in New York from like August to like January, maybe after the Super Bowl or whatever, till August to January. He'd be back there at his New York house. He also had a house in Laguna Beach in Orange County. And one thing I forgot to tell you about the circle of benevolence. He assisted his wife in buying a condo in Laguna for herself, separate from his house. So when she was at Rockingham, she had 2 condos in her own name. One in Laguna, one in San Francisco that she's getting money from, and living at Rockingham. They didn't tell you about that. He also had bought some property in Cabo San Lucas where he planned to build. All of the things that he was doing was about the family, about keeping the family together, about doing things with in-laws and with friends and with the children. So I think you'll hear evidence about the fact that he was away at great periods of time. And while I'm about that, let me tell you about the kind of schedule this man had. You won't be able to see his calendar yet, but at some point, hopefully, we will. If you went back and looked at Mr. O.J. Simpson's daily calendar from January to June of 1994, you'd find a man that in January was out of town and probably still living in New York almost every day. But he was out of New York because he was traveling. Some of you who know this is Super Bowl week. You can imagine that he was in Atlanta that week because that's what the Super Bowl was last year. That the evidence will be that this was a time that he and his wife were trying to make it, that he took some family members, the Browns from Germany, to the Super Bowl in Atlanta, paid for all of them, got them 50-yard seats, took them to all the big parties that are going on this week. He was again out of town during almost all of that particular month. If you looked at his calendar and you're able to be testimony, that in February, he spent a lot of time in Cabo San Lucas. He was in Nashville, in St. Louis, in Miami, in Miami again, involved in charitable work. Few days will you find he was even here in Los Angeles. If you looked at March, you find that he was in New York. He was doing Bryant Gumbel's charitable golf tournament in Orlando, Florida. He's back in New York again. He was all over the country doing various and sundry things. You got to the month of April, he was back in Cabo. From there, he came back to Los Angeles. Then he went to Puerto Rico. Evidence will be that some of you know, he's an actor, a would-be actor, and that he made this movie Frogman during that period of time in Puerto Rico. Again, very much out of California. And in May, with the exception of some things that he came to do for his children, and by the way, again, talking about the kind of things that he would do at Rockingham. And you'll see this place at Rockingham. On May 22nd, he had a school picnic at Rockingham. We had a number of kids, and I think that's for the Sunshine Preschool. That is where his son Justin went. It was a fundraiser for this school. They have all these kids, and all the people would come to his house at Rockingham to raise money for the school. On May 22nd, he did that. And Nicole Brown Simpson was there. And even though they had agreed in May, earlier that month in May, and he was now back with Paula, when Nicole Brown Simpson got sick the week of May 15, 1994, she had pneumonia. O.J. Simpson was the one who took her soup, who tried to nurse her back, to get her back on her feet, even though they agreed they weren't going to be together anymore. You heard testimony with regard to that. And he continued, of course, being in and out of town. In June of 1994, he'd had taken his two children, Sydney and Justin. And let me say something at this point. Mr. Simpson has two other children that he's equally proud of. The minors cannot be here, obviously, for obvious reasons. But he has two other children that he's equally proud of, and they're here in court today. And there's Arnell Simpson over there and Jason Simpson, sitting between his two sisters, Carmelita Duro and Miss Shirley Baker, and the balance of the family. And you've met Miss Eunice Simpson already. So he, on May 5th, attended a pediatric AIDS affair. Again, his interest in children and AIDS and charitable work, along with Paula. And he took the two younger children. It was a real fine day. And that was on that Sunday. On that Tuesday, he left to go to Washington, D.C. again. He left town. He had to work. On Wednesday, he was working for Hertz in Washington, D.C. On Thursday, he's in Connecticut, working again at one of his board meetings. He's on these various boards, some charitable, some profitable, hopefully. He was in Connecticut. On Friday and Thursday night, he was in New York with his friend Bender. And he'd work, and he'd try to play golf during these periods of time. You recall I mentioned that Mr. Bender had suggested, you're going to be in Chicago on Tuesday or Monday night, stay over. He came home for the recital. And when you see his calendar, you'll see it's planned all the way out, far beyond June, of course, of 1994. But it gives you a sense of this man, this man's life, what he'd been able to do with his life and with himself. I point out these things to you because I think as you look at all of the incidents that Mr. Darden talked about, it puts them into perspective. This is not a case about domestic abuse. It's a murder case. It's a murder case about who did these horrible crimes. That's going to be your decision. Not to think that O.J. Simpson is a bad guy or a good guy, for that matter, but to get a picture of him. And I think that you'll agree with me that after you hear the facts, you'll have a clearer picture. Now, about we talked about the 1993 incident, I think we did. And I think those are the main incidents that Mr. Darden talked about. One thing I wanted to point out to you is that there will be, I believe, testimony that as these parties got a divorce, as so often happens, Ms. Nicole Brown Simpson had her deposition taken. And she made a statement in that deposition with regard to whether or not he'd ever physically struck her after the '89 incident. And it'll be interesting to hear what that is. That this Mark Furman becomes even more relevant in this case as we go along and discuss it, because he was the officer who had supposedly responded, he says, in '85. There's other evidence that the incident involving the bat and the Mercedes was not in '85 because she was pregnant. But he writes a report 4 years later, in '89, saying he had an indelible impression of Mr. O.J. Simpson in coming to that location. An indelible impression. So we'll have to pursue what that means in this report that he wrote about that incident some 4 years later, and whether or not it was accurate. It was not done contemporaneously with the incident. Mr. Darden also said to us that this was not a tabloid prosecution. Well, that's interesting, isn't it? He used those words, didn't he? He said, first of all, this wasn't character assassination, which we now know it was. And he says it's not a tabloid prosecution. Well, I think the evidence will be that after this book that you've heard about from this so-called friend, Faye Resnick, came out, that's when the people started getting all these witnesses who wanted to come forward, talk about these incidents. So whether or not it's a tabloid prosecution is not for me to say. It's going to be for you to say. Let me say this about Faye Resnick.
Counsel, I'm sorry to interrupt, Mr.
Okay. Go ahead,
Your Honor, once again, my objection has been previously noted.
I caution you, Mr. Carpenter, about what you're just about to launch into, because that person's not on the witness list. And when you say, let me tell you about somebody, I'm concerned.
Right. You're right. There's a possibility that...
Right. Well, I think we should hear these objections at the sidebar.
Okay.
However,
I tell you, let's do it without the report. I think we can resolve it.
Please.
I talked just briefly about this witness, Faye Resnick. And you may or may not hear from her. She's on our witness list. There's a possibility. We may call her for a number of reasons, because...
Object, Your Honor. There's only a possibility.
Counsel overruled.
The reason why I think the evidence will show and will be relevant to you is that on or about June 3rd of 1994, Faye Resnick, who had had a long-time relationship with a Dr. Christian Reichart, whom we will definitely be calling, they'd been living together for a long time. And because of her drug usage, because of the fact she was freebasing cocaine, he put her out, literally. They broke up. She was one of these parties who they ran in this circle out there in Brentwood. And when she was put out on June 3rd, which I think was a Friday, she then moved over and lived with Nicole Brown Simpson, because they were friends. They would go out at night. These were all friends. The evidence will be these ladies would go out 2, 3, 4 nights a week and stay out till 5 o'clock in the morning. Nobody was controlling these women. There's a group of them, and you'll hear about it. They go out dancing, they do whatever they would do, and we know Faye Resnick was using drugs in this period of time. It got so bad, the evidence will be that on June 8th, 1994, they had what we call an intervention, that Nicole and Kristen Reichart and her former husband, Paul Resnick, all got together to try and convince her that she had to go into a drug treatment facility called Exodus. And on the 8th of June...
Excuse me, counsel. I'm sorry once again. Your Honor, you had asked us or given us leave to address these issues.
Overruled. Please be seated.
Noon hour.
Please be seated.
Very well.
Thank you.
Goes into a drug treatment facility on June 8th, and she remains there, and she's there on June 12th. And I think you hear from the evidence that she is one of the people who calls Miss Nicole Brown Simpson on the night of June 12th, perhaps after 9 o'clock, that particular night, from this drug treatment facility. We'll be talking about that and her role in this whole drama. To conclude, then, what I've tried to do in this opening statement is to lay out for you the fact that in almost everything you hear in this case, there are two sides. That as jurors, I'm sure you're not going to rush to judgment. That this should not be a case about character assassination, and I hope you will keep an open mind until you hear all of the evidence as it relates to who Mr. Simpson is. Now, shifting our attention now to the discussion, the very able discussion of of Ms. Marsha Clark yesterday. It seemed to me, as you summarized what she had to say to you, that her argument broke down, or, well, it was argument at the end, but her opening statement broke down into a discussion of timeline and so-called evidence trails. Let me first of all talk to you about the concept of a timeline. We've talked a little bit about that. And let me tell you what she didn't tell you about. And some of this we'll cover, so I won't be redundant. But there are witnesses like the lady who lived next door to Mr. Simpson. There's a Mr. Tom Lang that she knows about and didn't tell you about, who on this particular night, June 12th, 1994, was walking his dog on a street called Dorothy Street, right down the way from Mr. Cole Brown Simpson's condo at 875. That from his vantage point, just a short distance on the corner, he looked up and he saw a lady that he believes was Miss Nicole Brown Simpson, either embracing someone at a vehicle at the curb, and behind Miss Simpson, he saw a man that he described as a Hispanic or Caucasian, standing with his hands clenched, standing there looking as though he was angry. And he didn't know why this man was looking like this. And this is about 10 o'clock on June 12th. Whether he was angry because Mr. Lang didn't know whether he was angry because his dog was loose or what. But again, this is what I expect his testimony to be. This is at 10 o'clock. And he sees a lady that he believes is Nicole Brown Simpson at that point. I talked to you briefly before about Ellen Aronson and Dan Mandel, who she didn't talk to, but she's talked to him, but she didn't talk about them yesterday, as they walk past this place, right at about 10:25 or thereabouts. Then there's another witness, whose name is Robert Heidstra. And Robert Heidstra is in an alley one street over. But when you go out there, you'll be able to see how well you can hear late at night, especially on a Sunday night at this location. Mr. Heidstra, according to his statements, is walking in this alley. And now it's about 10:35 or 10:40. As he walks parallel to where the Bundy residence is, will be then looking west, he hears the sound of like arguing, and he hears someone or a voice say, "Hey, hey, hey," and he hears the sound of a fence closing, and he continues on walking his dog. Now this is at 10:40 or thereabouts, and you know then at 10:45, Mary Ann Gertrude sees these four men running from 875 down toward her direction, and she believes they're coming after her at that point. In her statement to you yesterday, Ms. Clark talked to you a lot about Alan Park, and I read you some of his transcripts, some of his testimony that you didn't hear about. And I think there'll be considerably more with regard to Mr. Park and to Mr. Cato Kalin. An interesting man, and I think that it'll be interesting when you hear from Mr. Cato Kalin about Mr. Simpson and how he appeared that night. Just before we wrap up for lunch, I think the evidence will show you that in order to believe that O.J. Simpson committed these horrible murders, you'd have to believe that he came back from back east where he'd been working to come to his daughter's recital, attended that recital. You see his picture there. He was home getting ready for a trip to Chicago that had been long pre-planned, that he was hungry. And the evidence will be that he didn't have any dollar bills or $20 bills, that he asked to borrow some money from Cato Kalin. Cato Kalin gave him this money. He went and had a Big Mac. You'd have to believe that he was planning to kill his wife either before he got this Big Mac or then went and got the Big Mac, that Cato Kalin will describe. He was dressed in some kind of a sweat clothes and some tennis shoes. That if you follow the people's case, you'd have to believe that he then came home and said, gee, I think what I'll do is I'll go over and kill my wife now, and I think I'll take these tennis shoes off and put on some dress shoes, some hard-soled shoes, and change clothes, knowing he's going to be leaving shortly to go to the airport. And then you'd have to believe that, to believe their theory. And then to make their theory work, they spend all this time talking about the plaintive wail of a dog, because they've got to make this as early as possible at 10:15. We know that that's not correct, based upon the facts that you've heard. And to conclude, isn't it interesting that in all of the discussion yesterday by these two very excellent lawyers, they never once mentioned their coroner, Dr. Golden. He's another mysterious mystery witness they don't want to talk about. And when we come back this afternoon, let's talk about why the prosecution doesn't want you to know about Dr. Golden. Let's talk about when Ms. Clark says, well, you can't really fix the time of death here with any precision. We will have testimony from one of the leading pathologists in the United States, Michael Batten, who's also worked for the LA County District Attorney's Office, who's written a book about the John Belushi death. He was able to pinpoint the time of death to within 1 hour. And yet in this case, because the coroner was not called for 10 hours after these bodies were found, or 8 hours, and they got out there about 10 hours, violating the state law, we are precluded from pinpointing this. And they have to tell you that it's about a dog's wail, when a man's life is at stake. We'll pick up after lunch, Your Honor.
Thank you, Mr. Cochran.
Okay, so, no, it's an okay question to ask because Mary Toodles, say, Moki's very into trials, and she told me about her perspective on OJ. So, in this situation, Mary Toodles could have mentioned it to me if she watched it. Yeah, I wasn't there to know, of course, yes, but she could have mentioned it to me later. Yeah, I think she followed the trial. I don't... But I will ask her again because I want to know more details. But yeah, she followed this. She knew about OJ, definitely. By the way, Mary Toodles didn't really know I was streaming. Today, she was kind of shocked I was going so early. But yeah, last night she was there when we were talking about the OJ trial, but she was just kind of in her own world, so to speak. Yeah, but as I said, Melissa Cat, you're fine. It's a good points, everybody. Yeah, I will say I appreciate the civilized discussion we've been having about this trial today. All right, so in this circumstance, yeah, there'd be more scenes to show. Yeah. Because this is before they had the trial the way we watch it on the YouTubes. Yeah. Okay, so this dude's almost done. I'll show the DNA testimony after this. Anna said it's basically puts the nail in the coffin over it. All right. You're welcome, chat.
All right, ladies and gentlemen, we will stand in recess for the jury until 1:30. Let me speak to counsel after the jury has departed. All right, let's clear the courtroom, please.
I thought Mr. Cochran was hiding from me, and perhaps Willie should. Okay, no, I see you, Mr. Cochran. And, Your Honor, let me say this. I was about to say, you asked me to examine the record for...
Well, wait a minute. So CTV was on regular cable one time. Look, I know CTV's on cable and satellite. I know that because I've seen it on television before. I didn't know it existed all the way back then. Wow. Okay, thank you, Moki, for the info.
Instances of inappropriate remarks for an opening statement. I want to make the people's position absolutely clear this afternoon with regard to when objections are likely to be opposed, because I want to give Mr. Cochran fair notice. What we heard in large part this morning
was not an opening statement, but could very well pass for argument. And if given an argument, would not be objectionable. But this morning, and as I stated to the court, I am reluctant in any case to interfere with opposing counsel's opening statement. It was with great restraint this morning that I did object to a number of clearly objectionable remarks made by Mr. Cochran. I will highlight those just in just a few moments. However, Your Honor, what the people are seeking this afternoon is, first of all, an admonition to Mr. Cochran not to engage in argument in the guise of an opening statement. Secondly, with regard to various passages, which I will highlight and pinpoint for the court in just a moment, I'm going to be asking for a motion to strike, and in addition, an admonition to the jury to disregard such statements, because not only are they not evidence, but they are improper remarks for an opening statement, and the jury should be so advised. In addition, Your Honor, after I address the opening statement issue, I have an additional issue to raise with regard to discovery, because it appears we are about to revisit the events of Monday to some degree. I will begin, Your Honor, by stating generally many of Mr. Cochran's remarks were in the form of a rhetorical question. Many of his remarks were in the form of a personal attack on my colleagues, Ms. Clark and Mr. Darden. Such remarks are not fitting nor are they appropriate in an opening statement. Absolutely 100% not fitting, not appropriate. Let me give you just a few examples, and I have to cite to the reference that we were given off the disc that the court reporters were able to provide us. For instance, and I cite to what appears...
Yeah, I guess for y'all, it was like the Johnny Depp trial in my time so far has been the biggest one I've seen. So with especially like a celebrity case, and also YSL to an extent. But so I guess this trial was like that for y'all in that time period. It was, it was worldwide, but see, that's before the social media. So okay. I'll say like a historical studies is that it's so fascinating to see how these different generations did these trials and how they communicated. Now it's like you got your phone and just talk to everybody spontaneously. So yeah, as I made a comment before about the computers being so big and clanky looking. So I mean, it's no problem, but it's just back how it's how it was back then. So yeah, very intriguing how it was worldwide.
The 0553 of this morning's.
Moki said, "Well, no one died in Depp." Yes, and that is true, and that is good that no one died in Depp. But what I'm saying is that the popularity of the trial itself, like the Depp trial was of course no one was murdered, thankfully, but it was like very well known and popular around the world. And this trial was popular, well known around the world, and it was a celebrity case. But yeah, I'm not comparing apples to oranges here, of course. Yeah, no one was murdered, and it was also a defamation trial. It wasn't nowhere near as serious as this trial, of course. Absolutely, Moki. Very, very true. And we survived with TV a long time, believe it or not. Yeah. Yeah. It's hard to imagine in this day and age, but yeah, they survived with TV. Yeah, so it definitely was viral. Indeed. All right.
Transcript where the defense argues that this case is about a rush to judgment and obsession to win at any cost by any means necessary. Your Honor, such a remark is fitting for argument, perhaps, not fitting for an opening statement. Clearly, that is outside the bounds. And again, Your Honor,
Mr. Hodgman, how does that compare to Mr. Darden's argument that the issue is that you have to establish the relationship and that the person who is guilty of this crime is a wife beater, batterer, controller, blah, blah, blah? Sounds like the same argument to me.
Well, does the court intend to make an equity call? I'm simply posing to the court
No,
things that I found to be objectionable.
Mr. Hodgman, here's the problem. Each side has to present what their theory of the case is. That involves some type of short explanation as to what that argument is going to be, and here's the evidence that's going to back up our theory of the case. That's opening statement.
And I understand that, Your Honor, and you stated a short.
Yes.
And I would submit to the court that based on what we heard this morning, that line got crossed very, very early on.
Right.
I will continue.
Mr. Hodgman, let me do this. And please forgive me for interrupting you again, but we did discuss this also informally. My suggestion is that we do this. Because we have to break early for one of the jurors' medical appointments this afternoon, well, let me let you put these matters on the record when we conclude. Let me just caution at this time, Mr. Cochran, because I did mention to him that I felt that we were about to cross over the line into argument. You can tell him what the theory is. Mr. Hodgman, they are entitled to say that the prosecution has indicated this is their theory of the case and how they're going to proceed. And he's entitled to say this is what we're going to present to counter that. And he gets to explain how they get to do that. Now, I agree with you that evaluating it and saying that your case is trash for this reason or that reason, that gets into argument. I agree.
Okay. And
all right. I will be more. My feeling was that the defense gave both Mr. Darden and Ms. Clark wide leeway in arguing and presenting their opening statements. All right.
But what the defense didn't do yesterday, Your Honor, was engage in rhetorical attacks upon opposing counsel, such as, why didn't Mr. Darden tell you about this yesterday? Why didn't Ms. Clark state something else yesterday?
I agree.
I agree. Argumentative and...
I agree.
Okay.
So what can be said is that the prosecution did not give you a complete picture. We're going to add this piece, and this piece for a clear picture. I think Mr. Cochran can phrase it that simply without referring to what the prosecution said.
Okay. We have additional language, and I raise this now, Your Honor. I will detail these objections more clearly at the time suggested by the court. But time and time again, Mr. Cochran stated this morning, and you would have to believe, and you would have to believe, and then you would have to believe time and time again, which again, Your Honor, this goes to argument, not to opening statement. Opening statement is supposed to be a recitation of the evidence that they expect to produce. And what you have clearly is argument. This is entirely inappropriate language, Your Honor.
Counsel, I've chosen to caution Mr. Cochran. I can tell by his response to me, he takes my caution seriously. Although I'm beginning to feel like the Rodney Dangerfield of judges these days. In fact, I'll have to call Barry Langberg later today. Mr. Cochran, you will take seriously my caution. All right. Okay. I just want to get the ball rolling today because we have a short court day.
And, Your Honor, and I agree with you, and the only reason I raise this now is so that we can have appropriate opening statement this afternoon. Reference to hearsay, I lodged my objection this morning. I trust that the court and counsel understand the basis for that. I would point out as well that based upon the record produced thus far in this case, that reference to Mark Furman by name should not have been made. Based upon, no, I am referring to page 11479 of the record. This is Monday, January 23rd. The court states, I am precluding the defense from making mention of Detective Furman during the course of their opening statement solely on the basis of the fact of the late turning over of other statements of Kathleen Bell today. I thought that was pretty clear, Your Honor.
What happened later in the record, there was a request for clarification. I indicated that they could not mention Detective Furman in the context of Kathleen Bell. They could mention his participation in the investigation, however, not in the and they could not, in opening statement, mention the Kathleen Bell aspect. There was a later clarification in the record.
Very well, Your Honor. We'll stand by that clarification. Then the last point I'll raise, and I will raise this in greater detail this afternoon. I know the court wants to move along, and that is the discovery issue. I can point out two names in particular this morning that were mentioned in the defense opening statement. Marianne Gerches and Joe Stellini. These are names which are on the defense witness list, but the way Mr. Cochran referred to these witnesses this morning, it was evident that these witnesses have been interviewed, that there have to be statements outstanding someplace. Now, we have gone through this over the past couple days. The defense is supposed to disgorge witness statements to the people. And, Your Honor,
I have in my notes that these are items as well that I was concerned about. So
and I share the court's concern, Your Honor. I share the court's concern for this reason, because as we have stated throughout these proceedings, going back to late June and early July in municipal court and
Mr.
superior
Hodgson,
court.
Please forgive me. I recognize it as a discovery issue. We'll take it up as soon as we get the jurors on their way at 3:30. Then we'll have a full hour that we can sit and talk about this. I am concerned, and I do recognize it as a discovery issue, and I'm going to make further inquiry.
Very well, Your Honor. What I'm concerned about is the prospective aspect this afternoon when Mr. Cochran speaks. What else are we going to hear about? The people are being denied the right to a fair trial, Your Honor. That is what's occurring. This is surprise. The court sees the issue. The court sees and senses our concern. It is happening in opening statement, and the people have not received reciprocal discovery. I think that is evident to the court. The people are not getting their fair shot, Your Honor.
All right, let's have the jurors, please.
Your Honor, may I send the witnesses home?
Mr. Cochran?
I think that's probably a good idea. If you're cutting our time, I'll speed up now. We have taken 10 minutes of Mr. Cochran's time.
All right.
What time would you like them back tomorrow?
9 o'clock. All right, let the record reflect that we've been rejoined by all members of our jury. Be seated, ladies and gentlemen. Thank you. All right, ladies and gentlemen, at this time we will resume with Mr. Cochran's opening statement. Please remember that the opening statements by the attorneys are not evidence. Mr. Cochran.
Thank you very kindly, Your Honor. Good afternoon, ladies and gentlemen. When we broke this morning, we had just gotten to the point of discussing the coroner who previously testified in this matter, Dr. Golden, and I think I alluded to the fact that in the course of the opening statement yesterday, we didn't hear his name. And we expect that he will, in fact, be called in this case. Either if the people don't call him, then we will. And I think that you will hear evidence to the effect that you can, in fact, determine the time of death with greater precision than you heard yesterday. That if one is qualified, one can look at the state of rigor mortis, the state of lividity of the body, state of the temperature of the body, and also the ambient temperature, use things like the stomach contents. In this case, there was a major problem. Dr. Golden's testimony is that he would place the time of death between 9 and 12 o'clock. Now, between 9 and 12 o'clock, you now have heard enough of the evidence to understand that at 12 o'clock, Mr. Simpson was in the air, and at 9 o'clock, there'll be testimonies you've heard as to where he was at his house. So we have a problem with regard to trying to fix the time of death. And you heard the prosecution's theory yesterday about the time of death being about 10:15. You've heard from me this morning that the defense advances the theory that that's clearly wrong, the witnesses that you've heard. Now, with regard to Dr. Baden, who is our expert, and I should tell you a little bit about him, Dr. Michael Baden is a former forensic pathologist, the chief medical examiner for the city of New York. He resides Now, with regard to Dr. Baden, who is our expert, and I should tell you a little bit about him, Dr. Michael Baden is a former forensic pathologist, the chief medical examiner for the city of New York. He resides in New York. As I said, he has worked for the LA County District Attorney's Office in the past. He's considered one of the foremost forensic pathologists in America. He came to, the evidence will be, he came to Los Angeles shortly after Mr. Simpson's return from Chicago, and in fact went to the LA County Coroner's Office that week, the week of June 13th. And it was after Dr. Michael Baden's conferences with Dr. Golden and his superior, along with Dr. Baden's colleague, Dr. Barbara Wolf, that the coroner's office wrote a letter to Mr. Hodgman with an amendment to the coroner's report they'd filed. And I'd like at this time to turn our attention to the graphics. This is a letter that is directed to our colleague, Mr. William Hodgman. You'll see Mr. Hodgman there. And we'll proceed on.
D88. D88.
It'll become clearer.
Your Honor, excuse me. May we have? I have an objection to interpose. I wish to approach at sidebar, and I would like this image stricken from the stream.
All right, now we're going to do the next part, which we're going to talk about. We're going to show the DNA evidence that was suggested by Anna.
Organism from the point of conception, that is, from the point when an egg and a sperm come together, the DNA in the egg and the DNA in the sperm now makes up the total DNA for that organism, and the information in that DNA programs the development of that organism all the way through childhood, if it was a human, adulthood, and on through aging until that human being isn't alive anymore.
What is DNA itself? How would you describe it?
DNA is
Exactly, Moki. A lot of times that's the case where they have like a special privilege over other people. And there's also lots of drugs involved. It's they did lots of allegedly they seem to have done a lot of coke. There is other reasons for them to be arrested, but yeah, probably the celebrity status helped out. You know, it seems like there's unfair injustice in the way of it was handled. Yeah. At the same time, of course, I'm still learning about all this. I'm not as familiar with it, but from what I can gather, that is a problem that I believe goes on today with sometimes with celebrities, where they just have a special privilege of sometimes to get away. Yeah. Yeah, she seems she seems so far calm, good at talking about the topic. Right.
It's correctly described as a polymer. That is, it's a long series of components that are all attached together. And it's basically our cellular alphabet.
What role does DNA have in creating our bodies?
All of the information that predicts our structure, our height, our build, our skin color, our organs. You have a liver. That information on how that liver is going to be formed as the organism developed is contained in the DNA. And the DNA does that by containing the information that's eventually translated into proteins, and those proteins do the major part of the work in the cell. And so basically the DNA contains all information to make a specific organism.
Sometimes the term genetic blueprint has been attached to DNA.
And it's a good description.
Where is DNA actually found in our bodies?
It's found in the nucleus of each cell.
Is this entire molecule the same in every cell of our bodies?
Yes.
Can you describe, please, what are the various sources of DNA? In other words, various parts of the body that DNA can be taken from?
Well, DNA can be taken from almost any source. You can get DNA from bone, from any tissue, liver, spleen, pancreas, kidney, brain, skin. If you have a enough blood, semen, hair roots.
Dr. Cotton went on with her crash course in DNA, explaining its importance in the process of human identification and criminal investigations.
All of that DNA information that creates those things that we have in common will be basically the same from one person to the next. There is then a small portion of the DNA that is different from person to person. And that's intuitively obvious because you can look around even in a very large room or many people, and you'll see that with the exception of identical twins, people are different, even closely related people. Two brothers are different. You can always tell them apart.
With regard to, then, these portions of DNA where we differ, and I believe you said that's something less than 1% where we differ from one another?
That's right.
Why is that of interest? Why do you as a scientist care about that region or those regions where we're different?
In order to distinguish people, especially at the DNA level, you want to be looking at those sections of the DNA that are different from one person to the next. So you have to single out those sections, and for purposes of identifying or telling apart individuals, then you want to look at those sections of the DNA that are not the same from one person to the next.
Do not conduct any deliberation.
The day finished early because of the funeral of a well-known LA detective unconnected to the case. Some in court wanted to attend. The first time DNA was ever used in a criminal case was in England in 1986.
Okay, this is more like a documentary, but I'm trying to get the scene of her talking. So I am going to, as I said, we're going to play some of this, but I'm going to find something else that I want to, another version of this I want to play. All right, let's see. Let's put her right there. That's where she is.
Information. That is, you can discriminate one person from the next with a high level of discrimination. On the other hand, the PCR, the tests that are currently available, doesn't have that level of discrimination. It is a much lower level of discrimination, sort of in the range or maybe somewhat better than a whole series of serological markers. However, the PCR can use DNA when you have a very small amount, or it's in very poor condition, or both.
So in other words,
Many of the blood samples underwent the PCR test. It is less reliable, and the defense is expected to concentrate heavily on the validity of these results. Clark then asked whether blood degraded by heat and humidity could give a
Oh no, I have the entire trial to play, definitely. We could go to that, but yeah, that was the DNA lady, and we'll see her in the trial while I have the whole entire trial in order. We will play it. We will come across the entire part that she has at some point. Yes, and I was playing day one earlier. Then I went to the opening statement, so we'll go to day one. Let's go there. All right, and thank you, Anna, and we'll see more of it as time persists. All right, this is the rest of day one.
Over and over and over again.
I'm only asking leave to see the chart as it currently exists. I have not seen the final hard copy. All we saw was a rendering on an 8 by 10 piece of paper. I would like to see what the final chart says.
Mr. Douglas, do we have that available?
We're looking around.
I have, sure. You know, the chart is being mounted right now and will be picked up this morning. But it just mirrors this particular chart.
Yeah. No, I played the scene I want to play, and there wasn't like a clip of her testimony in full. It was part of a documentary. So that's why we'll play a trial like this, and eventually we'll come across her testimony. Alright. And we did see her for a moment. But yeah, we will, as I said, this is the entire trial in order, and I'll skip over the part where the opening statements, because we watched that already, if we come across it again. So yeah, this is January 24th, 1995, part 1. Oh, you were 23, Moki? Nice. Nice.
Does the court have a copy of this?
No.
Do you have an extra copy?
No, that's the only one.
All right, would you hand that to Mrs. Robertson, please?
I want to address the court on certain aspects of this chart.
Yeah, we could put it up on the envelope.
Well, that'd be great. Let me first indicate, with respect to the first entry...
Hold on, I can't see the entire chart.
You can't either, okay.
No.
That's good.
All right. Wait, focus that a little.
With respect to the first entry, Mark Furman and the gloves, it indicates plural. At no time did Mark Furman so testify, and the chart is misleading with respect to that language. The people object to the use of the plural. That never occurred. Secondly, Van Adder warrant. The search warrant and the circumstances of the search are irrelevant to the trial before the trier of fact. That is a legal issue that the court rules upon that is improper to raise in opening statement, let alone in trial. I would further mention to the court, I thought the court ruled that Mark Furman could not be mentioned in opening statement.
That's correct.
And the people object on that basis as well.
Make a question, Your Honor.
Furthermore, the Ron Phillips statement to the coroner, we're kind of not following procedure, but we're kind of asking a favor. A statement lifted out of context that is hearsay from a transcript that was issued by the coroner, not a statement made, not a report made by Ron Phillips, and is misleading and confusing on that basis.
All right. All right, Mrs. Clark, before you get too much further, counsel, this is an argument. This is not an opening statement exhibit.
Yes.
Hold on a second. This is something I'm not used to seeing. I'm not used to seeing the Asian with a beard. I'm not. This is being like a. I'm having like a silly moment. It's like I'm usually not used to seeing them with a beard. And I don't really know of many judges with beards anyway. Glanville kind of had a beard. I'm not saying it doesn't exist. But yeah, this is something that something I don't see every day. All right. And also shout out to you, Regina, by the way. Welcome.
Good morning, Your Honor.
Good morning, Counsel.
Your Honor, in this matter, it was my understanding yesterday that the people had an opportunity to look at everything. We did show this to them. And Ms. Clark indicated she had no objection. We don't want to be argumentative. This was passed, we thought, out of an abundance of precaution, if the court pleases, because we anticipated that she might change her mind. We have another chart, which I think the court will find hopefully less argumentative. I'd like for the court to take a look at it. I think this is what this is basically is a summary of the conduct. And I wanted one other query of the court with regard to Mr. Furman. The court did not say we could not talk about Mark Furman. I understand in opening statement what you indicated was that with regard to the Kathleen Bell incident, I think you said, but you never said we couldn't talk about Mark Furman. Is that my understanding?
That's correct.
Okay, I want to make sure that was clear. May I show this to Mr. Hodgman and then give Your Honor a copy of this, what we proposed? Thank you.
Is this a change to this document?
Yeah, it's a change to this document. You want to put it up there? Should we put it up for you? Let's put
Please.
it up. You got one? Okay, what's up now? With regard to these items, the court will recall that as part of the exhibits, we will have a video clip of Detective Furman. If Ms. Clark objects to the use of the words gloves, I will stipulate to strike or make it glove, but we still are going to play that clip. With regard to Detective Phillips, we actually have a transcript. We passed this yesterday. That's already coming in. We don't want to take any out of context. People will be able to see exactly the transcript, so nothing's taken out of context. With regards to Detective Van Adder, where the statement is made that Simpson had left on an unexpected flight to Chicago, what we're talking about is not relitigating the issue, the court pleases, of the entry, but to indicate that in the very first contact with the criminal justice system at 10:45 on 6/12, an untruth was told. But in that warrant, under oath, they did not tell the truth. And we have that, and you saw yesterday Cato Kalin's statement. Your Honor, with regard to securing, documenting, and preserving the crime scene, everybody has been very much aware of that the trainee, Mazzola, was her third crime scene, was basically the officer in charge there. With regard to the Bronco, we've litigated this. Counsel has known for some time. We've made it in as innocuous language as we can that they failed to give that special care for evidence presentation. We showed all this yesterday, Your Honor. They went through it. They had no objection. The DNA testing, we've said consistently. They can talk all they want about DNA, but all the DNA evidence passed through the LAPD before it went to any other lab, and we think it's our right to talk about that. We have a chart that we've already passed on of the O.J.'s blood vial, and this mysterious blood vial and its saga, where it went, instead of being booked appropriately. And then finally, the question of the socks, whether or not there was none obvious in the socks. I disagree with my learned adversary that blood is red, albeit dark red. It's not black, like socks, and you would be able, I suggest, to see it. And I think the question is, if the prosecution thinks that they have a theory, and if we don't agree with that theory, they think they're always right. That's what a trial is about. That's why we're here, Judge. They're not always right. That's why they lose cases sometimes. And so they're not always right. The jury will make that determination. And this idea of protecting this jury, that's what you're going to do. We're not, you told us yesterday about doing our jobs. And that's when the system works best, Your Honor, as you well know. You do your job, we do our job, they do their job. We don't need Ms. Clark to do the job for the jury. They'll do their job, and you'll do your job. And I promise we'll do our job, Judge, and that's what you ask us to do. That's all we're trying to do here. This is a man that we have contended from the very beginning is wrongfully accused. And they are in for the fight of their lives. And so this is not any game, and so we're very serious about this. We don't want to be argumentative, and we want to just spell out. And we looked at this last night, even though she passed on this, we think we spelled this out, and I think it addresses all of the the concerns, Your Honor. And I think that certainly in opening statement, one can't be precluded about what our theory of the case is in good faith. And so what we're doing now is much more than usual, Judge. They're having a total preview of the things we expect to use.
All right, let's see the videotape as well.
Thank you.
Let me see everything that I have to consider, and then I'll rule.
I haven't addressed the new chart, though, that they just put up.
I'd like to see the videotape. Thank you. Does this contain any,
No, Your Honor, this pretty much starts where the other one left off yesterday. The bodies have been removed, but the coroner is still there, and Mr. Fung is putting down his tags.
Mrs. Robertson?
I think that contains all the clips that we wish to show in opening. There's a little more after this, but...
Stop the tape. All right, Ms. Clark, I'll hear your objections.
First of all, with respect to the videotape, Your Honor?
Yes.
Again, the same foundational problems we had with respect to time. We don't have the authentication in terms of the timing, and that's critical in terms of the evidence collection. The inference that the defense will seek to draw is that all of the evidence collected by LAPD was contaminated in some manner by the method, by the actions that are shown on the tape. If the evidence was already collected by the time these people are shown in the positions shown in the video, then there is in fact no impact, and the inference that they're seeking to draw is directly misleading to the jury. And that is one thing that in opening statement neither side is permitted to do. The people are not attempting to tell the defense how to try their case. The people are asking this court only to make sure that the jury is not misled, so that they get the truth, so that they understand what the evidence really is, not spin and not distortion and not half-truths or statements taken out of context, but the truth. And the problem with a video such as this one is that we have no way of knowing when it was shot, and the inference that the defense seeks to draw from it may be completely false, in which case the jury begins the case with a total misconception about the conditions under which the evidence was collected. And that is a very damaging thing, and that's why the defense, of course, seeks to do it, I understand. But it's not the appropriate thing to do. The jury deserves to get the truth and understand what the evidence really is.
All right, do you want to address the other issues, the SOC chart and the conduct chart?
Yes, the conduct chart, I think the SOC chart I have, Your Honor, I've addressed that. That is, again, totally misleading with respect to blood search. With respect to the chart, now the new one is even worse than the other. First of all, it repeats the misleading and completely false inference drawn about the blood search. They seek to argue in derogation of reality, in derogation of the truth. The truth is that it was scheduled for a blood search. What they seek to infer from this is that it was already conducted and none was obvious. And that is exactly 180 degrees opposite of the truth. So that is a complete falsehood. With respect to Mark Furman and the gloves, again, it's false. They state, they put on the plural, which was never stated by Mark Furman. They take his statement out of context. There's an extensive colloquy between himself and counsel in which he refers to one glove that he saw at the foot of Ron Goldman, and he says that repeatedly. And yet, taking one statement out of context, they seek to draw inferences from it. It's argumentative. It's not an opening statement, and it's misleading and unfair because it is taken out of context. The same would go for Ron Phillips to the coroner. Of course these are taken out of context. How could counsel argue to the contrary when you have a lengthy transcript of statements that have explanatory information both before and after? You have A and you have C, and you take out B. And that's what counsel has done, taken everything out of its proper context and stuck it on a chart. And again, it's argumentative. With respect to the Van Adder warrant, that statement is irrelevant. We're talking about language in a search warrant. That's appropriate for the court to rule on. That's not that's not appropriate for a jury to be presented. The jury has to be the trier of fact to determine whether the defendant is guilty or innocent, not whether the search was proper or improper. That is a legal argument that goes to the court, not to the jury. That statement is inappropriate and it's argumentative as well. With respect to preserving the crime scene evidence, the defense, if they are saying the trainee is Andrea Mazzola was not in charge. She was a trainee who was being supervised by Dennis Fun. So this is false. This is a false statement if that is who they are claiming was in charge of the crime scene. That is untrue and misleading. I thought that the court's ruling pertaining to Mark Furman was that neither side could mention him. That was just Kathleen Bell.
The Kathleen Bell impeachment issue.
Okay. With respect to may I have a moment, Your Honor?
Certainly.
With respect to the items failed to give special care, that's misleading as well. That's put in quotes as though it comes from a manual of some kind, which we know is not true, and it's argumentative. Yes, it's true, all evidence passed through LAPD. No objection to that. With respect to all blood not accounted for, that's argumentative. We haven't seen any evidence of that. If counsel thinks they can lay a foundation through the course of this trial, that's certainly appropriate for argument, but it's not appropriate for opening statement. And again, it's argumentative. I'm just waiting, is the court?
All right, are you finished with your comments?
Yes, Your Honor, I'm
All right,
finished.
thank you. Mr. Cochran. Counsel.
Thank you, Your Honor.
I think we need an air traffic controller for the lawyers
We
here.
do, Your Honor. We will be patient, Your Honor, at all times. Your Honor, in this regard, first of all, let me again point out, this is an opening statement, Your Honor, and whereas they have their theories, and we have not said they shouldn't have their theories. We think we have the facts, but certainly contingent upon that, we have certain interpretations of what we think the evidence is. As the court has so correctly stated, we are permitted to talk about those things. If you look at this chart, sometimes people shouldn't object if they have nothing to say. And in this instance, Your Honor, the issue, I already conceded with regard to using the word gloves. I don't want to mislead anybody. We'll take the S off. With regard to Detective Phillips, Your Honor, we have the entire transcript that we're going to have available. The court's rule, we can use that. With regard to Detective Van Adder, we're not relitigating anything. As I said, it's about credibility. And with regard to, and this is where counsel, who supposedly knows her case, should review to her own documents. I'd like the court to see this. Regarding Officer Mazzola, we have a form, 9408-17431, which says OIC name, Officer in Charge name, A. Mazzola, Assistant.
All right, so the Menendez trial was July 1993. This is January 24, 1995. What we're watching right now.
Name D. Fung. We don't make these things up. I'll be glad to have them look at that. It's their form. Now, we don't make these things up. And with regard to the field of special care, she says, this in quotes, that's from the LAPD form, Your Honor. Remember yesterday when we showed the form, we pulled that up, where they failed to check the appropriate box when the Bronco was left basically unattended for all those months. Now, she conceived the DNA testing did pass through LAPD. Yes, it does, Your Honor. With regard to the blood vial, Your Honor, again, that is our belief based upon all the documents we've been given in discovery. And, if it turns out wrong, that's what we're going to say. This is based upon the documents we've received. It's not argumentative. That's our position, Judge. And she can't tell us what our position is or what it should be. She should understand that right at the beginning. And then with regard to the socks, we'll accept whatever language Your Honor says about that. But, again, if you look at this particular form, Your Honor, this form is entitled O.J. Simpson, Summary of Analyzed Evidence by Analysis Performed. We're using their own forms, Your Honor, by analysis performed. And it says under there that none obvious. And so that's all we've said. We took their own form. And so, there was a recent movie, Your Honor, where there's a line which I think is very appropriate in this case. I think it was A Few Good Men. We keep hearing about the truth. I don't think they can stand the truth. That's what Jack Nicholson said, that you don't want to hear the truth. And I think it's very appropriate in this situation. That's exactly what's happening here. There's one other thing I'd like to point out.
Wasn't he the bad guy? Wasn't he the bad guy?
Yeah, but bad guys say something worthwhile sometimes, Your Honor. So even bad guys tell the truth on occasion, Your Honor. Certainly we aren't the bad guys in this case, Your Honor. Your Honor, with regard to one other thing you'd ask us to do at the end of the day, and I believe this is on page 25 of Volume 2, Volume 11 of the reporter's transcript of proceedings from Thursday, July 7, 1994. I'd ask leave of court to read this. It's Mr. Shapiro question. You did not measure the amount. Answer, well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe and looked at about 8 cc's. You'd ask us to find that for you, and I'll give this to the clerk. But all we're asking to do, Your Honor, is to stop all of this haggling, and let's start with the opening statements. And we previewed everything, and I think it's time to resolve it.
All right. Thank you, counsel. All right. The objection to the use of the videotape is sustained. The argument has been that the concession has been that these are snippets, and that the defense is willing to take the risk in argument that they cannot lay an accurate foundation. The problem is that leads to the danger of misleading the jury, and I'm not willing to take that risk during the course of an opening statement, so that objection is sustained. As to the SOC chart, the language that is on the SOC chart comes from a summary of reports and testing. It is not the report itself. The objection is sustained as to the language, blood search, none obvious. In all other respects, the SOC timeline chart may be used. As to the conduct chart, the objection is sustained. These quotes, some of these quotes are taken out of context, and there's a danger of misleading the jury as a result, so that objection is sustained. All right, counsel, I think that, I did not rule yesterday on the, Mrs. Robertson reminded me, I did not rule on the photograph of the defendant and 4 ladies in formal dress.
My notes say that the court did rule, Your Honor, that
I noted I didn't check it off on my list, and Mrs. Robertson indicated I didn't rule. So the objection on that, as to that, is overruled. So the record's complete. All right, counsel, that takes care of that. Let me just advise counsel, tomorrow one of our sequestered jurors has a medical appointment, and we will adjourn tomorrow at 3:30. 3:30 to accommodate that. And I would also like to talk to counsel at some point in time regarding your proposal regarding a scene view when you get the opportunity. All right, anything else before we invite the jurors to join us?
Your Honor, maybe
And the new chart will be people's next in order, photocopy of that for the record purpose. All right, Mr. Hodgman.
Thank you and good morning, Your Honor. Your Honor, first of all, there's a matter that we will need to approach sidebar. I think the court can handle it quickly, but it's a point of information I think all of counsel need to know before we proceed with opening statement.
All right.
Then, before we do that, Your Honor, before we do that, I'm sorry. Yesterday we raised a discovery concern with regard to the defense. This morning I've been provided with another witness statement from the defense, a memorandum from a Mr. William Pavlik dated November 2nd, 1994. I had asked the court yesterday that the court order that the defense turn over all discovery that's in their pipeline, so to speak, because we don't want to be surprised anymore. Now, I have asked Mr. Douglas this morning, is this it? Is there any other witness statement that they have, regardless of age? And I believe his response was that he could not be definitive about it. Is that correct, Mr. Douglas? No. All right, I'll let him speak for himself. But what I would like the court to do is to remind the defense of their obligation to turn over to us witness statements, timely fashion. We're asking that everything be disgorged, as I did yesterday. And I would like to have that order made clear for the defense.
Mr. Douglas?
Your Honor, yesterday there was a specific reference made to an interview of a Scott Matsuda, whose name was added to the witness list, and I specifically had asked my investigator for that particular report, and I asked him to check to make sure that none of the names that were added, that there were any reports that had not been turned over. That was the report that I was given. That was the report that I turned over, and I will again endeavor to review my files, to review the files of the other counsel, and to make sure that there are not any other reports still outstanding that have not been turned over. And if I find so, I'll give them to Mr. Hodgman.
All right, I would like for you to report back to the court tomorrow morning, Mr. Douglas, as to that search.
Yes,
all right. All right, Mr. Hodgman, can we approach now?
Yes.
Thank you. stand in recess until 10:30, and we will begin opening statements at 10:30. All right, Deputy Jex, we need the jury, please. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Ullman, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. The jury is not present. Deputy Magnero, may we have the jury, please? All right, counsel in the audience, please be seated. All right, good morning, ladies and gentlemen. We are going to begin with the opening statements made by the lawyers in the case. Let me remind you from my instructions to you yesterday that any statements made to you by the attorneys during the course of their opening statements are not evidence and should not be considered as such by you. These opening statements are normally given by the attorneys to sort of give you an overall view of the evidence that they intend to present. It's to give you a roadmap, so to speak, as to how to evaluate the evidence. This case, as you know, will be relatively long, and by necessity, some of this evidence will be presented to you out of chronological or logical order. So they'll need to explain to you the case that they intend to present. All right, are both sides prepared to go forward, Mr. Cochran?
We are, Your Honor.
Mr. Clark?
Yes, we are, Your Honor.
All right, do the people wish to make an opening statement?
Yes, we do. Thank you.
All right, you may proceed. Mr. Darden? Thank you.
Your Honor, Judge Ito, Mr. Cochran, and Mr. Shapiro and Dean Ullman, and to my colleagues seated here today in front of you, and to the real parties and interest in this case, the Brown family, the Goldman family, and the Simpson family, and to you ladies and gentlemen of the jury, good morning. I think it's fair to say that I have the toughest job in town today, except for the job that you have. Your job may just be a little bit tougher, but your job, and like my job, both have a central focus, a single objective, and that objective is justice, obviously. It's going to be a long trial, and I want you to know how much we appreciate your being on the panel. We appreciate the personal sacrifices you're making by being sequestered. We understand that can be difficult. And I'd like to thank you in advance for keeping the promises you made to us when you were selected for the jury initially. You promised to be fair. You promised to be open-minded. You promised to hear and see and carefully consider all the evidence in the case. And you promised to find this case, to come to a verdict in this case solely on the basis of the evidence and the law given to you by Judge Ito. And you promised to do that based on the law, based on the facts and the evidence, and nothing else. You promised us that you had no hidden agenda, that you only wanted to see justice done, and you promised us that you would do everything you could under the law to see that justice was done. And so I thank you for that, and I thank you in advance for the verdict you will at some point render in this case. And we're here today, obviously, to resolve an issue, to settle a question that has been on the minds of people throughout the country these last 7 months. It certainly has been on the mind of my people up in Richmond, California, and friends in Fayetteville, Georgia, and all across the country, and everybody wants to know, and everybody I know often posed the question to me, did O.J. Simpson really kill Nicole Brown and Ronald Goldman? Well, finally, ladies and gentlemen, I am here in front of you this morning to answer that question. And we'll answer that question from the witness stand, and from the exhibits you'll see in this case, and from the evidence. And when you see the evidence, and when you hear the witnesses, and when you put it all together and consider the totality of circumstances in this case, the answer will be clear to you as well. The answer to the question is yes. The evidence will show that the answer to the question is yes. O.J. Simpson murdered Nicole Brown and Ronald Goldman. And I'm sure you'll be wondering why as the trial proceeds on, and I'm sure you're wondering why right now. As the judge instructed you already, opening statements are not evidence. Opening statements are given by lawyers, and in an opening statement, we inform the jury of what we think the evidence will show in this case, what we believe the evidence will show. But we're lawyers. We're not witnesses. We're not under oath. Nothing we say is evidence. The things we say to you today are not the things that you should carry into the jury room and into deliberations. You should carry into the jury room and into your deliberations the evidence in the case, the testimony from the witness stand, the exhibits admitted at trial, the instructions given to you by the court. And when you look at all of that, when you go back and reflect on the testimony and the exhibits and everything you heard and saw in this case, you'll know why he killed Nicole Brown and Ronald Goldman. And when I give you the answer as I have, and you consider and you stop and consider and you think, why would he do it? Why would he do it? Not O.J. Simpson, not the O.J. Simpson we think we know, not the O.J. Simpson we've seen over the years. But that raises another question, and that question is, do you know O.J. Simpson? We've seen him play football for USC. We watched him thrash UCLA and play in the Rose Bowl. We watched him win the Heisman Trophy. He may be the best running back in the history of the NFL. We watched him leap turnstiles and chairs and run to airplanes in the Hertz commercials. And we watched him with a 50-inch afro and Naked Gun 33.5. And we've seen him time and time again. And we came to think that we know him. What we've been seeing, ladies and gentlemen, is the public face, the public persona, the face of the athlete, the face of the actor. It is not the actor who is on trial here today, ladies and gentlemen. It is not that public face. It is his other face. Like many men in public, like many public men, they have a public image, a public persona, a public side, a public life, and they also have a private side, a private life, a private face. And that is the face we will expose to you in this trial. The other side of O.J. Simpson, the side you've never met before. We will expose in this trial and show to you in this trial that other face, the face he wore behind the locks and the gates and the walls at Rockingham, that other face, the one that Nicole Brown encountered almost every day of her adult life, the one she encountered during the last moments of her adult life. The same face Ronald Goldman encountered during the last moments of his life. When we look upon and look behind that public face, the public face of the man who sits here in court today, you'll see a different face. And the evidence will show that the face you'll see And the man that you will see will be the face of a batterer, a wife beater, an abuser, a controller. You'll see the face of Ron's and Nicole's murderer. To understand what happened at Bundy, we need to examine this defendant's relationship with Nicole. Because when we do, we can discern from that, we can see a motive. We can see his motive for killing his ex-wife. And I submit to you, ladies and gentlemen, that as the trial proceeds on, and as you hear the evidence in this case, that motive will become clear. He killed Nicole for a single reason. Not because he hated her. He didn't hate Nicole. He didn't kill her because he didn't love her anymore, because in his mind, he did. He killed her for a reason almost as old as mankind itself. He killed her out of jealousy. He killed her because he couldn't have her. And if he couldn't have her, he didn't want anybody else to have her. He killed her to control her. Control is a continuing theme. It was a continuing theme. The central focus of their entire relationship. By killing Nicole, this defendant assumed total control over her. By killing her, he committed the ultimate act of control. By killing her, no one else could have her. No one but him. And he killed Ron Goldman. And he killed Ron Goldman for another reason. He killed Ron Goldman because he got in the way. He killed Nicole because he had a problem with her, as men and women sometimes do have in relationships. They have a problem. And this defendant's problem, the man in the courtroom, I think he stated his problem rather eloquently. He had his weight, because he stood over her body at his weight. And he said then, and he said on other occasions, and I quote, he said, while standing over that casket, while standing over Nicole's body, my problem was that I loved you too much. But it wasn't really love, ladies and gentlemen. And this will be reflected in the evidence, and the evidence will establish this, that it wasn't really love. What this defendant had for Nicole Brown wasn't love, it was obsession. He became obsessed with her. And his obsession was so great that he developed a need to control her. And his need to control and his feelings of obsession, his obsession was so great that when he came to realize that he could not keep her, he killed her. Because to let her go would mean to lose control of her. To let her go with Ron Goldman or someone else would mean to lose control. He couldn't have her. And neither could anyone else. Now, the evidence in this case will establish that the man in the courtroom, this defendant, is an extremely controlling and possessive man. And as I said before, control and possessiveness was a single dominant theme throughout their relationship. And he controlled her in a variety of ways. He controlled her financially. When the defendant and Nicole first met, she was barely 18 years old. He was almost 30. She shared an apartment. He owned a mansion. She waited tables at a restaurant. He was a millionaire. No one had ever heard of Nicole Brown, but he was one of the most recognized men in America. But after he met her, he slowly began to control her. She shared an apartment with a friend. He got her own apartment. He bought her things. He gave her things. The time she was 19, she was driving a Porsche. He got it for her. He began to gain control over her. And throughout the years, throughout their relationship, he maintained that economic control over her, that financial control. The evidence will show that Nicole never really held a job. She never really worked. She never really operated a business. She never had an income really of her own. Throughout her entire adult life, this man, the defendant in the courtroom, held the purse strings in her life. Whatever money she got, whatever material possessions she got from the defendant. People can sometimes be bought. And young people sometimes can be easily misled. Nicole was a very young woman, if a woman at all, when she first met this defendant, the man seated in the courtroom. And as the years went on, and as they continued to date, and as he gained more and more control over her, the more control he gained, the more abusive he became. As you listen to the evidence in this case, you're going to be hearing evidence regarding domestic abuse, domestic violence, stalking, intimidation, physical abuse, wife beating, public humiliation. As you listen to the trial and as you hear this evidence and see this evidence, please keep in mind that all of these different kinds of abuse were all different methods to control her. Let me proceed on. The evidence will show in this case that he abused her mentally. He stripped her of her self-esteem. This defendant dictated the way Nicole would dress. He dictated the way she would wear her hair. And when he didn't like her appearance, he would criticize her, he would humiliate her to the point that she would cry. If he didn't like her shoes, he'd go out and buy shoes. This is what I want you to wear. Wear this, look like this. She was not a Barbie doll, ladies and gentlemen. The evidence would show that he was so controlling that he attempted to define her identity. He attempted to define who she was. When she was pregnant and put on weight. The evidence would show that this defendant was so abusive that he called her names. He called her fat. He called her a pig. And he did this in the presence of her family and in the presence of her friends. And he humiliated her. And that is the face we intend to expose in this trial. That's the other side of this defendant we're going to show you in this trial. And by doing these things and by hurling these insults, he stripped her of her self-esteem. And when you're controlling someone financially, and when they have no self-esteem, and when they have no identity, you have them. You control them. The evidence will show that this defendant, this man in the courtroom, was a very controlling and possessive man. And that the dominant theme throughout their relationship was his control of Nicole Brown. But he did more. He did more than just demean her in the presence of others. He attempted to isolate her, sometimes from some people. When certain men came around, he became jealous. And he became so jealous that it got to the point that she would not want to be around certain men because she was concerned that he might get jealous by their mere presence. And as time went on, and as he became jealous, and more jealous, he even insisted that she not be around certain men. He began to isolate her, ladies and gentlemen. When her friends came around, her girlfriends came around, and when he felt that she was spending too much time with those girlfriends, he talked to the girlfriends. He let them know he didn't like them hanging around. He dissuaded her girlfriends from hanging around. He attempted to isolate her from other people. And when you isolate someone, and when you have economic control over someone, and when you strip someone of their self-esteem, and when you establish their identity, you have them. They're yours. You can control them. And the evidence would show in this case that this man is an extremely possessive and controlling individual, and that he is an extremely obsessive individual when it came to Nicole. And his obsession was manifested by the things he did toward controlling her, but demeaning her and controlling the purse strings and isolating her and defining who she would see and who she wouldn't see and who her friends would be and who they would not be wasn't all this defendant did to control this woman. There are more powerful forms of control. There's force. There's violence. There's fear. There's intimidation. And you will hear testimony. You will see evidence that in his quest to control Nicole, this defendant used all these things. He used fear. He used intimidation. And he used violence. And he instilled such a fear in her, ladies and gentlemen. She will hear testimony that he could walk into a room. He could walk into a room, and Nicole would be there. And a moment before he walked in, she would just be the most charming individual there is, relaxed. But when he walked in, her demeanor changed completely. As time went on, his mere presence became intimidating to her. I mentioned earlier that they met when she was around 18 years old back in 1977, and they dated for 8 years. And they eventually married in 1985. And the marriage was a stormy marriage. And it was a marriage punctuated by acts of violence. And that violence would always be followed by an apology. He would apologize, give her jewelry, buy her flowers. He would promise to do better. Promise to maintain control of himself. And he would promise not to do it again. And then those acts of violence would be followed by additional acts of violence, and it became a cycle. Violence, apologies. A period of quiet and calm. Then violence and apologies. Quiet and calm. Violence, apologies. Quiet, calm. A cycle of violence characterized their relationship. It characterized their marriage. And domestic violence, ladies and gentlemen, that's a difficult topic, because domestic violence is something that happens behind the gates and the walls. It happens in the bedroom and inside the home and in places where the public can't see. Domestic violence is a private affair, generally, while it's occurring. And so it makes it difficult to obtain evidence, to gain proof that the violence occurred. And it makes it difficult to obtain evidence and gain proof that the relationship is a violent relationship. But we do have that proof. We do have proof. We do have evidence. You will hear testimony from witnesses in this case, and they will discuss the violent relationship, the violent marriage this defendant had with Nicole Brown. In 1985, the police responded to the defendant's home in Rockingham in response to a call. And when they arrived, they were met by Nicole. She was crying, and she was upset, and her face was puffy, and she was near hysterics. And she told these people, she said, we had a fight. After the fight, I was trying to leave, and when I tried to leave, the defendant grabbed a baseball bat, and he took that baseball bat and he smashed the windshield to my car. This is 1985. And as they looked around, these law enforcement officers, they looked to the right, and they saw a white 450 SL Mercedes-Benz. And the windshield was smashed out. And just then the defendant came out of the house. And he offered an explanation. Well, the police didn't arrest him. They left. They left Nicole there. They left the defendant there. And that isn't an act of physical violence toward Nicole, is it? Or is it? Maybe it is. Nicole Brown was there to witness this act, this violence on her vehicle. And if you're married to someone and you love someone and you have a fight with them and they take a baseball bat and they do something like that to one of your prized possessions, could it be that they're sending a message? The evidence will show that this was a message. It was an indication. It was a warning as to what would happen next. It was a warning that what happened to this Mercedes-Benz could just as well happen to you. And it did happen to Nicole. Not with the baseball bat, but just like that Mercedes got smashed and dented, so did Nicole. You'll be hearing evidence. You'll be hearing testimony. You'll be seeing witnesses in this case regarding an incident that happened on January 1, 1989. It was almost 4 o'clock in the morning on January 1st when the 911 operator received a telephone call from Rockingham. And that operator will be here to testify in court. And that operator will be here to authenticate the tape of that 911 call from Rockingham. And when the operator appears and when the tape is played, listen very carefully. Because if you listen carefully, in the background you will hear a woman screaming. And you will hear something else. You will hear the sound of this defendant, this man, beating this woman. You will hear the sound of his hand smacking across her face. You will hear the sound of this defendant beating his wife. the police arrived. They arrived at Rockingham in response to that telephone call. And Nicole never got to tell the 911 operator to come and help me or anything like that. All she did was scream, and the operator could hear her screaming, and the operator could hear her being beaten. And she advised LAPD units to respond to 360 North Rockingham. We can hear the sound of a woman being beaten now, right now. And the officers arrived at Rockingham a short time later. And when they did, they rang the buzzer to the security gate. And as they did so, they saw someone run from the bushes, run from the darkness in their direction. And this person that they saw was Nicole. And Nicole came running out of the darkness, wearing nothing but sweatpants and a bra, running toward the officers. And she was covered with mud, and she was dirty, and she was filthy. And she ran toward the officers, and as she ran toward the officers, she was shouting and yelling, "He's going to kill me! He's going to kill me!" And the officers stood there. They didn't know what to do. It's 4 o'clock in the morning, she's out in her bra, sweatpants and covered with mud. They just got a call. There's a woman at Rockingham being beaten now. She comes running out of the darkness and out of the mud and out of the bushes. And she pushes the button to the security gate, and she runs through the gate, and she collapses in the arms of the officer. The entire time she's yelling, "He's going to kill me. He's going to kill me." And the officer said, Who's going to kill you? And she said, "OJ is going to kill me." And the officers looked. They looked at Nicole. Her eye was swollen, bruised. Her lip was cut. And one of the officers, the senior officer there, he looked at her neck. And what he saw startled him. On her neck, he could see the imprint of a hand. The imprint of a hand around her neck. Well, it was then that the defendant came out of the house. He was wearing nothing but his bathrobe. And he did not address his wife at the time. And he did not ask the police how she was doing or if she was okay. And what the evidence will show and what you will hear in this case is that he demeaned and humiliated her even more. He shouted to the officers in the presence of Nicole, his wife, "I've got 2 women now. I don't need that one. I don't want that one in my bed anymore." This was his wife, and this is what he said to these officers who were strangers to him. This is what he shouted out to the police. The officers were on one side of the gate of the wall, and the defendant at that time was on the other side. The officer said, "Mr. Simpson, we're going to have to place you under arrest. It appears that your wife has been beaten. So please go back into the house and put on some clothes and come with us. We're going to take you to the station." Well, the evidence would show that that did not sit well with this defendant. And he responded, "The police have been here 8 times before. And now you're going to arrest me for this? 8 times. That's what the defendant said. The police had been there 8 times before. And as he said, "You're going to arrest me for this?" The defendant told the officers, "This is a family matter." That's what the evidence would show. The defendant said to the officers. this is a family matter. And he asked, why do you want to make such a big deal out of it? We can handle it. The evidence would show that the officers did not like the way he had handled things up to that point. And they insisted that he get dressed. And they told him that he was under arrest and that they were going to take him to the station. Well, this was O.J. Simpson. And he did get dressed. But he didn't go to the police station. He jumped in his Bentley and he sped away, and they chased after him. They didn't catch him, and he got away. The next day, he went to the Rose Bowl. But despite this, despite 89, what happened on January 1, 89, despite the Mercedes-Benz incident in 1985, she stayed. She stayed with him. And I'm not suggesting, and the evidence won't suggest, that every day of their marriage or their relationship was stormy and rocky and filled with violence. That's not what we're suggesting here. But we are suggesting, and the evidence will show, that there was a cycle of violence. A cycle of violence, and the dominant theme in that relationship and in that cycle, and the ultimate objective was always control. Control. Well, after the 89 incident, after that night, their relationship changed somewhat. She was concerned. And the defendant was concerned. The defendant is a public man, and he was concerned about his public image. And in the public domain and in the public media, back in 1989, he was interviewed by Roy Firestone on ESPN. And during that interview, Mr. Firestone asked the defendant about that incident on the morning of January 1. And the defendant downplayed it. He minimized things, fluffed it over. And you'll hear and see that interview. And in that interview, the defendant said it was sort of a mutual wrestling match. She was wrong, he was wrong. Ta-da. No big deal. And that's what he said to the press and to the public. He minimized things. But you'll hear testimony from investigators employed with the DA's office, and they'll tell you about a day just a few months ago when they drilled a hole in the safe deposit box, Nicole's safe deposit box. And they'll tell you about the day that they recovered photographs taken of Nicole's injuries back in 1989. And they'll also tell you about the recovery of some letters the defendant wrote to Nicole after the 1989 beating. And you'll see those letters. They'll be here. You'll be able to read them. And you'll note that the account the defendant gave the press and the media and the public was not the same account he gave Nicole in those letters during that apology phase, the contrition phase, the phase he was going through. In the letter he wrote to Nicole, he apologized for hurting her. In the letter he wrote to Nicole, he admitted he had lost control. And in the letter to Nicole, He said the same old thing you've been saying all along, and that is that I will do better. We can get through this. And that happens in bad relationships and in abusive relationships, doesn't it? Things get bad, bad things happen. It's always somebody's fault. But nobody wants to take the blame. And in this situation, and the evidence will show that what the defendant did was he made these promises. He sort of roped her back in. You know how it is. Bad relationship, I'll do better, here's a gift, I'm sorry, and they just rope you back into it. And if you're the other person in Nicole's position, as she was, and this will be reflected in the evidence, she wanted to believe. She wanted to believe that her marriage could survive. She wanted to have hope, and he gave her hope for a while. Because this is a cycle. And so he beat her up on January 1, and he admitted to her privately in his letters that he was responsible. And he apologized, and he gave her things, and he tried to make it all better, and he gave her hope, and he roped her back in, and she stayed. She stayed because she had hope and because she wanted to believe that January 1, 1989 would be the last time that he would abuse her, physically or mentally. As you hear the evidence in this case, something very sad becomes very apparent. They met when she was 18, and he was almost 30. And in 1992, they divorced. She was only 33 or so. And she died when she was almost 35. Throughout her adult life, throughout most of her adult life, her concept of marriage and a relationship was defined by this defendant. That was adult love. Her notion of adult love for 15 years was what this defendant gave her. And he abused her throughout that relationship. Well, as I said before, sometimes you get roped in. People get roped in. Nicole got roped in by the defendant, and she stayed, and she stayed. And people stay in those situations, those abusive relationships, for years and years, until one or two things happen. One, they just can't take it anymore. Or two, until they just can't take it anymore and they wake up to reality. And finally, in 1992, Nicole woke up to the reality of her situation. And in January 1992, she moved from Rockingham, and she left the defendant, and she filed for divorce. Well, this did not sit well with this defendant, and this will be reflected in the evidence. He did not like this. He did not like the fact that Nicole was leaving his house, going somewhere else to live in her own house, away from him. There's that issue of control. How could he control her? She wasn't right there with him. And he didn't take it well, and he lost 20 to 25 pounds like that. And almost on a daily basis, he would call her sisters, Dominique and Tanya and Denise. And he'd call her mother and her father, sometimes crying on the telephone. And he would call them, and he would whine to them, and he'd tell them how much he loved her and how he wanted her back. He'd use them to try and rope her back in. Well, she couldn't let him go. not completely. I mean, how could she? She had been under his control for 15 or 16 years. And so she didn't go too far. She rented a house in Brentwood on Gretna Green. They saw each other. They had children together, lovely children. You'll probably be seeing a picture of one pretty soon. But he couldn't deal with the loss of Nicole. He couldn't deal with not having her there. He couldn't deal with the loss of control, and he couldn't help but pursue her. You'll hear a testimony in this case from Nicole's mother, and she'll tell you about some of the telephone conversations she had with the defendant back in 1992, and some even more recent. And in one conversation he told her, he said, all my friends tell me that I should just leave her alone, just forget about it, just go on with my own life. And when Mrs. Brown said, why don't you do that? Let her go. If you let her go, then maybe she'll come back to you. Just let her go and maybe she'll come back. And his response was, I can't. You know I can't. You know I can't help myself. I can't let her go. He couldn't let her go. He couldn't help but pursue her. He couldn't leave her alone. He couldn't handle the loss of control. And because she had left his house and moved somewhere else and established her own home, her own house, and began establishing her own relationships, he did the only thing he could do to gain control, to try to regain control, to try to find out what was going on with her. And so he stalked her. He stalked her. When she left Rockingham in January of '92 and set up a new household on Gretna Green, also in Brentwood, she began dating a man named Keith Zalamzowicz. And she got a babysitter for their 2 children. Whenever Keith and Nicole would go out, not every time, but enough, he would show up. They went to a nightclub, and Keith will tell you about this. He'll be here to testify. The defendant showed up. They went to a restaurant called the Tryst. It had just opened. Nicole and Keith and some other friends, they were there. They got a table. They began to have dinner. And as they sat there having dinner, guess who showed up? Guess who attempted to gain control again? The defendant showed up. And that'll be reflected in the evidence and in the testimony. And what he did is he walked into the restaurant. He saw Nicole and Keith and her other friends. He went to another table. Grabbed a chair. Now the chair was facing in an opposite direction, but he grabbed the chair, he turned it around, he sat there staring at Keith and Nicole and their dinner party. Well, Keith will be here to tell you that that was an awfully intimidating experience. Why? There was another incident at the Mezzaluna. Nicole was there, Keith was there. The defendant suddenly showed up, drove up in front of the restaurant, got out of the car, walked up to the table where they were seated, put his hands on and said, I'm O.J. Simpson and she's still my wife. Well, she'd filed for divorce and moved out of his house. But that was intimidating. And there's more. And you'll hear about the other incidents. There's more evidence of stalking in this case, and you'll hear about that. There was one evening when Keith and Nicole, they went to a comedy show, and after the show, they went to Nicole's house on Gretna Green. It was about 3 in the morning. And they were seated on the sofa in her living room. The kids were upstairs asleep. It's 3 o'clock in the morning. And Keith and Nicole made love on the couch. But they weren't alone. There was somebody watching. There was someone watching through the window. It was the defendant. At 3 o'clock in the morning, he was looking through Nicole's window, watching her make love to another man. And the next day, when Keith and Nicole were together, he walked right into her house. And he was beside himself, and he was angry. And he said some very naughty things. But one of the things that he said to Keith and Nicole was that he said, "I watched you last night. I watched you and I saw everything." Well, the evidence will show that that is some unusual behavior, to say the least. But the evidence will show also that this is all part of this cycle. It is all part of this dominant theme in their relationship. This is all part of his need to know everything about her, to know where she is, to know who she's with, to know what she's doing, to control her. It's control. It's all about control. And though he did not interrupt them during the middle of the act, and he didn't punch Keith out, and he didn't punch Nicole out, he still watched so that he would know. And to control her, he had to confront her with what he knew, to intimidate her, to keep her from doing it again. It's all about control. Well, over the months, Nicole still wanted to believe that they could be a family again together. And they would attempt reconciliation, and they would fail, and they would attempt again. And Nicole was as much a party to that as the defendant was. But there was a situation in October of 1993, an incident another control incident. He forced his way through the back door of her place on Gretna Green. He forced the door in. He entered her house without her permission, without her knowledge, and he confronted her, and he scared her. He frightened her, and he scared her so badly that she telephoned 911. And she asked for police assistance, and you will hear that tape, the tape of that 911 call, and you will meet the 911 operator. And you will hear the defendant in the background. This is October 1993. He watched Keith and Nicole have sex in April of 1992. And when you listen to the October 1993 911 tape, you can hear him in the background still yelling and shouting about what happened in April of 1992. But that 911 tape is a telling glimpse into their relationship. That's for sure. And it's also an example of this defendant's private side, his private face. The other man, the man in the courtroom, the man that's on trial here today. And you'll hear Nicole on the telephone talking to the operator. And as you listen to her, you can't help but discern from the tone of her voice and the things that she says that she's a tough woman, but that she's also afraid and intimidated. And not only that, but that she feels that her situation is hopeless. The evidence will show that by October of 1993, Nicole, her situation was hopeless, and she was helpless. Way back in 1989, the defendant said that the police had been to the house 8 times before and never done anything. Nicole said the same thing on the telephone to the 911 operator in 1993. Her situation was hopeless and she was helpless. And you can infer from the evidence that Nicole Brown expected or had no expectation that anyone would ever do anything to this defendant because he beat her. There was no help coming and she didn't expect any help. But you'll hear that telephone call, and you will hear the defendant, and you will get a true sense of the fear he instilled in her. And he didn't hit her that day. He didn't strike her, and he didn't punch her. He did go through the house to see who was there. But he didn't hurt her that day. Still, she stayed. Still, they remained involved. Not only in the sense that he was the father of her children, but they still attempted to reconcile. And over the months after October of 1993, they tried to get together and they failed. They tried to get together and they failed. And in May of 1994, it was Nicole's birthday, and the defendant gave her a very nice gift, a piece of jewelry. And they attempted to reconcile, for lack of a better description. But the evidence will show that it was a very brief attempt, because a few days later, Nicole called it quits. She woke up to the true reality of her situation. She couldn't be bought anymore. She couldn't live like that, and the evidence will show that she let the defendant know that it was over. This is it. Hasta la vista. And this was significant in the mind of this defendant, ladies and gentlemen. It was something that had never happened before. He would do things to her and he would try to appease her by giving her things, and she would accept those things and they would reconcile. But not this day. This day, she couldn't be appeased. She couldn't be bought. She couldn't be bribed. She had had enough around, and he sat in it, and he sat there facing Nicole, and he just stared at her. He just sat there staring at her. And you'll hear testimony about this, and the evidence will show that it was a menacing stare, a penetrating stare. It was an angry stare, and it made everyone very uncomfortable. When the recital was over, there was a little issue of whether or not the defendant was allowed to give Sydney some flowers, and he gave her some flowers. But the Brown family had decided to go over to the Mezzaluna restaurant for dinner. And as they left, they made it clear to the defendant that he was not invited. And he wasn't invited. And by not inviting him, it was a reaffirmation of what he'd already been told. and that is that it was over. He was no longer being treated as a part of the family. He was no longer the centerpiece of every family outing. Nicole was getting on with her own life. And as the Brown family left, they looked toward the defendant and they saw him, and he was angry and he was depressed and they were concerned, and everyone wondered, what is he up to now? Well, Ms. Clark will tell you exactly what the defendant was up to as the day proceeded on. But there are some things you should know about this evidence that, as you hear it. This is not character assassination. This is evidence of a controlling personality, of a controlling relationship. It's proof of jealousy. And as Ms. Clark talks and as the evidence develops in this case, and as you hear it and see it and process it, you'll see that cycle of violence. You'll see how things escalated. You'll see how controlling he is. And you'll see why he would kill on June 12th. This is not character assassination. This is not some tabloid prosecution. The evidence you will hear in this case will be evidence of this defendant's life, of his conduct, the things he did. You hear evidence of his relationship with one of the victims. And as you hear it, as you hear the evidence and as you listen to Ms. Clark, you'll see how it is that Ron Goldman happened to be at the wrong place at the wrong time. As you listen to the evidence, you'll see that his decision to kill finally was merely a final link in a progressive chain of abusive and controlling conduct. And it was a chain that consisted of fear and intimidation and battery and emotional and mental abuse and economic abuse and control and stalking. And you'll see that there was a common scheme, a common plan in all of this, and that was to control her. It was all designed just to control her. And in controlling her, it was the private man, the private O.J. Simpson. It was the defendant who committed that final, ultimate act of control. She left him. She was no longer in his control. He was obsessed with her. He could not stand to lose her. And so he murdered her. And as you hear the evidence in this case, it will become clear that in his mind, she belonged to him. And if he couldn't have her, then nobody could. Thank you.
Ms. Clark?
Good morning, ladies and gentlemen. We've all seen him for quite a while, but hadn't seen Mr. Darden. He was busy with other matters, and he is an integral member of our team. Let me introduce some of the other lawyers you haven't met yet, but you will be seeing through the course of this trial. Mr. Hank Goldberg, Mr. Willie Clark, and Mr. Rodney Harmon. They will all be presenting the scientific evidence in this case that relates to the blood analysis and DNA testing. When you hear the amount of evidence that we have, you'll understand why I need the help, and I thank them very much for their able assistance thus far. Of course, you know Mr. Hodgman. He's still here. You've now heard the why. You've heard why. Why would Orenthal James Simpson, a man who seemingly had it all, commit such heinous crimes? Throw it all away. The one simple truth about the evidence described to you by Mr. Darden is that it shows that Mr. Simpson is a man, not a stereotype, but flesh and blood, who can do both good and evil. Being wealthy, being famous cannot change one simple truth. He's a person, and people have good sides and bad sides. Whether you see both sides or not, both sides are always there. Now, we will show you the other side of the smiling face you saw in the Hertz commercial, the one you never saw on camera, the one none of us ever wanted to see. And that was the side that went from Rockingham at his estate to Nicole's home at 875 South Bundy on the night of June the 12th, 1994. Now, on that night, many events were happening at the same time. And in order to give you a true picture, the most clear and accurate picture of what really happened, how the events occurred, I'm going to go back and forth between the parties and between the locations. So what I want to do, first of all, is describe the setting for you. As of June the 12th, 1994, Nicole was living at 875 South Bundy in Brentwood. That's a condominium. It was a duplex, and so it's one building. She had one side, had a common wall, and her neighbors had another side. She lived there with her two children, Justin and Sydney. The defendant was living at 360 Rockingham Avenue in Brentwood. Brian Kalin, known as Cato, some of you already are familiar with the name, was living in one of the guest units behind the defendant's home on Rockingham Avenue. The defendant's daughter, Arnell, lived next to Cato in another one of the guest units. I'll show you a diagram a little bit later to get you more familiar with the location, but the guest units are behind and apart from the main house, and they share common walls. It's kind of like one long building. So Cato had one, and then Arnell had the next one. Now, the background on Cato, and the evidence will show you, is the following. Cato met Nicole in 1992 after she had left the defendant at a party in Aspen. They remained friendly after that point, not romantically, platonic, just friends. And he went to a party that she gave in Gretna Green in 1993. He noticed that that house had a guest unit behind it that was a separate living quarters, and he asked Nicole if he could rent that location. She said yes. She rented it to him for $450 to $500 a month, and he was allowed to reduce that amount if he did babysitting for her. He was very good with the children, so that was an arrangement that worked well for everyone. However, Nicole decided to move out of Gretna Green in 1994, and she found the residence on Bundy that I've described to you. Now, the Bundy residence did have separate quarters with its own entrance and exit, but it was all under one roof. It didn't have a separate living quarter like the other house did on Gretna Green. The defendant asked Cato not to stay there, not to live under the same roof as Nicole, saying it wouldn't be appropriate. And he asked Cato to come stay in one of the guest units at his house on Rockingham. He told Cato he could stay there for free. Cato, obviously, saw a much better financial situation for himself and agreed. And so in January of 1994, Cato moved to the guest unit behind the defendant's house on Rockingham, and Nicole moved to 875 South Bundy. Let me show you a board now of the Rockingham location. Oh, sure. Look, that's a scene.
Yes, I know, just so they, which one?
This one.
Yeah.
Thank you very much, Your Honor. Thank you, counsel. We might have a number on it.
So we can tell which one it is.
Should I mark it down?
Let's just,
Or I just describe it? 360 North Rockingham Avenue. This is an overall diagram of the defendant's home on Rockingham Avenue in Brentwood. This location here, this area here, is the main house. These rooms that are shown down here are the guest units. Now the guest units close off. They are locked off with a door so that you can't enter from the guest unit into the main house. You see the area here, it's marked Kalen's room. I don't know if you can all read it, that's why I'm pointing to it for you. That is Cato's guest unit. Right next to his unit is
Ms. Clark, could you allow Mr. Cochran to step over to your right so that he can see what you're pointing at?
Thank you, Ron. This is an office that Cato had access to. And this would be Arnell's room, right next to Cato's. Now, the Rockingham address also had a gate that opened onto Ashford Street on the north, and a gate that opened onto Rockingham on the west side. I'll get into more detail about it a little bit later. Now, before I really get into the events of the night of June the 12th and into all the details, there are a few key points that I want to bring out to you right now. I'll come back to them again, but I want you to bear them in mind. This has to do with the timing of the events that happened that night. You're going to hear a lot of talking about that throughout this trial. I think I can guarantee that. With respect to the timing, the evidence will show that on the night of June the 12th, 1994, the defendant had an hour and 10 minutes of time in which his whereabouts are unaccounted for. And we will show that it was during that hour and 10 minutes that the murders were committed. And so the evidence will prove that Cato last saw the defendant on the night of June the 12th at 9:35 at the latest. He did not see the defendant again until after 11 o'clock. In between those two times, at 10:15, a dog is heard barking that the evidence will show was Nicole's dog, which fixes the time at which the murder occurred. At 10:45, Cato heard thumps on his wall. And shortly after 11, he saw the defendant. An hour and 10 minutes during which the murders occurred, in which the defendant's whereabouts are unaccounted for. I'll come back to that point. Now, on the night of June the 12th, as Mr. Darden has already described to you, that was the recital for Sydney. It was a dance recital for her school. On the morning of June the 12th, the defendant played golf, played cards, and he was scheduled to go to the recital at 5 p.m. on the evening of June the 12th. Mr. Darden described to you how the defendant behaved that night. He was in an ugly mood, morose, depressed, and clearly fixated on his ex-wife, Nicole Brown. He returned home after the recital, and he spoke to Cato. It was approximately 6:30 to 7 p.m. He returned home to his home on Rockingham. Now, at about that same time, 6:30 to 7 p.m., Nicole was arriving at the Mezzaluna with her party. That was all of her family and Sydney and Justin. Now back at Rockingham, Mr. Simpson spoke to Cato. He discussed a little bit the recital, what he wanted to tell him about it, and he mentioned to him that Nicole was wearing a tight dress, and he wondered how she'd look in that tight dress when she got to be older. During the course of that day, he also told Cato that he and Nicole were through. Important to remember that the defendant would make statements sounding like he was cavalier about it, but the truth that we learned from the inside is that he was not at all cavalier about losing Nicole. Now, while the defendant is talking to Cato on Rockingham, Nicole and her party arrived at the Mezzaluna for dinner to celebrate Sidney's recital. Ron Goldman was a waiter at the Mezzaluna. He didn't wait on her table that night, but he was working there that night. Nicole was wearing a black halter dress and a black blazer. She left the restaurant with her family at approximately 8:30 p.m. Now, between 8:30 and 9 p.m., Cato was back in his room, and the defendant came out to his room to ask him for some change. The defendant was set to take a flight out that night to Chicago, an 11:45 red-eye. He indicated to Cato that he only had $100 bills, and he needed smaller change for the sky cap. He asked Cato if he had that smaller change, and Cato said he did. He then told Cato that he was going to go out and get something to eat. Cato asked if he could come along. The defendant said, okay. They then left, and they went out to the driveway. The defendant drove to McDonald's in his black Bentley. They got some burgers, and as he drove back, the defendant ate his food while he was driving. Cato did not. They got back to 360 Rockingham, and the defendant parked his Bentley in the driveway in the same position in which it was found by the police in the early morning hours of June the 13th. When Cato got out of the car, it was 9:30 to 9:35 at the latest. And when he got out of the car, we last saw the defendant standing near the Bentley. Cato walked through the driveway, through the side yard, and back to his room. As soon as he got back to his room, he made a call to his friend in San Diego at 9:37. So we know that the defendant got home between 9:30 to 9:35 at the very latest, based on the timing of the phone call that Cato placed to his friend in San Diego. When Cato left the defendant standing at the Bentley at 9:35, he did not see the defendant again until after 11 p.m. Now, what I'm about to describe to you is a series of events that proves that the murders occurred between 9:35 and 10:45 on the night of June the 12th, and that during that time, the defendant's whereabouts are unaccounted for. At 9:37, Juditha Brown, that is Nicole's mother, called the Mezzaluna to see if they had found her prescription glasses that she thought she had left there at dinner that night. Karen Crawford, the bar manager for Mezzaluna, took that call and then went to look for the glasses. She found them out in the gutter near where the family had gotten out of their car to come into the restaurant. She brought them back into the restaurant, told Juditha that she had found them. Juditha asked her to keep the glasses there. So Ms. Crawford put them into an envelope marked Nicole Simpson prescription glasses. We'll show you photographs of that envelope today. Now, Juditha called Nicole at 9:40 p.m. and told her that the glasses had been found and were being kept at the Mezzaluna at 9:40 p.m. And that was the last time Juditha ever spoke to her daughter, Nicole. A few minutes later, Ms. Crawford received a call from Nicole, and they spoke. Ms. Crawford then called Ron Goldman over to the phone. Ron Goldman spoke to Nicole for a few minutes, and when he was done, and he hung up. Ms. Crawford gave him the glasses, and he took the envelope containing those glasses. Shortly thereafter, at approximately 9:50 p.m., Ron Goldman left the restaurant, still dressed in his waiter's uniform, the white dress shirt, the black pants, and the black shoes. And his friends at the restaurant never again saw him alive.
Which graphic is this?
This is a view of the alley.
All right, what item, what exhibit number?
I'm sorry?
What exhibit number, just for the record, so we can demonstrate?
Oh,
what
I'm
we-
sorry. Number? P1. At approximately 10:15 p.m., Pablo Fenves, who lived diagonally across the alley behind Nicole's condominium, heard a dog begin to bark. The area you see here in the photograph, and I'm trying to designate it with the red light, this is alley behind her house, behind Nicole's house at 875 South Bundy. This Jeep that you see here is her Jeep. Pablo Fenves, whom I've just described, lived in the area where you see the police car. The lights that you see here on the balcony indicate where Nicole lived. That's her condominium. This is a rear view, again, of Nicole's, the rear of Nicole's condominium. That's her Jeep. That's her garage that I'm indicating. And this is the balcony area I've indicated before, and there's the upstairs area. This is P2.
Thank you.
This garage and these living quarters here belong to another family. As I indicated before, it's a duplex. So at 10:15, Pablo Fenves heard a dog bark. He remembered it clearly because the bark was like a plaintive, insistent wail. It was like nothing he'd ever heard before. Although he'd heard dogs barking in the neighborhood often, other dogs lived in that neighborhood. This was different. This bark sounded to him like a dog in trouble. At 11 p.m., when Pablo Fenves went to bed, the dog was still barking. He went over to his bedroom shutters and opened them to look out in the direction that the barking seemed to be coming from. And he looked in the direction of Nicole's condominium, which is the direction it seemed to be coming from. And he noticed that there were lights on in the upper floor of her condo. When he fell asleep, shortly after 11 o'clock, the dog was still barking. The evidence will show that this dog, wailing and barking so insistently, was Nicole's white Akita, Cato. Another neighbor, Steve Schwab, left to take his dog for a walk at approximately 10:30. At about 10:55, when he got to the corner of Dorothy and Bundy, which is right on the corner of Nicole's, where Nicole lived, maybe one house down, he saw Cato the dog walking alone. The dog was acting very agitated. It seemed to be barking at the house on the corner of Dorothy and Bundy. He couldn't tell which one. And he noticed that the dog had an expensive collar. When he checked it further, looking for tags, he noticed that there was blood on the paws and on the legs of the dog. Although at that time he saw no injury, he assumed there must have been a cut on the paw to cause all that blood. As he continued to walk, the dog began to follow him, but it behaved in a very strange manner, because at the walkway to every house that they passed, the dog would stop and bark insistently. When Steve got home at approximately 11:05, he and his wife discussed what to do with this dog. They sat outside, gave it some water because it seemed very dehydrated, and decided to try and get it to lead them to its owner's home. So they took it out, and they started to walk back, but as they neared Bundy, the dog resisted. The dog pulled back, and they couldn't get it to go any farther. So they took the dog back to the courtyard of their apartment building. Now in that courtyard, there was more light, and they were able to see more clearly that there was no injury on the dog, but that its paws and its legs were clearly bloody. Now, Steve Schwab later gave that dog to another neighbor in his apartment building, Sukru Bostepi. You'll see them testify in this courtroom. And Sukru Bostepi agreed to take care of the dog for the night. But again, the dog was acting very agitated with Sukru Bostepi. He tried to take him inside the apartment, and he was sniffing and scratching and trying to get out. So he tried to do the same thing that Steve did. And he took the dog out for a walk, hoping it would lead him back to the owner's home. As they went south on Bundy, the dog started pulling harder and harder until they got to the location of 875 South Bundy. And there at the pathway leading up to that home, the dog stopped. And the dog looked up the pathway. And that made Sukru look up the pathway. And there he saw a sight that he'll never forget. He saw the body of Nicole Brown lying at the foot of the steps in a pool of blood. Now I'm going to backtrack for a moment and talk about Rockingham. I last mentioned Cato at 9:37. He was on the phone to his friend in San Diego. He was on that phone for 7 minutes. That call ended at 9:44, at which point, after trying to use the typewriter in that office I showed you before, which is right next to his guest unit. This be the room right here. He called his friend Rachel Ferreira.
Once you finish your thought, Clerk.
It goes into, it's kind of better to break here if that's all right with the court.
All right. All right, ladies and gentlemen, we're going to take our recess for the lunch hour. Ms. Clark, could you take the poster down, please? Thank you. All right, ladies and gentlemen, we're going to take our recess for the lunch hour. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions about the case, talk to anybody about the case, or allow anybody to talk to you about it, and we will see you back here at 1:30. All right, have a nice lunch. All right. All right, good afternoon, counsel. Is there anything we need to address before we invite the jurors to rejoin us? Mr. Cochran?
Thank you very kindly, Your Honor, and I'll be very brief. This morning, Your Honor, I have received several calls regarding the witness, Rosa Lopez, and at noon I spoke with her personally. She indicates she's being besieged by individuals who are trying to either interview her. The press is outside of her house. She can't get out of her driveway or where she works. She's very, very afraid that in these harsh economic times that she may lose her job. Her lawyer, Carl Jones, has written a letter asking that should the people want to interview her, he'll arrange it and not to try to come on her job. She is works as a housekeeper. And I don't know what the court can do about the press, but she was really exasperated when I talked to her, and perhaps the court can appeal to the good side and the press and ask them if they would give her some privacy. She's very, very concerned about herself and her family. She feels it's unfair. I thought I should bring this to Your Honor's court because I got a call here, and several calls here in court.
All right. Mr. Darden, you have some response or comment on that?
Yes, Your Honor, thank you. And I appreciate Mr. Cochran's comments. I would just like to indicate that we haven't been part of the harassment. We haven't attempted to contact Ms. Lopez, as Mr. Douglas alluded to yesterday. And I would join in Mr. Cochran's request that this witness, as other witnesses in the case, not be harassed by the media, by the public. Leave these people alone. It's not their fault that they happen to be witnesses in the case of People v. Simpson. And we will contact Mr. Jones at the proper time and before we attempt to interview Ms. Lopez.
All right.
Thank you. We join. We agree on something, Your Honor, and we welcome your suggestion to the press if you have one.
I think it goes without saying. All right. Thank you, counsel.
Before the jury comes in, Your Honor?
Yes.
step outside for one moment.
Sure. I'm sorry? Briefly.
Well, for the same purpose that Mr. Driver's going outside.
Who are we missing?
Our technical support.
All right. Is Mr. Harris here? Mr. Harris? What's the warm-up time on the Elmo? All right, Ms. Clark, are you ready to proceed? Are we ready to proceed? All right, Deputy Magnero. All right, thank you, counsel. Be seated, ladies and gentlemen. Thank you. Back on the record in the Simpson matter, Mr. Simpson is again present before the court with his counsel. People are represented, and we have all the members of our jury panel again present with us. Ms. Clark, do you wish to continue your opening statement?
Thank you, Your Honor.
All right.
Good afternoon, everyone. I forgot to introduce a very important member of our team, and I sincerely apologize for that. Jonathan Fairlow. He's a new member of our office, and he does all of the technical work that you're seeing here. I wouldn't have a clue how to operate these things without him. I'm in serious trouble. I hope you all had a very good lunch. Let me remind you of where we left off so that we can pick up from there. We were talking about the timing, and I was discussing with you that Cato had last seen the defendant at 9:35 at Rockingham, and that an hour and 10 minutes, and that it was after 11 before he saw him again. So he saw the defendant at 9:35, did not see him again until after 11, and during that period of time, the defendant's whereabouts are unaccounted for. Now, last I spoke to you, Cato was on the phone with his girlfriend, Rachel Ferreira. At that time, at that same time that he was on the telephone, and this was approximately 10 to 10:15, Alan Park, a limousine driver, was on his way to Rockingham to pick up the defendant to take him to the airport, where he would take his flight at 11:45 to Chicago. Now, although his instructions were to arrive at Rockingham at 10:45, he hadn't been in the Brentwood area before, and he didn't want to be late. So he left early, and he arrived at Rockingham at 10:25. Now, I'm going to use the diagram again. When Alan Park pulled up on Ashford Street, he parked across the street from the defendant's residence, got out of his car, sat behind it on the curb, and had a cigarette. He got back in his car at about 10:30, sat in his car for a few minutes listening to the radio, and at 10:35 he decided that he would go and look at the Rockingham gate to see if that drive-in would be easier for him than the Ashford Street gate. What I should tell you right here is that he was driving a stretch limousine, and that has a very hard time making tight curves. He wanted to be able to pull up in front of the front door to an area that would be easy to load the baggage. And so he wanted to see if the Rockingham entrance would be more easy for him than the Ashford Street address. So he decided to pull down to Rockingham. He pulled the limousine down to Rockingham, all the way down to the point where the driver's side window would be parallel with the Rockingham gate, so he could look inside. Now, in doing that, he had to pass right by the curb area just north of the Rockingham gate. And what he noticed when he pulled to that area that was right in his field of view is that there was no car parked there. No white Ford Bronco. And it was 10:39. That's very important. We'll come back to that again. He looked down the driveway, and he saw that that looked like a tighter turn even than Ashford. So he backed the limousine up Rockingham Avenue and made a left turn onto the Ashford Street and pulled right up to the Ashford gate. When I say he pulled right up to the Ashford gate, on this photograph you see the Ashford gate of the defendant's residence. He actually had the grill of the car almost touching the gate, facing inward toward it.
Photograph.
I thought we gave the court.
It's P 29.
All right, thank you.
Can you give him? Your Honor, so the court won't have to inquire after every photograph. We've given a list to the court for each and every one with a
Well, I think you should make the record, counsel. You should tell us which this is. Because the clerk can't see, clerk has the list. She can't see directly the video. So you need to tell me which video you're using, which graphic you're using.
Very well, Your Honor. I'll ask that Jonathan Fairlow be allowed to.
Fine.
Thank you, Your Honor. Now, when Allen Park pulled back to the Ashford gate, parking up against it, facing into the driveway, he looked at his watch, and it was 10:40 p.m. At that point, he decided to go and ring the buzzer. I wanted to show you something else on there so you'll know what I'm talking about when I say ring the buzzer. I'm gesturing with this red light. You can see right here, that's the call box, where you'd be pressing the buzzer. And it rings inside the house. The person inside can then press a button to open the gate. At 10:40, he began to ring the buzzer. He could hear it sound, but there was no answer. There were lights on in the upstairs, one light on upstairs. There were no lights on downstairs. It seemed to him like no one was home, and he was a little worried about that, so he decided to page his boss and find out if perhaps the plans had changed. At 10:43, he paged his boss. He was then worried that perhaps the page didn't go through, so at 10:49, he called his boss at home, but there was no answer. He then got out and pushed the buzzer at the Ashford gate a few more times. Still got no answer. Now, during this period of time, Cato is still in his room on the phone with his girlfriend, Rachel. Now, what I haven't explained to you yet, this area here shown, this is the southern border of the defendant's property. This is a walkway here, but it's not like a sidewalk. It's very narrow, and it's very dark. Just a few feet wide. It's covered with leaves. It has the shrubbery that's indicated here. It's actually from the neighbor's yard. And there's a chain link fence. The shrubbery's right up against it. It overhangs the walk to make it very dark. Here you can see what's indicated as an air conditioner. I don't know if you can all read it, but that's what's written here, this little black box here. This air conditioner actually hangs over the walkway quite a bit. It's an air conditioner that is set into Cato's wall. So you can see the air conditioner on the inside, and then it hangs outside the wall, outside the house, over that walkway. So that this wall of Cato's room faces onto the south walkway. There's no entry or exit there. He can't go out that way. If he wants to exit his room, he has to exit through the doors that are right here. They're like shuttered doors, like shutters, door-like shutters. And he goes out through those shuttered doors to the pool area, and that's how he exits. So on that night, he's on the phone with his girlfriend, Rachel. Okay, what's indicated here, P what? P what?
P4.
What's indicated here is the area I've just described to you. You see the shrubbery from the neighbor's yard and the chain link fence. And this is the air conditioner right here that I'm circling. That air conditioner is for Cato's room. It's set into his wall. This is the walkway. You can see how dark and narrow it is. This is a shot taken during the daytime. At 10:45, Cato was talking to his girlfriend Rachel when suddenly he heard on the wall where the air conditioner was 3 loud thumps. The thumps were so loud that a picture on that wall actually moved. Cato was alarmed. He asked Rachel, "Have we had an earthquake?" When she said she hadn't felt any, he became even more alarmed. And then he wondered if there might be a prowler, somebody trying to break in, because if it wasn't an earthquake, that's what it had to be. He was worried about the sounds he had heard. He was worried about those thumping noises. And so he decided that even though he was afraid, and it was late at night and it was dark, he should go and see what the cause of those noises might be. A few minutes later, he hung up with Rachel and went out of his room to go and look.
P6.
This is a picture of Cato's room. Right up here, where I'm indicating, that's the air conditioner in the wall. The part of the wall that you can't see in this photograph, which would be actually over here, the opposite side of the bed, is where the picture was hanging that moved when the thumps were made. And now the shuttered doors I referred to, you can see them here at the left edge of this photograph. See them better here. This is taken from the head of the bed facing outward. These are the shuttered doors that lead out to the pool area.
P5.
He walked out of those shuttered doors and out through the pool area, coming out onto the side lawn that borders Ashford Street. When he came out to that side yard, he saw the limousine that was pulled up to the Ashford gate. But he figured that the defendant had already made contact with him, was about to let him in anyway, and didn't pay any further attention because he was very distracted by what the cause of those noises might be. Now with him, he had a little dim flashlight that he was going to use to try and see what was going on back there in the dark. In the meantime, just before Cato came out onto the side yard, Alan Park was standing at the Ashford gate ringing the buzzer, still getting no answer. Finally, he heard the car phone ringing inside his car, and it was 10:52. He had still received no answer to the buzzing at the Ashford gate. He got back into the car and spoke to his boss, telling his boss, "I don't think anybody's home. What shall I do?" His boss told him to wait a little longer, and when he'd been speaking to his boss for 3 minutes, he saw Cato coming out the side yard with his little flashlight. almost simultaneously with seeing Cato in the side yard, he saw a person 6 foot tall, 200 pounds, wearing all dark clothing, African American, walk quickly up the driveway and into the front door entrance. Immediately, as that person entered the house, the downstairs lights went on. Alan Park hung up the phone and walked over to the Ashford gate and buzzed again. This time, he got an answer. And the defendant said, a voice that Alan could recognize as the defendant's. The defendant said, "Sorry, I overslept. I just got out of the shower. I'll be down in 1 minute." Now, Cato, who was distracted by the possibility of a prowler, wasn't looking to see if anyone was coming and didn't see. And although Alan Park could not see well enough at the time the person entered the house to identify who it was, clearly that was the defendant. Now, while Alan was standing at the gate speaking to the defendant on the intercom, Cato decided to walk around to the south side of the garage, and he was going to attempt to go down that narrow walkway to see what had happened. But when he got actually back to this corner of the garage with that little dim flashlight, it was very dark and he was scared. So he decided not to, and he came back around. When he came back around, he realized that the limo driver was still outside the gate. So even though the defendant had spoken to him and said he was coming down, he did not open the gate for him. Cato had to go and open the gate. He opened the gate and he let him pull in. As soon as Alan Park pulled the limousine into the driveway, Cato, who was still very worried about the sounds, started talking to him, telling him he'd heard the thumps on his wall. His picture moved. He thought it might be a prowler, or maybe was it an earthquake? Had Alan felt an earthquake? Alan said, "No, I haven't." Cato was very nervous. But now, with Alan pulled into the driveway and inside the grounds, he felt a little safer. So Cato decided to go back to the area and try and check out the sounds and what had caused them. When he went back to the south side of the garage, he went through a first gate that basically you just lift and push against the wall. It's not a locking gate. Went up as far as a second gate, but couldn't see anything. It was still dark. The flashlight was very dim, and he decided to come back. He was still too afraid to go back there by himself. Cato came back out around the garage, and when he came out, he saw that the defendant had come out of the house by that time. The defendant was now wearing a light blue denim shirt and light blue denim jeans. As he came out, Cato also noticed that there was a small dark bag placed near where the the Bentley was parked. Remember, I told you the defendant parked his Bentley this way, facing out towards Rockingham. He could see that there was a small dark bag on the grass near that Bentley. It was Alan, Park, and Cato who were loading all of the bags into the limousine. And while they were loading the bags into the limousine, Cato spoke again of the thumps that he had heard, and being worried that it was a prowler, thinking it might have been an earthquake, hoping, I guess, it was an earthquake. So he asked the defendant for a better flashlight so he could go around to the back area and check out the source of those sounds again. He and the defendant then walked into the house very briefly, but then the defendant said, "Oh, it's late, I gotta go," and came back out. While they were loading the bags, Cato offered to go and get that small dark bag on the grass and put it in the car for the defendant. Unlike any of the other bags, the defendant said, No, I'll go get it." He went and got the bag, the defendant got the bag, and put it into the car. Now, the defendant did not give Cato a better flashlight, and when he left, although Cato seemed very concerned about the thumps, the defendant seemed relatively unconcerned. He got into the limousine and they left for the airport at approximately 11:15. Now let me back up for a minute. Just before he left, the defendant asked Cato to set the alarm. Cato said he didn't want to do that. He'd never set the alarm before. He didn't know the code. He felt very uncomfortable with the responsibility. told the defendant, no, I really don't want to do that. The defendant then left. They left out the Rockingham gate at 11:15. Cato went back to his room to call back his girlfriend, Rachel Ferreira, as he'd promised to do. On the way to the airport, the defendant repeatedly complained of being hot. Alan Park could see that he was sweating, and he rolled down the windows and turned on the air conditioner. The temperature that night was 63 degrees. During that drive to the airport, Alan could see that the defendant was moving around with his bags in the passenger compartment, although he couldn't see exactly what he was doing. They arrived at the airport at 11:30, and that small dark bag that the defendant insisted on putting in the car himself was never seen again after the defendant left for Chicago. Now, during the time the defendant was driving to the airport, Cato was on the phone again with his girlfriend, Rachel. During that phone call, there was a call waiting interruption. The call was interrupted by the defendant. The defendant told him, I need you to set the alarm. I forgot to set the alarm. He had to give Cato the security code and tell him where to go and set the alarm. There was a keypad outside the front entrance at the front door. Now, in the 6 months that Cato had been living there, the defendant had never asked him to set the alarm before, had never had to give him the security code before. This was the very first time that had ever happened. Now, at this point, we know the following. I'll talk to you about the timing again. Cato last saw the defendant at 9:35 when he was standing by that black Bentley after they'd come back from McDonald's. 40 minutes later, at 10:15, we hear Nicole's dog barking, that loud, insistent bark that went on and on and on. And it would be safe to assume that it was very shortly within that period of time that the murders occurred. When Alan Park drove over to Rockingham and saw that the defendant's Bronco was not there at the Rockingham gate, it was 10:39. And so we know that the defendant had not yet returned home. The drive between Rockingham and Bundy was timed, taking a normal rate of speed between the hours of 9:30 and 10:30 at night. It took approximately 6 minutes. And just so you can see the relationship of the two locations. Here's Nicole's condominium, 875 South Bundy. Here's the defendant's residence, 360 North Rockingham.
All right, for the record, this is
Brentwood?
supposed to be a blow-up of the Thomas Brothers map.
Yes, map of Brentwood area.
All right.
So at 9:35, last sight of the defendant. 40 minutes later, at 10:15, the dog is barking. Nicole's dog is barking. At 10:45, half an hour later, we hear the thumps on the wall. This leaves us between 9:35 and 10:45 for the defendant to drive from Rockingham to Bundy and back, a total of 12 minutes, which leaves him a full hour to commit the murders. Now let's go back to Nicole's home at 875 South Bundy. Now I'm going to show you what Sucru Bastepi saw when Nicole's dog took him to 875 South Bundy.
P7.
This is the view from the walkway. This is from the sidewalk area. At the end of the walkway, at the foot of the steps, you see the body of Nicole. She's wearing the black dress that she wore at the Mezzaluna that night. Officers Risky and Terrazas were the first officers to arrive at the scene. They got there at 12:13. That's 12:13 a.m., shortly after midnight. They immediately contacted Mr. Bastepi and his wife, who pointed to where they had seen Nicole. Next. What you see here is what Officers Risky and Terrazas saw when they arrived at the scene. You can see here the paw prints
P8.
of a dog. Officer Risky will describe to you what it was he saw when he got there. They were the same paw prints, no shoe prints, only dog prints up and down this walkway. In order not to disturb the blood or any of the evidence, Officer Risky and Terrazas walked up the side where you see the bushes next to the walkway.
P10.
They walked alongside. It would be to the left side of the walkway.
You give me just a moment before you bring up the next one to let me know what it is. Because I indicated to you I do not want to let out a video feed of certain items.
Right.
Thank you.
Officer Risky went all the way up to the end of the walkway in the bushes to a point where he was able to see at that point that it was not just Nicole, but also Ron. Your Honor? This one.
P11.
Thank you. You see here Ron Goldman, as he was found by Officers Risky and Terrazas. Now, what you're not going to be able to see in these photographs, ladies and gentlemen, is the fact that Nicole Brown's throat was hideously slashed. And you'll be able to see, and the evidence will show, that her murder took very little time to accomplish. The same goes for Ron Goldman. As a matter of fact, what you will be able to see in this case, that I'll describe to you now, is the area in which he was confronted. The area in which he was suddenly attacked by this defendant was very small. He was literally backed into a cage where he had nowhere to run. And that is how his murder was accomplished in a very short amount of time. You can see the area he's in right there. What you can't tell from these photographs is how small, how narrow this area really is. It's very small. He's bordered on one side by the rungs, you can see by the fence, and by the other at his feet. Yet another fence. It's literally backed into a corner. Now, so you can see the relationship and how close Nicole and Ron actually were. I have a diagram.
Can you take a picture now? Need a picture?
Yes. What this board shows you, and this is a board you want to call 875 South Bundy Drive, depicting envelope, hat, glove, and both of the victims. envelope in between them. The graphic nature of them, but this is the crime that we're here to examine. Looking down the steps, what the officer is pointing to is the ski cap and the glove that I've just shown you in the photographs. You can see it now in relation to Nicole. At the top of the photograph, you can just see the boot of Ron Goldman, and you can see the envelope in between them. That is the scene as it was found by Officers Risky and Terraza.
P13.
There's a close-up. You can see now underneath the plant. It was harder to see before from a distance. The glove and the ski cap. What you can also see here is the bloody shoe print. We'll be showing you more of those.
All right, Ms. Park, I'm going to release this one video.
Okay.
P14.
This is a little bit closer shot to let you see how clearly you see the bloody shoe print at the scene, right at the, right near the ski cap and the glove. And you can see how on a dark night, when it is dark there, the ski cap and the glove would be hidden by the plant. It would be difficult to find. And under pressured and hurried situation, you're not going to have a lot of time to look for them. Upon seeing that what you've just seen here, you ladies and gentlemen, Officer Risky went and notified his supervisor, who arrived at 12:30. A crime scene was immediately set up. Yellow tape was placed in front of the residence and behind the residence in order to make sure that no one would walk in and disturb any of the evidence. After the arrival of his supervisor, Officer Risky entered the condominium. Now, what I should tell you is that when he came to the scene, he found the body of Nicole. He could see the front door of the condo, and it was standing wide open. So she had just come outside when she was attacked. He went inside, thinking that there might be a suspect inside, and looked all through the house. Not only did he not find a suspect, but he found no evidence of ransacking, no evidence of forced entry, no evidence of a struggle, nothing that would indicate this was related in any way to a burglary. When he got upstairs in that condo, he found the two children, Justin and Sydney, asleep in their beds. They were taken quickly out of the condo, out through the rear, to avoid the hideous sight in front of their house. Now, what Officer Risky saw, he had gone inside to clear the house. He came out the front door and he looked down the walk. And I'd like to show you now what he saw on that walkway.
P.
Okay, Your Honor, this is... Can you kill this one?
I'm going to turn it off until I see something else.
Thank you, Your Honor.
P15.
What I'm showing you here is a shoe print. Again, right here. Heel print, a bloody heel print, and another one here. Next.
P16.
Again, bloody shoe prints. You can see one set of bloody shoe prints as they go down the walkway.
All right, I'm releasing this one.
Those bloody shoe prints, that one set of bloody shoe prints continues all the way back towards the rear alley area where there's the driveway. Remember I showed you earlier on that there was a driveway area behind the condominium where her Jeep was parked? These bloody shoe prints are all in the same direction, leaving the bodies of Ron and Nicole, going towards the back area.
P17.
And you can see them here again in a perspective shot. I'm circling with the red pen. About halfway down the walkway, they start to fade out as the blood is picked up by the sidewalk. What Officer Risky also saw were that there were blood drops just to the left of those bloody shoe prints. So next to that single set of bloody shoe prints leaving the scene, you had blood drops to the left of them.
P18.
These markers here indicate where there were blood drops found. And close up.
P19.
It's a close-up of 112 that you saw farther in the distance, the blood drop.
P18 again.
That gives you the perspective. Now I can show you what I was talking about. Here's a bloody shoe print. To the left, blood drop. Off farther, see this one I'm circling here, close up,
P21.
another blood drop. You can see that it is to the left again of a bloody shoe print. You can see that's a heel you're looking at there.
P22.
Again, this is showing you another blood drop that was found going down the stairs. I should explain to you, ladies and gentlemen, that the walkway going from the front of the house to the rear has many stairs going up and down. See, there are landings going up and down. You see a lot of stairs on this pathway. And on these stairs as well, I'm circling here. That's a blood drop. There were also bloody shoe prints seen here. I think you can even see this one I'm circling with the pen right now.
P23.
And that's close up, the one on the stairs. Blood drop.
P24.
Again, now this is at the rear gate of the condo. This tag shows another blood drop that was found. Close up.
P25.
And there it is. And now the blood drops continued out to the driveway area.
P26.
These markers show close up.
P27.
You see here the blood drop on the driveway. Now the shoe prints that you saw were determined to have been made by a size 12 shoe. The defendant wears a size 12. The blood drops to the left of the bloody shoe prints. When the defendant returned home from Chicago, he was found to have had a cut to the middle finger of his left hand.
P35.
The case was assigned to the Robbery Homicide Division. Detectives Philip Van Adder and Tom Lang, the investigating officers assigned to handle the case. They arrived at the scene just after 4 a.m., and they viewed the crime scene and the evidence as I've just described it to you. They found the same things that Officer Risky found. Given the fact that there were 2 young children being held at the station pending some adult who could take charge of them, they determined that they would go and make notification to the defendant. They then proceeded to the defendant's house. Now, they got to the defendant's house at approximately 5 a.m. At that time, they started to ring the Ashford gate, and they buzzed, but they got no answer. Now, at that point, they could see there were lights on in the house, there were cars in the driveway, but no one was answering. They eventually got the defendant's home phone number, called it repeatedly, but again, they got no answer. Then the detective saw the white Ford Bronco parked at the Rockingham gate.
P30.
This is the position in which the Bronco was found, just to the north of the Rockingham gate, and that's what you're looking at here. This area here is the Rockingham gate entrance to the defendant's home. This is the location that Alan Park drove by earlier that night at 10:39 and saw that there was no Bronco there at that time.
P31.
The detectives noticed that there was a small spot of blood near the driver's handle of that door. The criminalist is pointing to it here. That's Dennis Fung.
P32.
That's a close-up. You can see how small that spot of blood is.
P33.
This is taken from the rear of the vehicle.
P34.
Inside the vehicle, they saw in the rear cargo area, they were able to see a package that was addressed to Orenthal Productions. Knowing that that was the defendant's first name, they realized that was probably his car. After all they had seen and failing to be able to get any answer at the defendant's home, they became alarmed and they decided they would enter the property to see if they could locate someone or find perhaps another victim. When they went in, they went first to Cato's room. They knocked on his door and they asked him if there was someone there who could assist them. He directed them to Arnell, who was right next door. Cato told the detectives about the loud thumps that he had heard against the south wall of his residence that night, and about being worried about the source of those noises. After he told them about those noises, indicating that it was on the south wall and it seemed to come from the area of his air conditioner, the detectives went out to look to see what could have caused those noises.
P36.
And this is where they went, the same area that Cato had walked to earlier but never gotten up to because he was too afraid, the area of the air conditioner. As they approached this area, it was very dark. They were unable to see anything until they got closer.
P37. P38.
And there's the glove where it was found, in the very same location in which it was found that night, right next to the air conditioner on that narrow path. When they saw that glove, they realized that it looked like the mate to the glove that you also already saw at the Bundy scene underneath the plant at the foot of the body of Ron Goldman. They then realized that perhaps they needed to secure the residence, and Detective Van Adder then walked out of this pathway and out onto the driveway.
P40.
When he walked out onto the driveway, what Detective Van Adder saw, now that it was becoming light, it was at least 6 o'clock in the morning at that point, were blood drops on the driveway that led from the Bronco and all the way into the house.
P41.
And close up,
P42.
and there's the blood drop, one of the blood drops that was seen. On the,
P43.
this was inside the house. This is right inside the front door in the foyer area. There were a series of 3 blood drops here, close up.
P44.
You can see them here. I'm circling them. Having seen all of this, the detectives then realized that this was not just an occasion to make notification, that in fact they had uncovered evidence that indicated that the defendant had committed these murders. They secured the home and prepared to conduct a search. Criminalist Dennis Fung arrived at Rockingham at about 7 a.m., where he began to test all of the blood drops they had found. He tested the Bronco, and then he tested the drops on the driveway, determined that the drops on the driveway were indeed blood. Then he went to test the glove and found that it too contained blood. A search of the house, inside the house, revealed, among other things, a pair of rumpled socks at the foot of the defendant's bed in his bedroom.
P45.
You see there the socks that I just spoke of. This is exactly where they were found, in that condition.
P46.
Close up. Those socks were collected, along with many other items, and submitted for analysis. Now, the defendant's Bronco that you earlier saw in Rockingham proved to be locked. They couldn't find any keys for it, they couldn't get into it, so it was towed in a locked condition to the print shed, which is an area where the police keep large items that need to be fingerprinted, where they can keep it locked up. They towed it to the print shed and did not open it until the 14th, when they opened it by use of a Slim Jim. You'll probably hear some discussion of things that occurred with that Bronco after the 15th, and they may be interesting, but they have nothing to do with the evidence that was recovered on the 14th. And a search for blood was conducted of that Bronco on June the 14th. Those items were recovered, the blood was collected, and it was analyzed And those items that we'll be talking about today that were analyzed were recovered from the Bronco on June the 14th. Now, all of the items I've just shown you were collected and submitted for examination and analysis, and what you have here is a trail of blood from Bundy Drive to Rockingham Avenue and into the defendant's very bedroom, linked by the defendant's white Ford Bronco. I'm not going to go into the details right now with you, ladies and gentlemen, about the manner in which evidence was collected or the manner in which it was all analyzed. We have experts for that. But I do want to make some general comments in order to point out a few things right now, just to dispel any misconceptions anyone might have about evidence collection and analysis. First of all, collecting blood stains is a very simple thing. You or I could do it. And I tell you this because I'm not that good mechanically or scientifically, but even I could do it. What you do is you take a very small square of cotton and you put distilled water on it and you soak up the stain. There's no magic. Anyone can do it. It's just like you would go and soak up a spill in your kitchen. Not very different. Now, many laboratories or many police agencies use lab technicians for that. You know, people that don't have a bachelor's of science or any particular degree in criminalistics or forensics. Forensics is a science of crime scene analysis and investigation. Many of them don't use anyone with a degree in that, but LAPD does. LAPD uses criminalists who are people that have Bachelor of Science degrees in forensic science, the science of crime scene analysis. So they actually use people that are overqualified for the job. A likely issue in this case will be the testimony of the coroner. Now, I know that we've all seen, some of us have seen anyway, Quincy, seen Jack Klugman on television. He goes out to investigate the crime and he finds out who did it. In the general course of things, although there is a coroner's investigator, that investigator is just responsible for collecting the body from the scene and getting it to the coroner's office intact. What the coroner does is the coroner looks at the body to determine cause of death. Ladies and gentlemen, I can guarantee you one thing in this trial: there will be no dispute as to cause of death. No one will argue about what the cause of death was for Ron Goldman and Nicole Brown. The issue that will be raised is the time of death. Now, what can a coroner do for you with respect to time of death? The coroner can never really be that precise. A coroner can tell you, just based on his examination of the body, he can usually bring it down to a range of within 3 hours, between 9 and midnight, between midnight and 3. But if you want to pinpoint the time to within a minute, 10 minutes, a half hour, or even an hour or 2 hours, a coroner, solely by his examination of the body, cannot do it. We always have to, and that's true in any case, we always have to rely on the testimony of other witnesses, witnesses who will tell you when the victims made a phone call, or when they heard the victim leaving the house, or when they last saw the victim. Dogs barking, the kind of evidence I just talked to you about, is often what is used if you want to try and really pinpoint the time, because the coroner cannot pinpoint it to within minutes or even an hour, really, in any case. Now, before I get into the analysis of evidence, I'd like to talk to you a little bit about what scientists and criminalists look for nowadays when they examine the evidence. We've made tremendous strides in many areas. In general, in order to be able to solve crimes, the police have to stay at least one step ahead of the criminals. That means that they have to look for evidence in places and in ways that the criminals will not have thought of. For example, when it became known that you could match fingerprints, criminals wore gloves. When it became known that a bullet removed from the body of a victim could be matched to the gun that fired the bullet, they started to dispose of weapons, or to use weapons that could be easily disposed of other than guns. And nowadays it's very common to find cases where no murder weapon is recovered because they're smart enough to get rid of those weapons. So not all criminals figured this out, but the smart ones did. So we look at blood, for example. We test it for DNA. We look at hair and fiber. We examine it microscopically, comparing it to the victims and to the suspects to see if we can exclude them or if it's consistent with them. Now, in particular, the value of hair and fiber is a very unique thing. The reason for that is that through your daily life, You walk around, you shed hair, you shed fiber, you pick up hair, you pick up fiber, and you're not aware of it. It goes unnoticed. It's an involuntary thing, and it happens constantly throughout the day. There's a very fancy term for this, and it's called the Locard exchange principle. You don't have to remember that, because all it really says is when you go into a place, the environment affects you, and you affect the environment. And it's just what I said. You leave hairs and fibers, you pick up hairs and fibers. So, for example, if you have a red couch, an expert can look at your clothing and find the red fibers, look at them under a microscope and compare them and say, first of all, you are near something with red fibers, and if he has access to that couch, can examine and see if they're consistent. That is, that they could have had the same source. What the value of this is that it shows contact. It shows where items of evidence might have been. It shows who might have been in a given location and who came into contact with who. Because you find hair and fibers so often in a crime scene, because the shedding goes unnoticed, this can be of very great value in solving crimes. So every crime scene and every piece of evidence has value in terms of being able to help you solve the case. Now, with respect to blood evidence, as you know, we've made enormous strides. We have advanced our ability to extract information from blood with the development of DNA testing. This allows us to be far more precise in pinpointing the possible source of a blood stain. And we can also have then the experts tell us how rare it is that you have a blood stain matched to the type of a particular person. I'm not going to go into the details of all that testing. I'm going to let the experts talk to you about that when they come in and testify. But they will. They'll come in and tell you about all of the processes, and they'll explain how rare it is to find a match between a blood spot in a place and a particular person. Now, the defense is going to speak to you at length about contamination and all the problems that could ensue in the testing, but I'll simply say this at this point. There are safeguards built into the DNA tests that you will hear about, and these safeguards will show when problems occur. This is one of the reasons why DNA testing is so reliable. And you'll see that in this case, we have many blood stains, as you've already seen, not just one. You might question it if only one of many blood stains came back to a suspect. But when one after another, after another, after another matches the same person, then you realize that the testing is accurate, that it works, and that if there was contamination, it wouldn't keep coming back to one person. It just wouldn't come back at all. And although we're talking about science, and sometimes just saying that word can make us uncomfortable, all you're going to need is common sense and logic to follow this evidence. That's all you'll need. Now, DNA testing is not only used to solve crimes, it has many other purposes as well. Some of you talked about Jurassic Park, and they used it to make dinosaurs, but there are other more common uses for it as well. For example, it is used in the amniocentesis. We talked about that in your questionnaire and when we talked to you during the voir dire process, if you recall. That's the process where you determine whether a fetus may have a genetic defect. Most of you are familiar with that, either by first or second-hand experience. And what happens in that process is that fluid is extracted from the mother's stomach, from the sac, and that's amniotic fluid. That's a fluid that the baby floats in to protect it. They analyze that fluid to see if the baby has a genetic defect. Now, that procedure has many of the same problems.
Yes, with the reporter, please.
Your Honor, while counsel's approaching sidebar, if we could maybe take just a little stretch break, stand up, just stand up. Maybe the jury would like to do one.
Kind of unfavorable conditions that are going to deteriorate a sample very rapidly. And so you have a similar problem with non-criminal crime scene uses as you do with crime scene uses. And yet DNA has been very successful in identifying the war dead. Another way that DNA has been used that is not in crime scene analysis is in identifying old remains. By that I mean skeletons. They can extract the DNA from skeletons to determine the identity of the people that once those skeletons were. And they did that recently to identify the Russian royal family that lived back in 1917. So you can see that the DNA testing procedures is a very powerful tool that is useful in many, many ways, not just in crime scene analysis, but in medical diagnosis and in identifications that are necessary in other areas. Now, there are a couple of approaches to DNA testing that can be taken. The first one, you're going to hear these terms a lot, so I'm going to start you today, is RFLP. That stands for Restriction Fragment Length Polymorphism. And that's, all you have to know is RFLP for now. The experts will explain everything to you at the appropriate time. That is a very powerful tool used to pinpoint the identity of the person who left blood or hair or fiber, or excuse me, blood or hair or bodily fluid in an area. Very powerful tool. Another DNA test, not quite as powerful, but still more powerful than we used to have, is called PCR testing, polymerase chain reaction. In that form of testing, you can take much smaller bits of DNA and amplify them. That is, actually, you just multiply them. It's like Xeroxing. And you make it large enough so that you can test it. And that's been very, very powerful tool as well in analyzing and determining the source of a stain or bodily fluid that you find at a crime scene. Regardless of the method used, whether it's RFLP or PCR, they're both DNA testing. And the tests are really tests of exclusion. What does that mean? That means that when you conduct these tests, the effort is to exclude. You analyze the DNA and you see, can I exclude the suspect? Can I rule him out? Is there anything here inconsistent with the suspect or the victims, depending on what you're looking at? And that's exactly what was done in this case. With every piece of evidence collected, the effort was to exclude the defendant and to exclude the victims. That was the focus, and that is the aim of DNA testing. In this case, we asked this question over and over and over again. Can the defendant be excluded? No matter how hard we tried, over and over, the samples were tested and retested and tested again. Over and over again, we asked ourselves, can the defendant be excluded? And over and over and over again, the answer was no. The defendant cannot be excluded. I would now like to briefly summarize for you all of the test results of the analysis of the evidence I've just described. And I'm going to start with the hair and fiber. Now, the hair and fiber is microscopic analysis. It is not DNA, okay? This is the comparison of hairs and fibers that were found on various items of evidence and in locations at the scene that were compared to the defendant, the victims, and various other items of evidence. It's easier to explain to you if I actually tell you the results.
P14.
The ski cap that was found at the feet of Ron Goldman was examined for hair and trace analysis, and it was found on that knit hat that there was fiber like those from the carpet of the defendant's Ford Bronco. Now stop and think, why would there be carpet fibers like those from the defendant's Ford Bronco?
That's true. Just state what the evidence is. Thank you.
Also on that knit hat, we find hairs like those of the defendant. Which is what you would expect to find on a hat worn by the defendant. Your Honor, the next one
P11.
Your Honor, before we pull that up.
I've got it.
Thank you. On the shirt of Ron Goldman, we find a head hair like that of the defendant. On the glove found at the defendant's home at Rockingham, we find hair like those of Nicole Brown, hair like those of Ron Goldman, fibers like those from the shirt of Ron Goldman, and fiber like those found in the carpet of the defendant's Ford Bronco.
P48.
This shows you the defendant's Ford Bronco. You see the tags? Those all indicate blood spots that were recovered on June the 14th. The blood stain on the panel, and that's, I'm going to try and indicate it with the red light because it's at the edge of the photograph where that tag is. That blood, as well as the blood on the panel, matches the defendant.
P49.
The blood indicated here with the number 34 matches the defendant.
P50.
The blood on the panel here matches the defendant.
P51.
There's blood on the console matches the defendant. The item number 31 on the console, consistent with a mixture of the defendant and Ron Goldman.
P53.
This blood stain was on the console. This was recovered later in time, after the 14th. That is consistent with a mixture of the defendant, Ron Goldman, and Nicole Brown.
P54.
The blood stain found in this area marked with the number 33 matches Nicole.
P40.
On the Rockingham blood trail, the item number 6, which is, they don't have a close-up of it, it's one of these three markers. We will have it better explained to you with a diagram during the trial. The blood spot number 6 matches the defendant.
P41.
This is the blood spot number 7 we showed you before, close up. Matches the defendant.
P42. P43.
Again, the blood drops that were found just inside the front entry of the defendant's home. This is blood drops number 12.
P44.
Matches the defendant.
P45.
The socks that we indicated earlier to you were found in this condition, thrown hastily at the foot of the defendant's bed in his bedroom. The blood on those socks was analyzed.
P46.
It was determined that the blood on one spot matched the defendant. The blood on another spot matched Nicole.
P19. Pardon me, P39.
The glove that was found at the south walkway of the defendant's property at Rockingham revealed blood that was consistent with a mixture of Ron Goldman, Nicole Brown, and the defendant.
P19.
These are the blood drops at the Bundy location at 875 South Bundy. This blood drop that you see here, marked with the item number 112, matches the defendant.
P21.
Matches the defendant.
P23.
Matches the defendant.
P25,
Matches the defendant.
P27,
Matches the defendant. Apart from the test results, ladies and gentlemen, the mere fact that we find blood where there should be no blood, in the defendant's car, in his house, in the driveway, and even on the socks in his very bedroom, at the foot of his bed, that trail of blood from Bundy through his own Ford Bronco and into his house in Rockingham is devastating proof of his guilt. And the results of the analysis of that blood confirms what the rest of the evidence will show. That on June the 12th, 1994, after a violent relationship in which the defendant beat her, humiliated her, and controlled her, after he took her youth, her freedom, and her self-respect, just as she tried to break free, Orenthal James Simpson took her very life in what amounted to his final and his ultimate act of control. And in that final and terrible act, Ronald Goldman, an innocent bystander, was viciously and senselessly murdered. Remember that in voir dire, we asked you if you could use your common sense and reason to fairly and to objectively evaluate this evidence as neutral, impartial judges of the facts. You all promised that you could, and you would, and we believe that you will. We have every faith and belief in the fact that you will all keep that promise. But it will not be easy. You will be tested and tempted throughout this case to accept the unreasonable and be distracted by the irrelevant. The defense will talk to you about possibilities, and they'll insinuate many sinister things based on those possibilities. Possibilities of contamination, possibilities of setup, all in an effort to explain away all of the physical evidence. But possibilities alone do not equal proof. You've heard the instruction that says that all matters subject to human affairs are capable of some possible doubt. That's why the standard is reasonable doubt. And you'll hear the word reasonable more than once in the jury instructions, and you already have. Because if the proof standard was beyond all possible doubt, there could never be a conviction. There can always be a possible doubt about something. The question is whether you have a doubt that's founded in reason. So beware of the efforts to get you to accept the unreasonable, be distracted by the irrelevant, and to base your decision on speculation, on mere possibilities with no hard evidence to show that any of them really occurred. Listen carefully to all the possibilities and the hints raised by the defense and ask yourselves, is there any proof that any of these possibilities actually occurred? Listen carefully for the defense to explain how the defendant's blood got on 875 South Bundy Walkway. It's going to be up to you, ladies and gentlemen. You're going to have to be ever vigilant in acting as the judges in this case. Each one of you is a judge. Each one of you is a trier of fact. You have to examine all of the evidence very carefully, and as you do so, ask yourselves, is this reasonable? Is this logical? Does this make sense? Would I look at this evidence the same way?
Sounds like argument to me.
Look at the evidence the same way as you would for any other case. Now, winning is not what this is about. This is not a game. This is about justice and seeing that justice is done. 2 people have been brutally murdered, and the evidence consistently will point to the guilt of only one person as their murderer. Tell me what the evidence will show.
Are you about to conclude?
Mm-hmm. There was no rush to judgment in this case. It was very carefully considered before it was filed. The evidence will show, ladies and gentlemen, that as of June the 15th, many DNA results had already been returned. As of June the 15th, there had already been a match between the defendant and the blood found at Bundy Drive. There had already been a match between the victims and the blood found on the glove at his house. Many things were known, and yet it was examined carefully, the entire case examined very carefully, and was not filed till 2 days after those results were obtained. My job is to seek justice. I've had cases before this one. There will be cases after it. This case is not about the lawyers, myself, Mr. Hodgman, Mr. Darden, or Mr. Cochran. We have to remember what this case is about. And justice for all. Ladies and gentlemen, if those words are to mean anything, we must all be equal in the eyes of the law, and we cannot use a sliding scale to judge guilt or innocence based on a defendant or a victim's popularity. We live in very, very strange times.
Counsel, this has all been argument for the last 5 minutes.
I'll wrap up, Your Honor.
Please.
We cannot succumb to the temptation to thwart justice and throw truth out the window.
Counsel, I'm going to have to stop you right here. I've warned you 3 times now.
All we're asking is that
Counsel,
I'm
I'm warning you. I've warned you 3 times now.
I'm concluding right now, Your Honor.
Please.
May I?
Please.
Thank you. All we ask is that you stay focused on what the case is about the murder of Ron Goldman and Nicole Brown. Thank you.
Mr. Simpson is again present before the court with his counsel.
You then, as we start
to portions of Mr. Cochran's.
Oh, hold on. There he is, right behind you.
Oh, there you are. I thought Mr. Cochran was hiding from me, and perhaps Willie should. Okay, no, I see you, Mr. Cochran. And, Your Honor, let me say this. I was about to say, you asked me to examine the record for instances of inappropriate remarks for an opening statement. I want to make the people's position absolutely clear this afternoon with regard to when objections are likely to be opposed, because I want to give Mr. Cochran fair notice. What we heard in large part this morning was not an opening statement, but could very well pass for argument, and if given an argument, would not be objectionable. But this morning, and as I stated to the court, I am reluctant in any case to interfere with opposing counsel's opening statement. It was with great restraint this morning that I did object to a number of clearly objectionable remarks made by Mr. Cochran. I will highlight those in just a few moments. However, Your Honor, what the people are seeking this afternoon is, first of all, an admonition to Mr. Cochran. Very well, Your Honor. I withdraw the objection.
Thank you. All right, Mr. Harris.
in the United States, they wanted to determine with some accuracy the time of death would be to save the stomach contents. In this case, the coroner's office threw those stomach contents away. We will never have those. May I proceed, Mr. Harris, please?
That was D93B.
That he has seen it and he has his own pictures of it, and they haven't. I would suggest if this court is going to seriously entertain any of this abusive discovery request, that the court put the burden on them to have Dr. Blake come out of hiding and testify that there's some deficiency in his photos, and we'll do it on a photo-by-photo basis. We have wasted valuable days. Well, I mean, I think the legal process calls for something like that, Your Honor.
No.
I know it's real easy to say, well, no, just give it to him, but I don't think the process calls for that, Your Honor.
No, what struck me, Mr. Harmon, is I can see myself having to start another one of these hearings and having to look at all these photos. And
Well, but if the process calls for that, we may have to do that, Your Honor. I think it's real simple to just say, give them new copies I mean, we have shut down the state lab to satisfy Dr. Blake's schedule. You know, if you've ever done lab
Mr.
work.
Harvin, you're just misinterpreting the court's oy vey reaction.
No, I just wanted to make sure that I didn't misinterpret it, Your Honor.
Okay.
But you know, they haven't shown that they've been deprived of anything, and the only way they can do that is to bring Blake out of hiding and put him up there.
Okay.
And they're not going to do that.
You know, very briefly, when their experts are called, they're going to have the pictures, and we'll be entitled to review them. I'm just trying to save some time here because we may want to make blow-ups of their pictures, and if we don't get them until the witness testifies, it's going to cause a time delay.
All right. The issue, though, is access, knowledge, disclosure. You've had that. Request is denied. All right. Thank you, counsel. We're in recess. 1:30.
Statements earlier this morning concerning his representations that were trying to prevent him from telling the truth, and that is such a falsehood. If Mr. Cochran were standing up and telling the jurors the truth and had not hidden his witnesses from us willfully in violation of this court's order, we would not be before the court today. An opening statement would have been concluded, and a witness would have been on the witness stand. Unfortunately, because of the nature of this misconduct, which is egregious and flagrant, and not the minor violation that he attempts to represent to this court, he's attempting to sweep it under the rug, claim ignorance, and use Mr. Douglas as a sacrificial lamb, and that is absolutely inappropriate. That counsel should bear the brunt of his own misconduct, which was willful and deliberate and intentional, and is in effect a thumbing of his nose at this court's order. It is, yes, it's couched in nice smiles and ingratiating remarks, but that should not deceive the court, and I'm sure it doesn't. What lies behind it is a willful desire to flout the law, and it violates the law. It violates us both legally and morally. Legally, it's a violation of 1054 in both spirit and letter of that law. Legally, it's a violation of this court's direct order to counsel, and morally, it's a violation of the jurors' right to the truth. They've been lied to, they've been deceived, they've gotten half-truths from counsel. He has deliberately shown them items that were taken out of context, given them half-truths, giving them actually pieces of statements that led to a diametrically opposed representation of what really was being stated. And counsel is telling the court, oh, that's no big deal. If I mislead them, then the people can come back in closing argument and redress all the wrong. Counsel knows very well that we cannot, because our closing arguments are months down the line, and well, he knows it. Counsel has very carefully and very cynically weighed the risks and the benefits of his misconduct, and he has rightfully assured himself that the risks, if any at all, are far outweighed by the benefit. These jurors have now heard statements and representations of counsel about witnesses that the people were never informed of, that the people could have addressed in their opening statement, and even could have called in their case in chief in order to show the jurors the kind of witnesses that will come forward in a case like this for the sole purpose of gaining celebrity. And Mr. Cochran willfully withheld their names, knowing that what he was going to do was cloak them with a false aura of credibility before this jury and sandbag the people so that we were unaware of them and unable to address them in our opening statement. He made statements concerning witnesses that might never appear because of fear, thereby cloaking a witness with credibility who would never appear probably because of fear of exposure, because they are not telling the truth. Instead, now he's created ideas and notions in the minds of these jurors that there are people out there that will not come forward that would be holding the truth, except for the fear of harassment. And that is not true. There's no evidence of that whatsoever. In fact, we have witnesses coming out of the woodwork who know nothing about the case, claiming to know something just so they can get involved. So counsel has committed numerous acts of misconduct. And for him to turn to us and say we're trying to get into his mind and we're trying to prevent the truth from coming out is outrageous, is disgusting, and is appalling to me as an officer of the court. He knows that is not the case. And to allow that kind of statement to be made, and in essence that is the statement that he made to this jury, is worse than appalling. It is no longer just a fear, Your Honor, that the people's right to a fair trial is going to be damaged. It is a reality. It has been damaged. It's not damage beyond repair because if certain admonitions are made, certain sanctions are undertaken, and we were able to present the witnesses, the truth will come out because our case is strong. And I'm not worried about our case. What I am worried about is the way these jurors are being manipulated so cynically. They're being told, for example, why didn't the people tell you about this witness? Why didn't the people tell you about that witness? There's a real simple answer for that. They hid those witnesses. How are we supposed to tell the jury about witnesses they never told us about? Witnesses that the court ordered them time and time again to divulge, and willfully they told this court they had no such witnesses. 7 months old these statements are. 7 months old these names are. And only on the very day of his statement to the jury do we find them out, and at the close of the day, no less. Mr. Darden will address that further. I'm going to address the court solely on one aspect at this point, and that is that we are going to ask the court, at first blush, before opening statements are resumed, to admonish the jury, to tell the jury that they are to disregard the statements made by Mr. Cochran concerning the witnesses that were improperly withheld from the prosecution, and to admonish the jury, in effect, that the withholding of that information was misconduct, was in violation of a court order, and in violation of the law that requires both sides to exchange their witnesses and their statements. The other problem is that, Your Honor, I know the defense is arguing, well, we gave them the names of the witnesses. Yes, they gave us no address, they gave us no phone number, and they gave us no statement. Having a blank name on a list of 200 gives us no clue as to what that person might say and whether or not they should be high priority in terms of our investigation. They stand before this court repeatedly saying ridiculous things like, oh, there's 900 lawyers in the DA's office. Yeah, there's also 80,000 cases in the DA's office. Believe it or not, they're not all working on Simpson, nor can they. And there may be 9,000 officers, but guess what? They're not all working on the Simpson investigation either. They can't. Everybody is way overloaded. We have to prioritize. And for them to give us a name with no address, no phone number, and no statement on a list of 200 that contains a lot of bunk that we know they're not going to call is disingenuous and a fraud upon this court. We could not possibly have investigated these people, and to give us these late statements is outrageous misconduct. So we ask that the jury be informed of that fact, that counsel's remarks that relate to the mentioning of those witnesses, either by name or by content of their statement, that they are ordered to disregard them because they were mentioned in derogation of a court order. We are also asking that the court admonish the jury concerning the representations of counsel about witnesses that may not appear due to fear, that there is no such evidence whatsoever. Such remarks made by counsel were improper, and they are stricken from the record, and the jury should be ordered to disregard them. Furthermore, the people will be requesting some additional time to conduct investigation on the numerous witnesses that we have just been given at the close of opening statement day yesterday, as well as the day before. And should the court grant us the continuance in whatever amount of time that it does, we would ask that the court inform the jury as to the reason for the necessity of that continuance, that it was necessitated by counsel's misconduct in failing to turn over the information that it was ordered to turn over by the court. Mr. Darden will address the court on the remaining requests we have pertaining specifically to each witness and to our request to reopen the opening statement.
Mr. Darden. Good afternoon, sir.
Your Honor, good afternoon. Many of the witnesses disclosed to us by the defense the past 2 days are witnesses whose statements had not been given to us on any prior occasion. And the first is Mary Ann Gersh. And as the court will recall, Mr. Cochran told the jury that Mary Ann Gersh saw 4 men running from the scene of the killings on the night of June 12. We have never been given any discovery relative to that witness, that is, until yesterday. And that was given to us after Mr. Cochran already made comments regarding this witness before the jury. Now, this is obviously a material witness, one would think. That is, if one could believe her testimony. Mr. Douglas had this statement in his possession. The defense has had the statement in their possession for several months. Since July. They could have given it to us back in July. They could have given it to us back in December when they were squawking about our discovery problems and while they were asking the court to sanction us. But they didn't do that. They didn't do that throughout that 5-month period in 1994. And in December, when the court began to attempt to set a date for opening statements in this case, the defense didn't turn over this statement. And when they learned the exact day that opening statements would begin, they didn't turn it over. And when Mr. Cochran's opening statement was delayed a day, they didn't turn it over. And when they came into court to begin Mr. Cochran's statement, prior to that statement, that morning, they didn't turn it over. And there's only a few reasons that they didn't. First, they knew that had they turned over this statement this late in the game, the court would have precluded them from utilizing the statement in opening statement. The court would have sanctioned them, as they did us. And they were also aware that had the prosecution known about this particular witness, we would have discredited her. We have only known of this witness 24 hours, and already we know she has 9 lawsuits pending. In the DA's office, in our bad check section, there are $10,000 approximately in bad checks that relate to this person. She has defrauded the J.W. Marriott Corporation of $23,000 by staying in their hotel and not paying for it. And there's much more, much more regarding this witness, but we need time to investigate this witness, Your Honor.
What's your reasonable estimate as how long you need to investigate into the background of Ms. Gerchis, since People versus Jackson at 15 Calap 4th, 1197 at page 1203 indicates what the remedy is: having a meaningful opportunity to rebut or impeach. So what are we speaking of in terms of investigation to adequately be prepared to rebut and or impeach that testimony or that proffered testimony? That's the issue.
Your Honor, we are concerned that perhaps this witness is not the person she claims to be. That she is not the person. She is not the real Marianne Gerchis. There is a hint that perhaps she is not that person, and we're concerned about that. And she is such a critical witness, apparently, to the defense, that I believe it would take approximately 30 days to carefully search out the background of this individual.
All right, do you have any other comment as to this witness?
Well, in addition to the sanctions mentioned by Ms. Clark a moment ago, and in addition to a 30-day continuance to carefully investigate this witness's background, I would ask that the court strike any reference to this witness from Mr. Cochran's opening statement and advise the jury that the court is doing so because of Mr. Cochran's willful and flagrant violation of the rules of discovery. In addition, I think that the prejudice that the people have suffered as a result of this flagrant violation, this willful violation, this egregious conduct, that the prejudice is so extreme, I believe that the people should have an opportunity to reopen their opening statement.
Do you have any authority for that proposition?
There is no case law directly on point, Your Honor. However, the court does have discretion in terms of the order of proof. And under 1054.5b, the court has the discretion and the right to order any lawful remedy or legal remedy available to rectify the harm caused us by the defense in this case.
But
to reopen would be only fair.
How does that dovetail to 1093, setting the order of trial in the ordinary criminal matter? Do I have the discretion under 1093 to alter that to allow you to reopen?
I believe so, Your Honor. 1093 says that the proceedings shall proceed in the following order unless otherwise directed by the court. I ask that the court allow us a second opportunity. There is no law against it. It is not our fault that we're in this position. Back in December, you ordered us to provide the defense with discovery. You literally forced us to work 48 hours straight almost to comply with that discovery order. You told us to have discovery to the defense by 5 o'clock on a Friday afternoon, and we worked and we complied. Had we come into court and did what they did and tried to pull something like this, our conduct back in December, which as I recall the court agreed was nothing more than negligent, wasn't nearly as egregious as what has happened in this case. And in response to our mistake, an honest mistake at that, the court gutted the domestic violence evidence in terms of how it could be presented in the case. The court precluded us from calling witnesses in the order we wanted it to call those witnesses, so that now the defense has a hand so deep in our pocket at this point that they're literally dictating the order in which the witnesses will be called by the prosecution. Such sanctions ought to flow both ways, Your Honor.
Well, that's why it's called reciprocal discovery.
That's why it's called reciprocal discovery, and that's why it's a two-way street, and the water should flow both ways and in both directions. We had to do it. I'd like to put my hand in Mr. Cochran's pocket at this point. It's only fair. He created this situation. He didn't have to allow this to happen. The next witness is Dr. Carrie Mullis, an apparent DNA expert on PCR. Prior to the opening statement, we received no statement or report regarding this witness. I have not had a lot of time to search all the documents given the event of yesterday evening.
Was Dr. Mullis on any of the witnesses' lists for the Kelly hearing?
Well, one of the things we did with regard to the DNA hearing and the witness list is this. After they allegedly waived their Kelly cry, we updated our witness list to include the people we intended to call on a DNA issue. This doctor is not on any non-Kelly Fry witness list. And even so, we've never received any report or any statement relative to what this doctor would testify to. We require time to investigate this witness's background. I don't know much about him, but I understand that he is a very controversial figure in the scientific community. We need time to gather transcripts of his prior testimony. We need time to review the scientific literature, to review his background and his training. As the court is aware, that can be very difficult to do. Not anyone, and not just everyone, can perform a task like this as it relates to a scientist such as Dr. Mullis, and it's going to take time. It's going to take about 30 days. We would ask that the court, in addition to the admonition, instruct the jury to disregard any mention of this witness. I would ask the court to allow us to reopen our opening statement. And that's to Dr. Ron Fishman, Your Honor. We are somewhat acquainted with Dr. Fishman. In fact, I met Dr. Fishman, but unfortunately I didn't have a subpoena on me when I met him. I did, however, cause a subpoena to be issued for Dr. Fishman's appearance in this case. We have been attempting to serve Dr. Fishman and to speak with Dr. Fishman since December 14. We believe that if Dr. Fishman were honest and called to testify and testified honestly, we believe that he would testify that as Nicole Brown left the recital on June 12, he overheard this defendant say, "I'm going to get her. I'm going to teach her a lesson." and words along those lines. And so we have telephoned him, and we have gone to visit him, and we have attempted to serve him. And on January 19, 1995, our investigators were outside Dr. Fishman's home. They met. They told him they were there to serve him with a subpoena. Yes, as they were running to the elevator. Here, have some more discovery. They gave us 2 reports just that way yesterday.
That's not correct, Your Honor. Well,
Wait your turn, Mr. Douglas.
we'll get there. Mr. Darden, all right, what is the date on this witness statement?
Respect for him, as I've indicated. And I'm very concerned about his physical condition, and I hope that he'll get well soon, and I'm very concerned about it. I've discussed that with our client. But talk about sanctions. When have you ever seen a case, Judge, where
Do you solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please be seated and state and spell your first and last names for the record.
My first name is Sharon, spelled S-H-A-R-Y-N. Last name is Gilbert, G-I-L-B-E-R-T.
Thank you, Your Honor. Good morning, Ms. Gilbert.
Good morning.
Ms. Gilbert, who do you work for,
Los Angeles Police Department.
and what is your job title?
I'm a police service representative.
And are you also a 911 operator and dispatcher?
Yes.
Okay. And were you a 911 operator and dispatcher on January 1, 1989?
Yes, I was.
And were you on duty between 3 and 4 o'clock in the morning on that date?
Yes, I was.
And on that date, and during that time period, did you receive a telephone call?
Yes, I did.
And where were you physically located at that time?
I believe I was sitting on console 41. It's indicated on my incident, the console that I was sitting on.
Okay, so you're sitting at console 41.
Yes, which is what we determine as a primary position, and primary is 911.
Okay. Now, is console 41 located in a private office?
No, it is not.
Is it located in a cubicle?
No, we don't sit in individual cubicles. There are approximately 5 consoles side by side, all connected together.
I take it that there's a telephone of some kind in front of you?
Each console has its own telephone, and it sits to the left of each operator.
And are you provided with earphones?
Yes, we have headsets, individual headsets.
And are you also provided with a keyboard?
Yes, we have 2 computer screens and a keyboard for each console.
Okay. If you will, take us through the process and procedure that occurs whenever you receive a 911 telephone call. Okay. The call comes in and you answer it, correct?
Yes, when you're plugged in, we have what you call an in button. It stays in all the time, ready for a call to what you say drop in. And we have an indicator on the panel to the left that shows the address and phone number where this call is originating from. And it also comes in on my computer screen, which is the left computer screen considered as our status screen.
Okay. So whenever you receive a 911 call, a display comes up on the console that indicates the origin of the telephone call?
Yes.
The address from which the telephone call originated?
Yes.
And that same information comes up on another screen?
Comes up on our status screen.
You know, I have here a single-page document. It appears to be some form of a 911 dispatcher's log. I provided Mr. Cochran with a copy, may it be marked People's 2.
All right, People's 2 for identification.
Ms. Gilbert, showing you what has been marked as people's tooth identification. Do you recognize that document?
Yes, I do.
May I have one moment? I also have a copy of the document on the Elmo machine. May we project it on the screen, please?
Yes. Certainly. All right, thank you, Counsel.
May I proceed, Your Honor?
You may.
Ms. Gilbert, what is the
Hold on. Take it down.
what is the document marked people's tooth identification?
It's a incident form, what we determined to be an incident format.
Okay. And how was that form created?
On my working screen, which is the screen to my right that's directly in front of me, we have a format that allows us to create an incident by the computer by inserting certain commands. And I like to make a correction. It shows that I was on console 54. On the top line, it shows the time that I got the call, and the top example here is my update, so I need to drop down to the bottom. It shows the top line, shows the call came in at 3:58. It has my operator number. It shows the console that I was on and the incident number created.
Now, does the form also provide a space for you to add comments?
Yes, it does.
And did you add some comments to that form in this situation?
Yes, I did. That's where it shows in
Overruled.
it shows the update of my incident in the top example, and that was after I entered the comments.
And you did add those comments to
Yes.
this form. And the comments that you added to this form, were these comments based on your perception, your hearing?
Yes, it was.
May I, Your Honor?
You may.
On the screen. Looking at the bottom one-third portion of the form, and I'm going to ask Mr. Fairtlow, can you zoom in closer?
Yes.
This is that underlying, what's the mark?
Overruled, same document.
What time did you say you received the telephone call?
3:58.
In 3:58 in the morning?
Yes.
And does the incident report indicate the origin of the telephone call?
No, it just shows I have the ability to update it, and I have the ability to update the incident type. When I first got the call, I had it as an unknown trouble.
Okay. Okay, so the call came to you, right?
Right, it was the open line.
Okay, and could you hear anything over the open line?
No, at the beginning, no.
Okay. Did the line remain open?
Yes, it did.
And while the line was open, at any point in time, could you hear anything?
Yes, I did.
And what did you hear?
At first, I heard a female screaming, and that's when I went back and changed my incident type from unknown trouble to a screaming woman.
And did you hear anything else?
Yes, I did.
And what did you hear?
I heard someone being hit.
You heard a noise that you associated with someone being hit?
Yes.
And what did you do with that information?
That's when I went back and updated it to in the fact that I heard a female screaming, and then I heard what I thought was a slap. I went back and updated it as a female being beaten at the location to give the responding officer an indication of what was going on, that it was no longer unknown trouble.
In fact, you indicated that a female being beaten at location could be heard over the telephone.
Yes.
What was the next thing that you did after you updated the incident?
I brought up the necessary frequencies to broadcast it bureau-wide and for the air unit to assign a unit.
And did you assign a unit?
At the time I dispatched it, either there weren't any units available or I did an immediate dispatch, and I just broadcast it to West LA units.
And is there something called a call priority or priority code in terms of dispatching units to certain types of incidents?
Yes, it is. It's indicated to the right, far right. You see a C/P and a 2/H. That means code too high. And for the police department, that means a hot shot. That means immediate response.
You mentioned a moment ago that the telephone line was left open. Is that correct?
Yes.
Can you tell us how long that line was left open?
Well, only can go by my incident that I created, that the call came in at 3:58, and I updated it at 4:01. So I stayed on the line at least 3 to 4 minutes.
Okay. So the line was open then, 3 to 4 minutes?
Yes.
And the screams that you heard, you say that those screams were the screams of a woman?
It sounded like a female to me.
It didn't sound like a man?
No.
Could you tell who was being hit or struck or slapped?
No, I could not.
Oh, she indicated no, she couldn't tell. Interesting.
Are 911 calls recorded by the LAPD?
Yes, they are.
And have you listened to the 911 call you received at 3:58 in the morning on January 1, 1989?
Yes, I have.
And when was the last time you listened to that tape?
Approximately a week and a half ago.
And when you listened to the tape a week and a half ago, could you hear slaps or strikes?
Overruled. You can answer the question.
I could, in remembering the call, I could determine after the first scream, then I heard someone being hit.
Thank you. With the court's permission, Your Honor, I'd like to play the 1989 911 tape.
All right, you have that identified as an exhibit.
Yes, it's been marked People's 1.
All right.
Emergency operator 461. Hello? You calling from 360 North Rockingham, apartment number B? Emergency operator 72. Okay, please
So from Wilshire, Normandy at the highest. Suspect one is a male black. 5'10", 150 to 1.
Ms. Gilbert, is that a tape recording of the telephone call you received at 3:58 a.m. on January 1, 1988?
Yes, it is.
And there's more to the tape, is that correct?
Yes.
Okay. And when you listened to the tape last week, did you hear your voice on the tape?
Yes, I did.
You testified a moment ago that you dispatch your units to 360 North Rockingham?
Yes.
Okay. Is that on the tape?
Yes, it is.
Did you indicate that you dispatched units to 360 North Rockingham, apartment B?
Yes, it is indicated on there.
Could you explain to us why you included the apartment B directly?
When I first created the incident, I had not erased my screen from a prior call that I determined not to dispatch on, and had not erased the apartment number out of the field. When I went back and hit enter on a computer, it erased everything but the correct location that came up on the ANI, on the telephone console.
Now, we hear other voices, male voices, and apparently other dispatchers in this tape. Is that correct?
Right.
Those other voices, those male voices, those dispatchers, where is that noise originating from?
From people sitting beside me. There's people that sit behind me. Also, I had brought up the frequency to broadcast the call, and you were hearing the other divisions that were on the air because it was an open line. As long as I had not hit my transmit button, then you will hear all that.
And the comments you typed onto the incident report mark people's tube identification, where you indicate that you can hear a female being beaten. At what point in this process did you type that information onto the report?
After I had made my incident and made it a screaming woman, and hearing is just, you get excited, you hear all of it at one time, and I went back and typed it in after that, after I had created the incident.
Okay. And is this while the telephone line is open?
Yes, I left it open.
So it's during the telephone call then that you typed in the comment about you're hearing a woman being beaten?
Yes.
Okay. Did the caller ever speak to you directly?
No.
Thank you. That's all I have.
Thank you.
Mr. Carpenter?
You can leave that up if you would. Yamo. Good morning, Ms. Gilbert.
Good morning.
I'd like to ask you a few questions if I might. The date of this incident was back in 1989, is that correct?
Yes.
That was January 1st?
Yes.
Was that January 1st, 1989 at about 3:58 in the morning, so that would be New Year's Day morning, is that correct?
New Year's Day morning,
All
yes.
right. As I understand what you've indicated to us, you received this call through the open line, is that correct?
Yes.
And you were sitting at your console, and being 911, you started to pay attention to that call, to listen to it, then you made some reaction, is that correct?
Right.
Now, from what you told Mr. Darden, you never had one of your colleagues?
That's one of my colleagues.
All right. Now, at some point, you type into, and you describe for us, that you type into your computer, female being beaten at a location could be heard over the phone. And that was what you concluded after you heard this woman screaming, is that right?
Yes.
And you don't know whether there was a mutual fight or what was going on, do you, at that point?
No, I do not.
All right. So you just wrote, what you wrote down was what you concluded at that particular time, is that correct?
What I concluded that I heard.
All right, and that was back in January of 1989, right?
Yes.
You never at any time talked to any of the parties who were actually at that house?
No.
Mr. Mulder, your honor.
Certainly.
Yeah, just a moment more. Right?
That's correct.
All right. Thank you very kindly.
You're welcome.
All right, Ms. Gilbert, you may step down. Thank you very much.
May you be excused, Your Honor?
Yes.
Did you have a police vehicle?
Yes.
cause no opinion before this court. To give the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please be seated and state and spell your first and last name for the record.
John Edwards, EDWARDS.
Mr. Dart.
Thank you, Your Honor. Good morning, sir.
Good morning.
Sir, on January 1, 1989, were you employed by the LAPD?
Yes, I was.
Okay, and what is your present rank today?
Detective, Van Nuys Homicide.
Okay. And what was your rank and assignment on January 1, 1989?
Training officer for West LA Patrol.
Okay. So you were a patrol officer?
Yes, I was.
At West LA Division?
Yes.
Does West LA Division cover Brentwood?
Yes, it does.
Okay. Now, did you have a particular unit designation on January 1?
Yes, I was 8 Adams 69. I was assigned to an area around Cadillac and La Cienega.
Okay. And you say that you were a training officer?
Yes.
And what is a training officer?
Training officer trains new recruits out of the academy who are assigned to the field in the various aspects of police work and standard operating procedures of the police department.
Okay. And were you accompanied by a rookie trainee?
Yes, I was.
And who was that?
Patricia Milowiski.
How do you spell that?
It's M-I-L-W-I-S-K-I, I believe. I have the spelling if you need it.
And were you on duty between 3 and 4 a.m. on that date?
Yes, I was.
Were you in uniform?
Yes.
Was your partner in uniform?
Yes, she was.
Did you have a police vehicle?
Yes.
Was that a plainclothes vehicle?
It was a black and white patrol car.
Okay, so it had LAPD to protect and to serve and all of that on the doors?
Yes, it did.
On that date around 4 o'clock in the morning, did you receive a radio call?
I believe it's around 3:30 in the morning.
Okay. Do you know the exact time?
Not really, but I thought it was somewhere around 3:30, 3:40, somewhere in there.
Okay. But you did receive a radio call?
Yes.
And what was the nature of that call?
It was a 911 radio call at 360 North Rockingham. Woman being beaten. The operator could overhear it in the according to the comments, the operator could overhear the woman being beaten on the phone.
And where were you, if you recall, when you received that radio call?
I was somewhere in the general area of La Cienega and Cadillac, Robertson, in there, near the freeway.
And did you proceed to 360 North Rockingham?
Yes, I did.
How long did it take you to get there, if you recall?
Less than 10 minutes.
A moment ago, you testified that you had a specific or particular unit designation. Is that correct?
Yes.
Were you also assigned a particular or specific patrol area?
Yes, I was.
What was your patrol area?
It was from basically Venice Boulevard to Olympic and basically Robertson to La Cienega.
So 360 North Rockingham then was out of your normal patrol area?
Yes, quite a ways.
Had you ever been to 360 North Rockingham, that is prior to January 1, 1989?
No, I had not.
Had you ever met the defendant here, seated at the end?
No, I had not.
So you and your partner proceeded to that address?
Yes.
Tell the jury what happened next.
Well, when I arrived in the Sunset Rockingham area and went into the hills on Rockingham, it was dark, it was misty, it had been raining earlier in the evening, and as I went by the first part of the estate, I was not aware that there was a gate on Rockingham. I passed it, and I ended up on the next gate, which I believe is on Ashford, if I'm not mistaken, an electronic gate, and I stopped my black and white patrol car there and noted that it was a locked security gate with a little call box out front with a button.
Did you get out of the car at that time?
Yes, I got out of the car and pressed the button and waited for someone to speak to me, and a female came over the speaker, said she was the housekeeper, that her name was Michelle, and that she wanted to know what I wanted. And I said, well, I had just responded there on a 911 call. A woman had been beaten.
Sustained. All right, ladies and gentlemen, you're to disregard the last statement regarding what the housekeeper said. All right, Mr. Darden.
What was your response to the housekeeper?
I told her that I was there on a 911 call, that a woman had placed a 911 call and said she was being beaten, and that the operator could hear her being beaten over the phone, and that I needed to see and talk to the person who made that call.
Okay. Did the person you spoke to, Michelle, did she allow you entry into the compound or estate at that point?
No, on the contrary, she said that there was no problem there.
What did you do?
I told her I was not leaving until I saw the person that made the 911 call.
What happened next?
Then a woman came running out of the bushes to my left, crossed the driveway. She was a female Caucasian, blonde hair. She was wearing a bra only as an upper garment, and she had on a dark, I believe it was a dark, lightweight sweatpants or night pajama bottoms. And she ran across and collapsed on the speaker, the identical kind of a speaker post on the inside of the gate. She collapsed on it and started yelling, "He's going to kill me, he's going to kill me." Then she pressed the button, which allowed the gate to open. And then she ran out again yelling, "He's going to kill me."
Did you have a flashlight with you at that time?
Yes, I did.
What was your reaction? How did you react when you saw this woman run out of the darkness in her bra and night clothes?
Well, she seemed to be exhausted.
Sustained. Jury's order to disregard the last question and answer. Mr. Darden, answer the question again, please.
What was your response when you saw this woman running toward you, screaming, "He's going to kill me, he's going to kill me"?
I illuminated her briefly with my flashlight and then illuminated the bushes around her and near her and as much of the house as I could.
Did you see anyone else at that time?
No, I didn't.
What was her demeanor as she ran toward you, shouting, "He's going to kill me, he's going to kill me"?
She was hysterical.
And you say that she pushed the button to the gate?
Well, she had pushed it more than once. She pushed it 3 or 4 times like she was panicking. Several times she kept pushing it.
And did the gate open?
Yes, it opened and she ran out to me. I didn't enter.
Okay. And what happened when she ran out to you?
She clung on to me and then made several statements to me at that time.
Now, you say that she ran to you and clung on to you?
Well, she collapsed on me.
She collapsed on you?
Yes.
And what was her physical demeanor and physical appearance at that time?
Well, she was wet. She was shivering. She was cold. I could feel her bones, and she was real cold. And she was beat up.
And at some point, did you identify this woman?
Yes.
Who was this woman that you...
Nicole Simpson.
What, if anything, did she say to you after she collapsed?
She said he's gonna kill me. I said, well, who is gonna kill you? She said, OJ.
And what did you say?
I said, well, I was a little surprised.
Sustain. Officer, if you would, just answer the question.
Yeah.
Mr.
I
Darden.
said, OJ who? Do you mean the football player, OJ, the football player? She said, yes, OJ Simpson, the football player.
A moment ago, you said that as you saw this woman, Nicole Simpson, running towards you, that she seemed hysterical. Is that correct?
Yes.
Was she still hysterical as she clung on to you?
Oh, yes.
And was she hysterical when she told you that it was O.J. Simpson?
Yes.
How many times did you hear her shout, "He's going to kill me, he's going to kill me"?
4 or 5 times.
What, if anything, did you say to Ms. Simpson after she told you that the person who was going to kill her was O.J. Simpson?
Well, at that point, I was a little concerned about the possibility of...
Sustained. Officer, if you would, listen carefully to the question. Answer only the question that's being asked of you.
Yes,
Mr.
sir.
Darden. Thank you.
May I ask another question, Your Honor?
You may.
Okay. What were your concerns at that point, Detective?
That if someone was going to kill her, the person may have a weapon. It may come out any second.
Did you ask Ms. Simpson anything at that point?
Yes, I asked him if I asked her if he had any weapons. And she said yes.
Overruled.
Did she say what kind of weapons he had?
She said he had lots of guns.
You testified a moment ago that you had in your hand a flashlight. Is that correct?
Yes.
Did you illuminate Mrs. Simpson's face at all at that time?
Yes, I did.
Nicole Simpson?
Yes.
Did you notice any injuries at all on her face?
Yes, I did.
What were those injuries?
She had a cut approximately 1 inch, I believe, on her left upper lip. She had a swollen right forehead, and I believe her left eye or right eye was starting to blacken. It was swollen, and she had some sort of an imprint or some sort of a swollen mark that you could see on her cheek. I believe that was also on the right cheek, and she had a hand imprint on her throat, on the left side of her throat.
You saw a hand imprint on the left side of her neck?
Just the fingers.
Overruled. Answer the same.
Did you ask or pose any question to Nicole Brown at that time?
Yes, I asked her what happened to her face.
And was she still hysterical at that point?
Yes.
What did she say?
Overruled.
She said that O.J. had slapped her, hit her with his fist, and kicked her, and pulled her, I think pulled her by the hair.
What happened next, Detective?
I had my partner put her uniform jacket on her because she was shivering so bad, and had her placed in the right rear seat of our patrol vehicle.
And where was your partner at that point in time?
After Nicole was placed in the right rear seat of the patrol vehicle, my partner got in the right front seat of the patrol vehicle, and I told her to start taking a crime report. And she got the preliminary investigation report, put it on a notebook, and at that point, Nicole was repeating things rapidly.
Okay. Now, you indicated earlier that the gate opened after Nicole hit the button 4 or 5 times?
That's correct.
Did the gate close after she exited through the gate?
Yes, it did.
Did you enter the compound or the estate at that time?
No, I did not.
You remained on the outside?
Yes.
And as you placed Nicole Brown into the police vehicle, was she still hysterical?
Oh, yes.
Was she still shaking?
Yes.
And did she say anything at that time?
Overruled.
Did she say anything at that time, Detective?
Yes, she made a series of spontaneous statements prior to us attempting to ask her any questions.
What did she say?
She said, you guys never do anything, something to the effect of, you never do anything about him. You come out, you've been out here 8 times, you never do anything about him. And she says, I want him arrested, I want my kids back, I want to go in the house.
Had you been out to 360 Rockingham, North Rockingham 8 times prior?
Overruled.
No, I had only been in the division for...
Overruled. Overruled. He can answer that way.
I'd only been in that division for a very short period of time, and I had never been on that street.
And did you respond to Nicole Brown when she said, you guys have been out here 8 times before and you never do anything?
Not much I could say about that, no.
What happened next, Detective?
I told my partner to hand her the preliminary investigation report, and I asked her if she would sign a crime report against O.J. Simpson. She said yes. She grabbed the notebook from my partner and the pen, and she signed her name on the document without even looking, and as fast as she could.
What happened next?
Then I turned my attention back to the gate as my partner was getting the rest of the details for the report. and I saw Mr. Simpson walking towards me from the house wearing a bathrobe.
When you say Mr. Simpson, you're referring to the defendant seated here in court today?
Yes, O.J. Simpson wearing the gray jacket, suit jacket.
Indicating the defendant. All right, Mr. Darden, do you have much more?
Yes.
All right, ladies and gentlemen, we're going to take a 15-minute recess. Please remember my admonition to you, don't discuss the case amongst yourselves, form any opinions about the case, or allow anybody to talk to you. This will be a 15-minute recess, and I'm going to ask you to step back into the jury room, and we will resume at 11 o'clock.
And no shoes.
And did you still have your flashlight in your hand?
Yes, I illuminated him with a flashlight as he approached me.
And you shined it in his direction?
Yes.
Okay. Could you see his face at that time?
Yes.
You could see the defendant's face?
Yes, it was O.J. Simpson.
Were you still outside the gate?
Yes, I was outside the gate.
And the defendant, which side of the gate was he on?
He was on the inside of the gate on the driveway.
Okay. So the gate was between you and the defendant?
Yes.
Okay. Is there a wall or a fence at all around this compound or estate?
Yes, there is.
Okay. And how high is the wall and the fence?
I think it's about 6 feet from my remembering it. It's about 6 feet high.
And when you saw the defendant, he was walking, is that right?
Yes.
In what direction?
He's walking directly towards me and the gate.
Okay. Now, where was Nicole Brown in proximity to you?
As I was facing the gate, she was to my right in the patrol car, which was behind the wall.
So you were between the defendant and Nicole Brown, is that right?
That's correct.
When you shined your flashlight in the direction of the defendant's face, did he seem angry at all?
It's a leading question. Why don't you rephrase the question?
When you shined your flashlight in the defendant's direction, what, if anything, did you notice about his face?
He seemed furious.
Even he has to laugh. I'm the counsel has to laugh. The witness to testify now, Mr. Darden.
Mr. Darden? All right,
You saw the defendant's face?
Yes.
What was his demeanor at that time?
Better question.
Thank you.
You're welcome.
He seemed very furious.
Did he say anything at that time?
No, he was still approaching the fence.
Okay. And how would you describe his pace or his gait or his walk at that time?
It was rapid and deliberate.
Toward you?
Towards me.
Were you concerned for your safety at that point?
Overruled.
I illuminated his hands in his waistline area for any possible weapons because of statements made to me about him having lots of guns.
Okay. Did you notice the defendant carrying a gun at that time?
I could see no weapons in his hands, and his waistband was clearly visible, and I saw nothing in his waistband area.
What happened next, Detective?
The defendant approached directly to me at the gate where he was on one side and I was on the other. We were at close proximity. Then he appeared towards the black and white police vehicle and he started making some statements.
And when you say the defendant peered toward the black and white police vehicle, you're saying he looked toward your police car?
Yes.
Okay. And where was Nicole Brown at that time?
She was seated in the right rear seat of the patrol vehicle with the door closed.
And would that be the side of the vehicle closest to the gate?
Yes.
And you say the defendant started saying things?
Yes.
And what was his tone of voice as he said those things?
Extremely angry and loud and rapid.
What did the defendant say at that time?
Said, I don't want that woman in my bed anymore. I got 2 other women. I don't want that woman in my bed anymore.
Now, did he say this? Or did he shout it? Or
He shouted it, I believe, twice, and he pointed at her. Well, he pointed at my patrol vehicle while he was making the statement.
did you realize at that time that the woman in the patrol car, Nicole Brown, was the defendant's wife?
Yes.
Her name is Nicole Brown Simpson.
At that time, yes, that's correct. Mr. Dart.
And so he shouted more than once at Nicole?
Yes.
Did she respond at all?
She was, I believe the dome light was on in the patrol vehicle, and she was talking to my partner.
Okay. Did she appear to react at all?
At that point, I didn't turn around and look back at her. I did a sidestep to get between the two of them.
Did you note any reaction at all or any response to the defendant's statement that I don't want that woman in my bed anymore, I have two women?
From the victim?
Yes, from Nicole.
No, I don't believe I did.
And when you say victim, are you referring to Nicole?
Yes.
Did you respond to the defendant after he made these statements repeatedly?
Yes, I did.
What did you say to him?
I tried to make eye-to-eye contact with him to focus him to me, because I was talking to him. And after a short period of time, I was able to get him to focus on me.
Okay.
And
well, let me interrupt you there. Where was the defendant focused during the meantime?
On the rear of my patrol car.
And once you were able to get the defendant to focus on you, did his demeanor change at all?
He did. He slowed down, and his temperament dropped down enough to where I could talk to him.
And did you and he have a conversation at that point?
Yes.
What was that conversation?
I told him that Nicole had obvious physical injuries to her face, and that she said that he had hit her, and I could see trauma and open wounds to her, and that she wanted him arrested, and I was going to have to place him under arrest for spousal battery.
Now, you testified a moment ago that his temperament had changed.
It had dropped enough to where he was now looking at me, and it appeared we could communicate.
Okay. And did his temperament and demeanor remain the same as you told him that Nicole wanted him arrested for beating her?
No, it flared up back to a very loud, furious, angry mode again.
And did he say anything at that time?
He said, if I remember, he said, I didn't hit her. I just pushed her out of the bed, I believe.
You did write a report regarding this incident at some point, is that correct?
Yes.
Okay. And are you certain as to what the defendant said at that point in time?
No.
Okay. Did you describe the defendant's comments in your report?
Yes, I did.
And would it refresh your recollection if you were to read your report, that is, as to what the defendant said specifically at that time?
Yes.
May I, Your Honor? I'll show the page to counsel. Page 3 of the supplemental report.
You may.
Showing you page 3 of a supplemental police report. Do you recognize that page?
Yes, this is my handwriting, the report I filled out in 1989.
And directing your attention to paragraph 4, would you read that to yourself, please?
Yes.
Read that. Is your recollection refreshed, officer?
Yes.
What did the defendant say at that point in time? That is, after you told him that Nicole wanted him arrested.
He said, I didn't beat her, just pushed her out of the bed, nothing more.
What happened next?
Then I tried to explain to him again that I was going to have to place him under arrest for beating his wife. And then he made another statement to me.
Was he still angry?
Oh, yes.
And this next statement, the one you're about to describe, did he speak in a normal tone of voice?
No, he was extremely agitated, angry, and he was yelling.
And when he spoke to you the next time, was he yelling then?
Yes.
What did he shout or yell at that point?
He made, I believe it was basically two statements. One was, I believe this is a family matter. You've been up here 8 times before and never did anything before, and there was another statement. I can't remember exactly the phrase, but he emphasized that one.
Well, did you include that phrase in your supplemental report?
Yes, I did.
Would it refresh your recollection to see the report again?
It's been 6 years, I'm afraid it would.
Detective, let me hand you page 3 of your supplemental report. I'm going to ask you to read paragraph 6 to yourself.
Yes. Yes.
Is your recollection now refreshed?
Yes, yes it is.
By the way, in your supplemental report, did you include this particular comment in quotation marks?
I believe I did.
Okay. What did the defendant say at that time?
He said, you've been out here 8 times before, and now you're going to arrest me for this? And I remember he emphasized this. And he said, this is a family matter. I believe I said this. He said, this is a family matter and nothing more.
And did you respond at that time?
Yes, I believe I told him at that point that He was going to have to get dressed, and I was going to I would place him under arrest, and he was going to have to get dressed and come to the station with me when my supervisor arrived.
When you told the defendant that he was going to be arrested, were you still on the outside of the gate?
Oh, yes.
And was he still on the inside of the gate?
Yes.
And had he opened the gate or allowed you onto the property at that point?
No.
Had you asked permission to go onto the property at that point?
No.
You told him to go get dressed?
Yes.
Did you ask to accompany him back into the house as he got dressed?
No.
Did the defendant return to the house?
Yes, he did.
And what was the next thing to occur? What happened next?
Then I turned around to see how the report was going with my partner in Nicole Simpson, and I requested my supervisor to respond to the scene. And then suddenly I heard the gate open, and I saw somebody come through the gate. It was a female.
Could you describe this woman, please?
It was either a Hispanic or a Filipino lady. I can't remember, but she went directly to the right rear door of the police car.
And what did she do when she arrived at the right rear door of the police car?
She opened the right rear door and reached in and grabbed Nicole Simpson by the right arm and started pulling on her and saying something.
What did she say?
I believe it was Nick.
Sustained.
Your Honor, can we approach?
Sure. All right, thank you, counsel.
Thank you. Could I have the last question read back, Your Honor?
Certainly. Madam Reporter.
Question, what did she say? Answer, I believe it was the objection.
Thank you, Your Honor. The woman came out of the gate and went to the patrol car, is that right?
That's correct.
And you heard her say something?
Yes, I did.
And did you recognize that voice, that woman's voice at that time?
Yes.
You'd heard the voice before?
Yes, it was the woman on the speaker box that told me nothing was occurring in the house.
And this woman was pulling on Nicole?
Yes.
Did she speak with you prior to going over to the patrol car and grabbing Nicole and pulling on her?
No, she did not.
What did you do at that point?
I went over and grabbed her, pulled her away from the car, and closed the door after I saw and heard what she was doing.
Did you give her any commands at that time?
Yes, I advised her of 148 of the Penal Code, interfering with a police officer's investigation, and I told her to leave.
And did she leave?
Yes, she did.
Now, during the time that this woman was pulling on Nicole, trying to pull her out of the police vehicle,
Pulling on her. Rephrase it. Rephrase it, please.
where was the defendant during the time that this woman was pulling on Nicole?
He was inside the house.
What happened next, Detective?
After she went back inside the house, approximately 2 minutes passed, and O.J. Simpson came back out, now dressed.
The defendant came back outside the house dressed?
Yes.
And were you still on the outside of the gate in the wall?
Yes,
And was he still on the inside?
that's correct.
Did the defendant say anything at that time?
Yes, he reapproached the wall. This time he was on the other side of the brick wall itself, the block wall. He wasn't near the gate. He peered over the wall, and we had a conversation again.
What, if anything, did the defendant say at that time?
He said, "What makes you so special? Why are you doing this? You guys have been out here 8 times before, and no one has ever done anything like this before." Something along those lines.
And what was your response?
I said I was going to have to place him under arrest, and that the law required me to place him under arrest, and there's no ifs, ands, or buts about it.
Now, what was the defendant's tone of voice, that is, during this particular conversation?
Well, at this point, he wasn't quite yelling as much, but he was still very angry and hostile.
Overruled. Overruled.
Now, did you testify earlier that you'd already contacted the supervisor?
Yes.
Had you asked that supervisor to proceed to 360 North Rockingham?
Yes, I did.
And why did you ask that a supervisor be sent to the location?
Because I was going to have to somehow either get inside that house or the gated area, or I was going to have to convince the defendant to come outside to make the arrest. And I was by myself and my partner. We had a injured victim with us, and I just needed another person to help us.
And at some point, did you see a second police car?
Yes, Sergeant Vinger pulled up in a second patrol car.
And where was the defendant at that time?
He had been engaged in a conversation with me, peering over the wall next to the patrol car.
Okay, so you saw the patrol car arrive?
Yes.
Okay. And did you turn your attention away from the defendant at all at that time?
Yes, I did.
Where did you turn your attention?
I walked over to explain to the supervisor what we needed to do.
And when you did that, when you walked over to the supervisor, was the defendant still on the other side of the wall?
No, he had walked away from the wall.
Okay. What happened next?
As I was explaining to the supervisor what had transpired and what we needed to do, I saw a blue Bentley start up, the light start up, turned on, and it went out a driveway that I was not aware was there. It went out a driveway onto Rockingham, out another gate similar to the one I had been standing in front of, and the vehicle went southbound on Rockingham.
And how fast was that vehicle going as it left 360 North Rockingham?
I believe it was around 45 miles an hour, somewhere in there.
Were you aware that the defendant was leaving?
I had no idea that there was even a gate over there.
So you were surprised to see the Bentley leave the property?
Yes, I was.
Answer will stand.
How much time elapsed between your telling the defendant the last time that he was going to be placed under arrest and your viewing of the Bentley as it left the Rockingham address?
About a minute and a half.
Were you in your car or outside your car when the Bentley left the property?
Both the supervisor and myself were outside of both vehicles when this happened.
So So what did you do at that point?
We both re-entered our vehicles and pursued the defendant's Bentley.
Did you catch him?
No.
He got away?
Yes, he did.
During that pursuit, did you ever activate the red lights on your patrol car?
No, I didn't.
Did you activate the siren at all?
No.
By the time you got into your police vehicle and started your engine, could you still see the defendant?
No.
Could you still see his vehicle?
No.
Did you arrest the defendant that day or that night or that morning?
No, I did not.
Did you ever arrest the defendant?
Physically, no.
Where was Nicole? That is, where was she during the pursuit?
She was in the right rear of the patrol car wearing my partner's jacket.
I believe you testified earlier that Nicole signed the crime report?
Yes, she did.
And what does that mean? What is the significance of a victim signing a crime report?
Sustained.
What is the significance of Nicole having signed the crime report? What's the objection?
Sustained. Foundational.
Did you have a crime report at the location?
Yes.
Okay. Was that crime report handed to Nicole?
Yes.
Did she sign it?
Yes, she did.
Did you see her sign it?
Yes.
Did you see her signature on the document?
Yes.
Did you retain that document?
Yes, I did.
Strike that. Why did you have her sign the crime report?
Well, in our 273.5, you don't really have to have the signature, but this was her, whatever her statement was to us, when she signed the report, this is by law what she is representing as the truth.
You mentioned 273.5.
Yes.
Okay. What were you referring to?
Domestic violence, spousal battery.
Penal Code Section 273.5?
Yes.
You earlier testified to the injuries that you saw on Nicole's face and neck, correct?
Yes.
Okay. Did you offer her any medical treatment?
Yes, I did.
What did you offer to do?
I offered to drive her to a emergency room and get her treated right then and there.
And what was her response?
She said she wanted to go back to the house to her children. She wanted to be with her children.
Bless you. Did you ask her to go to the station?
I asked her if she would go, if I could drive her to our photo lab downtown and take pictures of her injuries.
And by downtown, did you mean downtown Los Angeles, Parker Center?
Yes.
And what did she say?
She said no, she wanted to go home to her children.
Did you offer her an alternative, that is to having her go downtown to take photographs?
Yes, I asked her if she would go to West LA Station and have Polaroid photographs taken of her real quickly.
And what did she say?
She agreed to that.
Now, had you taken her to Parker Center, would you have taken Polaroid photographs of her?
No, I would have had a photographer take professional photographs of her injuries.
And why did you want to take her initially to Parker Center as opposed to taking her to West LA?
Overruled.
Why did you want to take her to Parker Center as opposed to taking her to West LA?
Because I felt that her injuries needed to be documented properly on film.
You didn't think a Polaroid photo would be sufficient?
No.
Sustained. Answer stricken as being leading and suggested. Although perhaps self-evident. I think the jury knows the difference between a Polaroid photo and a hard film photo.
Did you take her to West LA Station?
Yes, I did.
Did you attempt to photograph her injuries?
I photographed her injuries myself.
And what kind of camera did you use?
Used a Polaroid 600, I believe.
Let me have counsel approach without the reporter, please. All right, ladies and gentlemen, during the course of the trial, I need to talk to the attorneys about whether or not you'll be able to view certain evidence. Primarily, sometime it has to do with scheduling, and it's easier for the 6 or 8 of us to walk over there and talk rather than have all 22 of you constantly going back and forth. So please be patient while we're doing that, and I appreciate your patience. All right, Mr. Darden, thank you.
If I can have one moment, Your Honor.
Sure.
Your Honor, I have in my hand what appears to be 3 Polaroid photographs. May they be marked Peoples 3, 4, and 5 for identification.
They may. Record shows like counsel have seen the pictures.
I made a record reflect going on that I've indicated the exhibit numbers in the bottom corners of the photograph on the rear. Showing you what has been marked as Peoples 3, 4, and 5 for identification. Do you recognize these photographs?
Yes.
Are these the photographs you took in the morning of January 1, 1989?
Yes, they are.
And do they fully and fairly and completely represent the injuries you saw that night?
Not even close.
Object that, Your Honor. Object. Let me approach on the record to you, Your Honor.
All right.
Can we have those photographs? Fairlow. Now, Detective, these are the Polaroids you took a little over 6 years ago. Is that correct?
That's true.
You indicated earlier that there was a cut on her lip that you saw.
Yes, it's right there underneath the nose. Appear to be about 1 inch in length.
And you've pointed that out. Is that correct?
That's correct.
What other injuries, if any, do you see depicted in this Polaroid photograph?
There's a bruise and swelling here on the right side of the cheek, and there's a pattern and swelling. There was some sort of a pattern right here that I couldn't quite make out, and I wanted that photograph. And her eye is swollen, and the other eye is starting to swell just a little bit. This one's getting black and blue. And down around her neck, this is red, and there's finger indentations on this part of her neck, the left side of her neck. None of that shows up on the Polaroid very well. I believe there's also a cut on the inside of her lip that corresponds with that cut, but it's on the side.
You can't see that from the photograph.
He's testifying from his recollection. You can cover that on cross-examination. Mr. Darden.
Detective, this is another one of the Polaroid photographs you took. Is that correct?
Yes, this is a different view of the same victim, different shot. It's the cut, the swollen, and contusion bruise right here. And this pattern is starting to look a little bit better, but it's swollen and red. There's a definite pattern to it. And then the black and blue marks here don't show.
What is depicted in People's 5, Detective?
This is the front of a West LA desk with a desk officer there. She's wearing, this is Nicole Simpson wearing my partner's field jacket. And these are the pants I was trying to describe as sort of a sweatpants or light pajama bottom. And this muddy leg is from when she hit the ground outside when she was thrown out.
Strike that, Your Honor. Strike that.
All right, the last comment, the muddy leg is when she hit the ground outside when she was thrown out. That, ladies and gentlemen, you're to disregard that as there's no foundation for that answer at this point. Thank you, counsel.
May I have one moment, Your Honor?
Certainly.
A follow-up or supplemental report in this matter, is that correct?
That's correct.
And did you prepare that report on the morning of January 1, 1989?
No, it was about 30 days later, I believe.
Okay. And why did you prepare a report 30 days after the incident?
The city attorney for the city of Los Angeles asked me to.
And do you know why he asked you to?
Sustained.
I'm asking if he knows. A prosecutor from the Los Angeles City Attorney's Office asked you to prepare a supplemental report?
Yes, I received a handwritten note from the prosecutor.
No, he can embellish slightly. Mr. Darden.
May I have one moment, Your Honor?
Certainly.
After you left 360 North Rockingham with Nicole, did you ever return to the house?
Yes, I did.
When?
I returned twice. I took Nicole home after the photographs, and then I had to return again.
Why did you return to the address that third time?
Nicole had called West LA Station, said that O.J. Simpson had returned, so I drove back to the location.
And why did you drive back to the location?
To try to place him under arrest for 273.5 of the Penal Code.
Spousal battery?
Yes.
And was he there when you returned?
No.
Thank you. Nothing further, Your Honor.
Mr. Cochran?
Thank you, Rick County, Your Honor. Good morning, Sergeant Edwards.
Detective Edwards.
Detective
Morning.
Edwards. Would you put the that last photograph back up for just a second? The Elmo, Your Honor. Are these? Thank you, Berry County, Your Honor. That's Sergeant as Detective. Detective Edwards? All right, I want to call you by the wrong name. Detective, are these the black sweatpants that you told us about when you described them earlier?
Must sustain the court's own objection. That's not what he testified to.
Did you indicate that she was wearing some dark sweatpants in your testimony earlier?
Yes, I believe I did.
Those sweatpants look dark to you or they look white?
The right leg looks pretty dark.
I'm talking about the color, sir, of the sweatpants. Look at the color of the left leg there. Is that white?
It's white pants.
All right, those are white pants, are they not?
Except for the right leg.
All right. Well, anything on the right leg is not the original color, is it, sir?
No, but that's why I was having a hard time with the color. I remembered something dark about the pants.
I see. Well, with regard to your recollection of these events, Detective, this took place 6 years ago, is that correct?
That's correct.
And when, after that, you wrote these reports, you wrote the first report, reports contemporaneous with the event on or about January 1st, is that correct?
That's correct.
Then I understand you wrote another report about 30 days thereafter, is that right?
That's correct.
And have you had occasion to review those reports in the recent past?
Yes.
And how long ago did you review the reports?
I believe last week.
Before that, when was the last time you reviewed these reports?
It's been quite some time, maybe 4 years or more.
All right. Are you aware that with regard to these proceedings that Mr. O.J. Simpson entered a no contest plea and resolved this incident in the criminal justice system? Are you aware of that?
Objection, Your Honor.
Overruled.
I found out about last year.
Your answer is yes. You're aware of it?
Yes.
All right. And are you aware that he thereafter wrote letters of apology to his wife regarding this incident? Are you aware of that?
Same objection.
This witness's awareness is irrelevant.
All right. Well, that's another way. Are you aware that in this connection, with regard to this case you've been talking about, that Ms. Nicole Brown Simpson wanted to drop the charges against her husband? Are you aware of that? Oh, no.
Sustained.
I'd like to be heard on that.
Please, with the court reporter.
Certainly. Was it?
No.
Thank you, Brown. Detective Edwards, you described for us that Miss Nicole Brown Simpson had gone down to the West Los Angeles station to have these Polaroid pictures taken. Is that correct?
I drove her there.
All right. And you took these photographs, did you?
Yes, I did.
And when you took these pictures, you did the best you could to try and accurately display her injuries. Isn't that correct?
Yes.
This wasn't the first time you'd taken Polaroid pictures, was it?
No.
And were you experienced at doing that at that time?
Yes.
And you took these pictures at West Los Angeles station, right?
That's correct.
And how many pictures did you take altogether?
3.
And the 3 that we see here, is that correct?
That's correct.
And I'm going to ask that the jury be allowed to see these pictures up close and personal after I ask a few more questions, if the clerk pleases. All right. Now, with regard to these pictures, is your testimony these pictures don't accurately reflect how she looked?
That's true.
Let me see if I understand this. You took the camera, you focused on her, and you took 3 shots. Is that right?
That's correct.
And these are the 3 shots that you took. Is that correct?
That's correct.
May I approach, Your Honor?
Yes.
I'm going to show you, first of all, the marks, Peoples 1 for identification. Peoples 1 is a photograph.
These are Peoples 3, 4, 5.
One on, I'm sorry. Peoples 3 purports to be a photograph of a female. Is that a photograph of Nicole Brown Simpson?
Yes.
That's Peoples 5.
Counsel record 5, it's like 3. Is that a photograph of Nicole Brown Simpson?
Yes, it is.
Did you take that photograph?
Yes, I did.
I'm going to show you Peoples 4 for identification. Is this a photograph of Nicole Brown Simpson?
Yes, it is.
Did you take that photograph?
Yes.
And Peoples 3 for identification. Is that a photograph of Nicole Brown Simpson?
Yes.
Did you take that photograph?
Yes, I did.
Now, did you ever go to court to testify in this matter, in any criminal proceeding that took place?
No.
Did you ever at any time have any further discussion with Nicole Brown Simpson as to whether or not she wanted to proceed with the charges against her husband?
No.
You didn't talk to her after this?
No, I didn't.
The last time you talked to Nicole Brown Simpson with reference to this incident was on what day?
January 1st, 1989.
At what time of day was that?
When I took her home, it was around 6, I believe.
6 o'clock in the morning?
Yes.
And when you had occasion, did you not, to get very close to Nicole Brown Simpson on this night? Is that correct?
Well, she grabbed me and hung on to me, yes.
Excuse me, Your Honor. Not for director's examination.
I am, Your Honor. I'm getting all the photographs up. All right. You got very close to her, is that correct?
Yes.
Did you have occasion to determine whether or not she'd been drinking that particular night?
I didn't smell any significant alcoholic beverage on her breath. I don't believe I did.
I'm not asking about significant alcoholic beverages. Did you smell any alcoholic beverages on her breath?
Not enough that I would be able to detect it. I don't remember it.
Well, I don't understand that answer. Not enough? What does that mean?
I can't remember smelling alcoholic beverage on her breath.
So your answer is you don't know one way or the other, right?
I just can't remember smelling alcoholic beverage on her breath.
The answer is you don't know at this point, right?
Okay, I don't know.
All right, that's all I'm asking. Your Honor, I'd like at this point, if this is the appropriate time, to show the photographs.
Mr. Cochran, if you would then hand the all 3 photographs to juror number 1. Actually, hand it to our bailiff. Ladies and gentlemen, as you look at the photographs, would you pass it to your right? Actually, to your left. Sorry about that. Juror number 1, would you pass the photographs to your, as you look at it, pass it to your left. That way everybody will see it quicker. But take your time. Please take as much time as you feel you need. As you look at the photograph, pass the individual photograph, please. We'll get used to the procedure. But please take as much time as you feel you need to look at the photographs. I'm sorry, why don't, let's just go down the front row, please. And then we'll come back around to the cheap seats.
Film.
Wait a minute, you mean to tell us that the Los Angeles Police Department only had 3 shots on a Polaroid roll on January 1st, 1989 at the West Los Angeles station?
Is out filming that camera.
Did you get, with the Polaroid camera, as I recall it, you put another roll in after that finishes. Is that correct?
Right, she wanted to go home.
But wait a minute, how long would it take you, sir, to put another roll, slide another container inside that camera?
She wanted to go home to her children, and it wasn't my option. I had to comply with her.
So you didn't have time to take any more pictures? Is that what you're telling us?
That's correct.
You did have other film at that station?
I would imagine somewhere locked up in that station there was film.
Now, you drove her back home, did you not?
Yes.
What stopped you from taking some pictures at her home when she got back home with her children?
She wanted, I didn't have any other film with me. That particular camera was out of film.
Well, there was other film at West Los Angeles Station. Isn't that correct, sir?
She wanted to leave. She wanted to go back to her children.
Can you answer my question? Was there other film at West Los Angeles Station?
Somewhere in that station, I'm sure there was other film.
And you could have gotten that film. Isn't that correct?
I could have eventually gotten the film,
And you
yes.
could have put that film inside that Polaroid camera. Isn't that correct?
Yes,
You could have taken that camera back to Rockingham, right?
I could have.
And you could have taken the pictures that you claim you now want. Isn't that correct?
If I would have ignored her request, I could have done all those things. It's true.
You did not do that, did you?
No, I complied with her request to go to her children.
But you were a police officer out there, and the reason you take pictures is so you can preserve how the person looked for years later. Isn't that correct, sir?
Exactly.
And you didn't do that according to your testimony, although we have these photographs, right?
I did it to the best of my ability.
All right. Can we stop at this point? I'm not finished with him yet.
All right, ladies and gentlemen, we're going to take our recess for the noon hour. Please remember my admonition to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't allow anybody to talk to you about the case. Don't perform any deliberations till the matter has been submitted to you. And we will resume back here at 1:30. All right, Detective Edwards, you're excused until 1:30. All right, thank you, sir. All right, let the record reflect we have now been rejoined by all the...
Rockingham, before you went to West Los Angeles? Yes, Your Honor. Thank you very much.
The testimony that you are hearing regarding this 1989 incident is one of those incidents that is being received for the limited purpose that I have already instructed you on, and you are to make note that as you listen to this evidence, it is for that limited purpose that I have already instructed you on. All right. Let's have, Detective Edwards, please. All right, good afternoon, Detective. You're reminded you're still under oath.
Yes, Your Honor.
All right, Mr. Cochran, do you wish to continue your cross-examination?
Yes, Your Honor. Thank you very much, Your Honor. Good afternoon, Detective. When we broke at lunchtime, we were talking about this Polaroid camera. Now, I want you to think back for us. This camera that you had, did you have that camera at the scene at Rockingham before you went to West Los Angeles?
No, I got it at the desk.
At West Los Angeles Station?
Yes.
And that was your station? You were assigned to that station at that time, right?
That's correct.
And the time you got that camera, how many exposures, or what was the total number of film that you had in that camera at that time?
I don't know. I shot it until it was empty.
All right, now, and in shooting until it was empty, is it your testimony that you only took 3 shots?
I believe I only took 3.
Do you recall taking a photograph of Nicole Brown Simpson while she's still in the police car?
I don't believe I ever did that.
You don't recall any such photograph being in existence?
I'm pretty sure I didn't do that.
All right, do you have any records that would refresh your recollection on that at all?
I don't think I took a picture of her in the car.
All right. Now, at some point, you described for us that a young lady or a lady by the name of Michelle came out to the police car and started having a conversation with Miss Nicole Brown Simpson. Is that correct?
That's correct.
And so that we're clear, as I understand it, at that time, Mr. Simpson was not outside. You could not see him at that point.
He was not outside in my view.
All right, and you were still outside the gate at this point, right?
That's correct.
All right, and this lady, Michelle, can you describe her for us, please?
I believe she had dark hair. She was about 5'4", and I think she was Filipino, but I'm not really sure.
You believe she was Filipino?
I'm not sure. I know she had a long last name that I can't remember what it was.
Was her last name Michelle Abdurrahman? Abdurahm? Is that a refresh your recollection?
That might be it.
That sound about right to you?
It was A something.
And did she appear to speak to you with an accent?
She had an accent, yes, but she spoke English.
All right. And you believe that she was Filipino, did you?
Well, not really. I just can't. I didn't ask her what her nationality. It was at night, and I really don't know.
Well, now, you were out there, of course, in response to this phone call. Did you or your partner or Sergeant Vinger ever interview this Michelle Abdurahman?
Just to admonish her of 148 of the Penal Code and tell her to leave.
No, let's get back to my question now. When you admonished her, you told her to leave because she'd be interfering, right?
That's correct.
I'm asking you, did you interview her to find out what had happened, either inside or outside of 360 Rockingham before you arrived there?
No, I did not.
So you did not take a statement, and as far as you know, not only did you not do it, but neither did your backup sergeant or your trainee partner. Is that right?
No, because she was inside the gate after I told her to leave.
So your answer is no, you didn't do that?
Nobody interviewed her.
All right. Were you aware that there was a second woman, another woman inside the house, a so-called nanny? Did you ever see another woman?
I didn't see another woman, no.
You never saw her or talk with her, is that correct?
That's correct.
Now, by the way, with regard to you said you would spell for us the name of your partner. Spell it for us now, will you please?
You know, I didn't look it up to see what it is, but it's Milweskwi, I believe.
Milweskwi?
Yeah, something like that. First name Patricia.
That's close, all right. Now, did this officer, Milweskwi or whatever we have there, did she ever have occasion to, as a female officer, look at Miss Nicole Brown Simpson's body for any other bruises or injuries at some point?
Objection, Your Honor, unless the witness is present.
I'm asking, he can answer yes or no. He knows?
Hearsay.
It's not hearsay.
Overruled. If he was present, if he knows.
I was not present during that.
All right. But you instructed her, did you not, to look at her body, did you not?
Yes, correct, I did.
Okay, tell us what you asked her to do.
I asked her to go take her into the women's bathroom that's located in the lobby of West LA Station and see if she had any bruises or marks on her back.
And did you then see your partner, female partner, then go along with Miss Nicole Brown Simpson into a bathroom area?
Yes.
All right. And you weren't in that room, obviously, were you?
No, I was not in that room.
And then they came back out at some point, isn't that correct?
That's correct.
And after this was all over, you had occasion to write out a report, did you not?
That's correct.
And in that report, you talked with your partner as to her observations, did you not?
Well, my partner wrote the report, and I assisted her with it, yes.
So you had occasion to see her report, and you had her response as to whether or not she saw any bruises on Nicole Brown Simpson's body, right?
That's correct.
And it's true, in fact, she did not see any bruises, right?
Sustain.
All right. There is a report, is that correct?
That's correct.
Is she here today in this building, your partner?
Not that I know of.
You haven't seen her?
No.
All right. You still work West Los Angeles?
No. Van Nuys homicide.
All right. Now, Detective, so that we're clear, I believe you indicated to Mr. Darden that you believe that you arrived at the scene sometime after 3:30 or thereabouts. And if I were to indicate to you that the call that came to downtown for the 911 was at 3:58, would that refresh your recollection that you were there a little after 4 o'clock or after
That's
4
correct.
o'clock? Would that be correct?
That's correct.
You also told us that you had heard in the transmission that the woman calling the 911 had said she was being beaten. You heard that, did you?
No, it appeared on the video screen in our car.
Well, isn't it true that what appeared on the video screen was that it was the comments of the transcriber, the person who was working down at Parker Center?
That's correct. That's what I testified to. That's what we were given as a radio call.
You didn't say earlier today that it was your understanding that the woman who made the call had said she's being beaten. Did you say that?
I can't remember if I said that or not.
Right. Okay, well, at any rate, as you think about it now, at no time were you ever told by anyone that Nicole Brown Simpson or any lady inside that house ever told anyone they were being beaten through the transcriber. Is that correct?
At the time that I got the radio call, it was just that a woman was being beaten in the background.
All right, that's your understanding, right?
That's correct.
All right. So let's assume that you arrived there at some time after 3:58. Knowing that information, can you now tell the jury and the court and jury with better precision as to what time you actually arrived?
No, because I don't know exactly where I started from and how long it took me to get there unless I had the arrival time on that document that you're talking about. Just refreshing my mind, I think it was under 10 minutes, like I testified earlier.
So whatever time you got the call, you think you got there from the area you were in near La Cienega or whatever, in about 10 minutes?
I'd say it was under 10 minutes, but it was around that area.
All right. So let's assume that you were out there by 4:15 a.m. And this is New Year's Day, early morning hours, right?
That's correct.
And how long were you there until you left to take Miss Nicole Brown Simpson down to the West Los Angeles station to have these pictures taken we were talking about?
Probably somewhere around 8 or 10 minutes.
So if you arrived by 4:15, you say by 4:23, 4:25 you'd be out of there, is that right?
4:30, somewhere around there.
In that general range?
Right.
Now, you described for us, was it raining that particular night?
It was a light, misty rain in the hills pretty much only.
And had it been, was it also kind of muddy outside?
Yes.
Did you ever at any time go inside the residence at Rockingham there and look at any of the rooms or at any time go inside the house?
I never got past the front gate.
Your testimony is that everything you testified about in this 8 to 10 minutes occurred with you outside the Rockingham residence, is that correct?
That's correct.
The photograph that showed Miss Nicole Brown Simpson with the apparent mud or whatever on the right side of the light-colored or white-colored pants she was wearing, did she have that mud on the pants when you first saw her?
Yes, she did.
And that was on the right side of her body?
Yes.
And that was consistent with some of the marks or injuries you saw on the right side of her body also? That same size?
What's the objection?
Question is vague, Your Honor. How can he testify that an injury is consistent with the mud on
No, that's not what I asked, but so I wanted to be clear for him, so may I state it again, please, Your Honor?
Please.
Okay, good. Your Honor, I'll proceed. You've described for us that this mud was on the right side of the pant leg of Ms. Nicole Brown Simpson, right?
From the waist down.
Right. It was on the right side.
Yes.
All right. And did she have injuries on the right side of her face or body?
Yes, she did.
The same side as where this mud was, right?
Except that there was no mud between her waist and her shoulders.
That's not what I asked you, officer. I asked you, is it the same side as where the mud was?
It's the right side of the face. Some of the injuries were on the right side, yes. Some of them were on the left.
I asked you, were there injuries on the right side?
Oh, the side of her torso? No, just on the side of her head.
Were there injuries on the right side of her face, officer?
Yes.
Now, by the way, when you took her back home, did you ever book these pants into evidence so we can have them look at them now?
No.
When you went back home with Miss Nicole Brown Simpson, did you go inside the house at that time?
No.
You just let her out of the gate?
At the front door.
The front door of what?
The house.
So you went inside the gate this time?
I think we drove to the front gate and let her out, yes.
Well, it's not clear. There are gates all around the premises. Did you drive inside the gates up to a front door?
Yes.
The premises? Did you go inside?
No.
So you let her out and she just went inside the house?
That female came out, Michelle, came out and met her, and they went in together.
She and Michelle went inside and you didn't bother going in at that point?
No.
When you went in the second time, did you ever see the nanny at that time?
No.
Now, this was the morning after New Year's Eve, is that correct?
That's correct.
In talking to Miss Nicole Brown Simpson, did you discuss with her the fact that she'd been to a party that evening?
I asked her...
You answer that yes or no?
Overruled.
Yes.
She indicates you've been to a party, isn't that correct?
That's correct.
If you think about it, if you have the lunchtime to think over it, you recall, don't you, that she had been drinking that night? You recall that now?
No, that's not it. No, I don't.
You don't recall that?
No, I don't recall her had been drinking.
Did you write that in any of your reports, sir?
That she had been drinking?
Yes, whether or not she'd been drinking.
I don't think I did.
Did you ascertain that both she and Mr. Simpson had been to a New Year's Eve party?
Overruled.
Yes.
And did you find out what time they come up from that party?
Overruled.
No. This part of the conversation that we're talking about now, at what point did you have this conversation about the party and what happened earlier?
At the station.
At West Los Angeles Station?
Yes.
Is that written down anywhere?
No.
So you just have an independent recollection of that 6 years later?
Yes.
Now, when you asked Miss Nicole Brown Simpson whether or not she wanted to be taken for medical treatment, is it my understanding she indicated to you that she would seek her own medical treatment? Is that correct?
That's correct.
You described for us that you were just recently assigned to the West Los Angeles area prior to this incident. Is that correct?
That's correct.
And you had never been to that residence before, right?
That's correct.
You never knew either of these parties before this time, right?
That's correct.
You never had a conversation with Mr. O.J. Simpson before this, right?
That's correct.
You've never seen him when he was angry, if he was ever angry, had you?
No, I had never seen him angry at all.
You've never seen him happy before?
I had seen him on television in football games and things like that.
Well, wasn't talking about on television, I'm talking about in person, officer. You'd never seen him at a time in person when he was either happy or sad.
I've never met him before.
All right. So with regard to all of your observations about him being angry or hostile or whatever, you had never talked to him before this particular night, right?
I never talked to him, but I'd seen him on television, things like that.
You'd never talked to him in person, officer, before that night, right?
That's correct.
You indicated that at some point, Ms. Simpson said that the police had been out there 8 times before and hadn't done anything. Did you ever have occasion to check to see whether or not in the logs at West Los Angeles Police Department there were 8 previous contacts, written contacts, from West Los Angeles to that particular residence on Rockingham?
No, I just took his word for it.
Could you just answer my question? Did you ever check that, sir?
No, I took his word for it. I never checked.
So the answer, you didn't check. And to this date, you still haven't checked, right?
To this date, I haven't checked.
If officers from the West Los Angeles station would come out on a social call to stop by and talk football or whatever, there wouldn't be a record of that, would there?
I don't know.
Well, if an officer from the Los Angeles Police Department assigned to West Los Angeles stopped by Rockingham, saw O.J. Simpson, and just stopped by and talked football when they saw him outside, let's say, you wouldn't write that down, would you normally?
I don't know. I've never done it. I wouldn't know.
Are you a detective now, LAPD?
Yes.
And how long have you been a police officer?
24 and a half years.
So you know something about the procedures, don't you?
Yes.
And someplace at some time in 24 years, you've worked in an area where you've had some friendly encounter with somebody in your particular beat area. As a matter of procedure and your training, did you at that time have occasion and were required by your training to write that down?
I want to check this question. The compound is convened and Mr. Coughlin becoming witness.
Overruled. Overruled. Do you understand the question?
I think so.
Try to answer, please, sir.
There would be a couple of ways to log something like that. You just drop by someone's house, either going to Code 7, that means to eat. You would be taking your Code 7 time or your eating time to visit that person, and you may log it at that address. Or as an officer call, you would log it whenever you went to a business or a person's house for any reason like that.
Any other ways that you might just stop by and not log it?
I would imagine.
All right. Now, when you talked to Mr. Simpson at some point, you described for us that he had on some shorts and a robe, and you at some point, after talking with his wife, made a judgment that you were going to place him under arrest. Is that right?
That's correct.
Okay, now at that time, had you spoken with this lady, Michelle Abduran?
No.
All right. At that time, did you talk to Mr. Simpson about what may or may not have happened?
No.
All right. But you made the judgment he was going to be placed under arrest, and you then told him to go back in the house and get dressed, right?
That's correct.
And is that normal police procedures?
For 273.5?
Yes.
Penal code arrests? Exactly.
You just tell him to go in, put your clothes on, and come back out here, right?
No, that I was going to place him under arrest.
No, I mean the procedure. You missed the question. The question was, is that normal procedure for you to stand on one side of the fence and say, I want you to go in the house, put your clothes in, and come back out here so I can arrest you? Is that normal procedure?
It was a tactical decision I had to make with just my partner, myself, and an injured victim in the back seat.
So that was your tactical decision. Now, your tactical decision was you were going to do this even after you'd been told that Mr. Simpson had lots of guns. He could just go in the house, get dressed, and come back out, and you stand up there and wait. Is that right?
Exactly.
All right. And by this time, had you thought to call for backup for Sergeant Vinger?
Yes.
Had he come by this point?
He was on his way.
And he arrived there at some point shortly thereafter?
Yes.
And sergeants travel in vehicles by themselves. So he's a one-person car. Is that right?
That's correct.
So he then came back out, right?
Right.
Now, as I understand your testimony, is your testimony that Mr. Simpson left out of one of the gates of this place at 45 miles per hour?
No, he went southbound on Rockingham at about 45 miles an hour as soon as he left the gate.
All right. What speed was he traveling when he got outside the gate?
I don't know. He went by pretty fast. I didn't get a real good look at the car. I'd say probably 15 to 25 miles an hour.
You ever driven a Bentley before?
No. I've chased him.
So now let's see. You chased one, but you haven't driven one, right?
That's right.
All right, and so your testimony that as he got outside the gate, the Bentley was traveling about, on the way outside the gate, was 15 miles per hour?
Right.
And then it soon got to 45?
Right.
And did you and Sergeant Vinger both go in pursuit?
Right.
Did you have any communication so there were other vehicles in this pursuit at all?
We switched to Simplex, which is an internal car-to-car frequency, and we broadcast that on Simplex.
All right, were there any other vehicles involved in this so-called pursuit, sir?
I think a total of 5 searching the area ultimately, but I was the only one that was directly trying to catch up with him.
You were the only one supposedly following the Bentley, is that right?
Right. Everybody else is fanning out through, there's multiple side streets, and we were checking the side streets.
Now, after this incident, you described for us that you may have stayed there 8 to 10 minutes. You went to West Los Angeles Station, right?
Well, we ended up down around Bundy and Wilshire in an attempt. From there, we went to West LA Station.
All right, and Miss Nicole Brown Simpson was in the vehicle with you?
That's correct.
All right. So ultimately, you got to West Los Angeles Station?
That's correct.
What time was that?
I don't know. I would guess somewhere around 5 o'clock or before 5.
5 o'clock a.m., thereabouts?
Right.
All right, and how long did you stay at the station?
Just long enough to get the camera, take the 3 photographs, have her go in the bathroom and come out.
Now, could you answer this question? How long did you stay at the station? Can you tell us that in minutes, officer?
I'd say about 8 to 10 minutes.
And then was your partner still with you at this point?
Yes.
The two of you then drove Miss Simpson back to the residence of Rockingham?
That's correct.
That's when you dropped her off?
Yes.
And did you stay at any time there other than to drop her off and then you left again, is that right?
We just left.
Did you ever see any children in or about that residence that night?
No.
Did you have occasion to have a further conversation with Mr. Simpson that you haven't told us about thus far, where he described to you...
Objection, call for hearsay.
May I finish the question, Your Honor?
The form of the question calls for
May I
hearsay.
finish the question, Your Honor?
Over here at the sidebar. With the recorder, please.
Thank you, counsel.
May I that be read, or should I just restate it, Your Honor?
State it again.
Certainly. I doubt I will read it.
Detective Edwards.
Did you have occasion to have a further conversation with Mr. Simpson that you haven't told us about thus far, wherein he described for you the events of that night as regards he and his wife? You answer that yes or no.
No.
Did you have any follow-up conversations with Mr. Simpson on a day after January 1st, 1989?
No.
Do you know an officer by the name of Farrell?
Yes.
And was he one of the officers who did some investigation on this case?
He's the one that filed the case as a misdemeanor.
So he did have something to do with this case?
Yes.
Do you know whether or not, of your own independent knowledge, whether or not Officer Farrell had any further conversation with Mr. Simpson?
Just from what Farrell told me.
And were you able to ascertain whether or not he talked to him?
Objection to that.
Yes, that, yes.
Farrell will follow this officer to the witness stand, Your Honor.
Sustained. It's irrelevant.
When you saw Michelle Abduram out of the vehicle, it's your testimony that you recognized her voice as the person who told you there was nothing wrong with the premises there?
Yes.
And what was there about her voice that made you recognize it?
It's probably the accent or something, but I realized it was the same person from the voice.
Were you able to ascertain whether or not there was any, strike that, were you able to ascertain whether or not any of the grounds in and around Rockingham were muddy on that particular evening as you came back to the residence or at any time?
That whole mountain area appeared to be wet.
I presume it had rained over a period of time then, is that correct?
Right.
The Polaroid shots that you took at West Los Angeles Station, was that after your partner had taken Mr. Cole Brown Simpson into the bathroom area?
No, it was before.
All right, and was any effort made to take any shots or pictures of her body that your partner saw?
We were out of film.
Well, we went through that before, but there was film in that station, was there not?
I would imagine somewhere in that station there was film.
All right, was there any effort made to get any film so that you could take pictures of her body as your partner saw them that night?
No.
But you never asked anybody for any film, did you, after it ran out?
No, she wanted to go home to her kids.
But you didn't take the camera home either, did you?
Didn't have any film.
But, officer, you didn't ask anybody for film.
I think we've been through this once already.
That does sound familiar, Your Honor, doesn't it?
Yeah.
Yes. All right. I think I did ask that. Thank you, Your Honor. I have nothing further of this gentleman at this point.
All right. Mr. Darden?
Detective Edwards, you testified that you saw scratches and bruises on the Cole Brown, is that right?
Yes, I did.
You didn't see any scratches on the defendant when you saw
I think
him?
that's leading and suggestive. That's improper redirect examination. I didn't go into that.
Yes, he did.
Overruled.
Redirect examination.
Overruled.
Did you see any scratches on the defendant?
No, I did not.
You see any bruises on the defendant?
No, I did not.
See a handprint around his neck?
No.
The only person you saw with scratches and bruises and handprints around
Object,
his
this
neck
is
was
argumentative.
Cole Brown.
Sustained. It's leading, it's argumentative, it's suggestive. Calm down, gentlemen.
I'm sorry, what was that?
Calm down, gentlemen. The issue was whether or not he saw any injuries on the defendant. That was a yes or no.
Did you only see injuries on the right side of Nicole Brown's body?
No, it was on the left side also.
You described a moment ago a portion of the conversation you had with Nicole Brown at the station, is that correct?
That's true.
Did you have additional conversation with her?
Yes.
What was that additional conversation?
What foundation? What?
At
Additional.
West Philly Station.
All right. Overruled.
Had to do with why the argument occurred.
She told you why the argument occurred?
All right, let me
Yes.
see counsel at the sidebar.
Okay, and shout out to you, Zoe. Thank you so much for the kind words. Also, I appreciate your support to myself, chat, and the animals you care for. So, and shout out to all of you in chat. Now, at this point in the stream, we have come to a stopping point for the night. We will resume tomorrow. So, always, Alien, I'll be lurking. Have a wonderful night, you guys. Yes. And I'm going to be doing a lot of my streams earlier, for now. And I really like doing my own stuff. It's really cool. Which I do them every night, but I'm going to do them a little bit earlier. I'm going to start earlier. So everybody, have a good night, good evening, afternoon, wherever you are. Thank you all for your support. And take care, and peace.